maging abogado at abogada, ano ba? I hope my lecture on book to in the special panels could add to what you have already in your house of knowledge in order to ensure your passing the bar. You know, your reviewer this morning, and until we finish the entire book to, is Professor Salva, Nelson A. Salva. I am the head of the Critical Law Department in the School of Law of Arellano University and professor in several law schools in Metro Manila and paper reviewer in many review centers all over the country. I just got from Davao, where I lectured also on book 1. But the next weekend, I will also lecture on what I'm going to lecture through this schedule. So, in a way, this is only a rehearsal for my succeeding lectures in the other review centers. All right, you know, all your efforts during this review is in order to eliminate your ignorance of the law, especially those that are covered in the 2011 bar examination syllabus. You know, Justice Abad, who happens to be my classmate in Fed during AB days, had told us, unlike in the previous bar, there is no specification on what to read. And this time, he wanted it to be a little more specific. That's why he came out with this 2011 bar examination syllabus. I say to eliminate ignorance of the law. Ignorance of the law excuses no one from compliance with it. But your ignorance of the law will not excuse you from passing the bar. Take note of that. And all the laws which you learn and discover in your adolescent years in the law school will have to be revived from your memory. You know, the adolescence age of all of us in the law schooling is from first year. But actually, in our actual life, the most wonderful age is adolescence. The age of adolescence, because that is the time when men meet girls. And on the other hand, girls become happy because they discovered that they are discovered. That is age of adolescence. Now, book 2 is divided into 14 titles. But the review here is more lengthy because of the additional special panels. We shall begin with title 1. This title was first read by you in book 1 because it is included in the 5 exceptions to the rule of territoriality of our criminal law under Article 2, the last of the 5 exceptions. Crimes against the national security and the laws of nation as they are defined in Title 1 of Book 2 of the Revised Penal Code. So it covers Article 114 up to Article 123. Now, first, treason. What is treason? Treason is a breach of allegiance of any national or citizen to his sovereignty. Allegiance is the obligation of obedience and fidelity to his country or state in return to the protection that that national or citizen received from it. There are 2 ways of committing treason in Article 114. They are, number 1, levying war against the government, and number 2, adherence to the enemy, leaving them aid in comfort. But remember, treason could only be committed in times of war. There is no traitor to his country unless the country is at war with the foreign power. And the offender, previously, in the crime of treason under our code, are only citizens of the Philippines. But before the outbreak of the Second World War, that provision of Article 114 underwent amendment through an executive order, making aliens residing in the Philippines also liable for the crime of treason. So both Filipino citizens and resident aliens are the ones liable. If aliens are not resident of the Philippines, then they are excluded. The citizens of the Philippines, wherever they may be, once they commit any act of treason, they shall be held liable and be held before our Philippine court. But with respect to resident aliens, they should be committing those acts only when they are in the Philippines, not outside of the Philippines. So the elements of treason act that must first be, number one, the offender is a citizen of the Philippines or a resident alien. Number two, that the Philippines is involved in a war with a foreign enemy country. Number three, that this offender either levy war against the government or that they adhere to the enemy, giving them aid in comfort. Now, what is the meaning of levying war against the government? It means that the offenders shall assemble themselves. There must be actual assemblies of men for the purpose of carrying out treasonous design against the government by means of force. So, mere enlistment to fight the government is not enough to make one liable for treason. It requires actual assemblies of men in order to carry out the treasonous design against the government by means of force. And then we have the second mode of committing treason, that is adhering to the enemy and giving them aid in comfort. So mere adherence to the enemy without giving aid in comfort does not make the offender guilty of treason. What is the meaning of adherence? Meaning, intent to betray. The offender is entertaining intellectual and emotional sympathy to the enemy and an adverse sympathy against his home country. But that alone will not make him liable unless it is coupled by that second element, giving aid in comfort. And what does aid in comfort means? That aid must have the effect of strengthening the effort of the enemy in fighting our government. Mere giving women to enemy soldiers or army, commanding all women in order to give them entertainment. The Supreme Court said that is not the concept of giving aid in comfort, although giving them women entertainment will boost their morale. It does not fall under that concept of strengthening the effort of the enemies against our government, said the Supreme Court. So kahit na ibigay ng traitor yung lahat ng mga prostitute sa ating bayan, sa Pilipinas, para sila ay aliwin, hindi raw yung crime na overt act of treason. Bakit kamo? Eh kasi common sense, lalo lang silang manghihina kapag kayo lang ginawa nila. Lalo lang silang manghihina. It weakened them. Then, so giving food stuff, supply of foods, giving armaments will constitute overt act of treason. There are two ways of proving treason. Or the question would be, what is the quantum of evidence required to prove treason? Now, under the second paragraph of Article 114, it says, no person shall be convicted of treason unless upon the testimony of two witnesses at least to the same overt act or confession in open court. So those are the two modes of proving the crime of treason. Either that two witnesses are presented testifying to the same oferta. That is the so-called the two witness rule. And the other one is when during arraignment in open court. And that court must be a court of competent jurisdiction which could render judgment of acquittal or conviction as the case may be. And the accused in that open court makes an admission of his guilt, confession of guilt in open court. Meaning to say, he confesses that he had committed the act of treason, either by levying war or adhering to the enemy, giving them aid in comfort. And how will you apply this to witness rule? When shall it be considered to have been complied with, so that it will result in the conviction of the accused? Well, these two witnesses must testify to the same overt act. Meaning to say, if for instance there are two overt acts committed by the offender, a Filipino citizen. The first is delivery of truckload of rice to the enemy garrison. The second, delivery of 100 pieces of automatic rifles to the enemy. There were two witnesses presented by the prosecution. Witness A testifies to that overt act of delivery of rice to the enemy garrison. Then, witness B was presented, and this witness B testified he saw the same offender deliver these 100 pieces of automatic rifles to the enemy. Those are the only evidence presented by the prosecution. Can that result to the conviction? There are two witnesses testifying to overt act. The answer, no, it will result to the acquittal. Because while there are two witnesses, each one testified to an overt act different from the other. When you speak of testifying to the same overt act, if there is an overt act of delivery of 100 pieces of armored rifle, those two witnesses must testify to the overt act. And also, the two witnesses shall testify to the fact of the delivery of that truckload of rice to the enemy. That is how these two witness rules should be applied. And remember, even if there are two witnesses who will testify to the same overt act, it requires that both must be credible per the assessment of the court. Because if only one of them is found to be credible, then the two witness rule is not complied with. It will result likewise to the acquittal of the accused. Remember that treason is the only felony under the revised penal code requiring these two witnesses to testify on the same overt act. No other felony. Why is it so? Because the crime of treason, which has a very severe penalty, is committed during abnormal times. And during abnormal times, like war, people may, in a small squabble, may forget their scruples and may sacrifice truthfulness. Thus, if there is no two witness rule, one who is entertaining some peeling of pretense against a Filipino during wartime, in order to get even with him, that sole witness may be tempted to file a complaint for treason against that man and testify against him. Because he has given the enemy aid and comfort. He appeals to the enemy. If he is a good false witness, there is probability that the court may be persuaded to believe his testimony, and that will result to the conviction of the accused. That will be a grave miscarriage of justice. To avoid that situation, the law requires this two witness rule to apply strictly in cases of the crime of treason. That is the reason for this two witness rule. Now, of course, in proving treason by confession of guilt in open court. It must be in open court before a court of competent jurisdiction. Extrajudicial confession will not suffice because that is not confession in open court. Now, you have covered in your study of Book 1 about Article 8, conspiracy and proposal to commit treason. They are preparatory act which, as a rule, are not punishable unless there is a specific provision of law providing penalty therefor. That exception is found in Article 115 as one of them, because there are felonies in the revised penal code, few of them only, where the mere conspiracy and mere proposal to commit that felony is already punishable by law. Conspiracy and proposal to commit treason. But unlike in treason, where the two witness rule will apply, here, in conspiracy or proposal to commit treason, that two witness rule does not apply. Why? Because that is a distinct crime from treason. It is only in the crime of treason itself where these two witness rule shall apply. And there is conspiracy to commit treason when in times of war, where the Philippines is involved, two or more persons come to an agreement concerning the commission of the crime of treason, either by levying war against the government or by adhering to the enemy, giving the making comfort, and decide to commit it. So the elements that must always be remembered is there must be a war in which the Philippines is involved. Then two or more persons come to an agreement to commit that crime of treason in either of those two modes. And lastly, that these two or more offenders have decided to commit the same. Absent the decision to commit the crime of treason will not make such conspiracy a punishable crime. That last element is always necessary. And remember that this Article 115 gives you the concept of conspiracy and proposal as a crime in itself. That is the concept, because you learn that there are two concepts of conspiracy. Concept as a crime and concept as a mode or manner of incurring criminal liability. There is proposal to commit treason whenever a person has decided to commit the crime of treason, either of those two modes mentioned, and proposes its execution to some other person or persons. The moment this proposal is accepted by those two or more persons, then the crime for which they shall be prosecuted is for conspiracy to commit treason. There is no more crime of proposal to commit treason, because proposal to commit treason will only exist if such proposal has not been accepted by those two or more persons. While conspiracy will be the offense to be prosecuted, because the one who made the proposal and those who accepted the same will now fall under the definition of conspiracy when there are two or more persons come to an agreement to commit that felony of treason and decide to commit it. So, by mere agreeing, they become liable for conspiracy to commit treason. That is the concept as a crime in itself. But the moment overt act of treason is in itself committed by those conspirators, they shall not be liable anymore for conspiracy. They shall be charged and be convicted of the crime of treason. What happens to the conspiracy? It shall merely become a mode of incurring criminal liability. And the principle of conspiracy, the act of one is the act of all.
Then we have this crime by omission. Article 116 provides for the crime of misprision of treason. According to the provision, any person owing allegiance to the government of the Philippines without being a foreigner who has personal knowledge of any conspiracy against the government shall disclose the same as soon as possible to the public authorities mentioned in that provision, provincial governor or provincial prosecutor or fiscal, city mayor or city fiscal. Now, who would be the offender in misprision of treason? Now, you know, in 2010 bar examination, one question about this provision was asked. Only citizens of the Philippines. Resident aliens are not included. Why? Because the very sentence, any person owing allegiance to the government of the Philippines without being a foreigner. A resident alien is a foreigner. Who is not a foreigner who owes allegiance to the government? Citizens of the Philippines. Pinahirap lang ng lawmaker para binigyan tayo ng rebate. Sasabihin, any citizen of the Philippines. Dapat ganun na lang ang sinabi. Pero sinabi, any person owing allegiance to the government of the Philippines without being a foreigner. Imagine bata. Siguro tinitest talaga kung magaling tayo mag-intindi ng batasan. Kahit kung hindi, gagawin na lang na citizen of the Philippines. Simple. Alright, the omission there is the failure to disclose as soon as possible. But remember, what must be disclosed is mere conspiracy to commit treason either by levying war or adhering to the enemy, giving the waiting comfort. So once two or more persons have already consummated the overt act of treason, it came to the knowledge of a Filipino citizen, but he fails to disclose the same to the proper authority, he has not committed any crime at all. Because what the law is specifically mentioned or referred to is the failure to disclose conspiracy, personal knowledge of a conspiracy against the government, not a consummated act of treason. And upon conviction, according to the law, the penalty shall be the penalty for an accessory to the crime of treason. Meaning to say, 2 degrees lower than the penalty prescribed by law for the crime of treason. But can the convict of violating this Article 116 be entitled to the exemption provided in Article 20 of the revised penal code? Accessories who are spouses, descendants, ascendants, legitimate, natural, or adopted brothers and sisters, and relatives by affinity in the same degree. Can they be entitled to the exemption provided under Article 3? No. Why? Because the offender in violation of Article 116 on misprision of treason is a principal. Remember, he is a principal. What the law mentions there is that once convicted, the penalty to be imposed is as an accessory to the crime of treason. But he remains to be the principal, and therefore he is not included in the provision of Article 20, who may be entitled to the exemption from criminal liability. Now, is there any defense about, for instance, a Filipino not being able to report as soon as possible that knowledge of his personal conspiracy against the government? Yes. Don't forget to remember paragraph 7 of Article 12. When the offender pays to perform the duty required by law, and that duty under Article 116 is the duty of reporting any personal knowledge of conspiracy. If he pays to do and perform that duty, if the reason is by local or insuperable cause, then he is exempt from criminal liability. Simple illustration is, when for instance, Series X, a Filipino citizen in his barrio, he learned personally, 2 or more persons of his barrio mates had conspired to commit treason against the government. But at the time, there was a strong rain that caused immediate flash flood up to the deep neck water with a strong current of water. To pray those strong current of water, definitely he will die. So he was not able to report as soon as possible that knowledge of conspiracy. Hence, he falls under that paragraph 7 of Article 12, exempting circumstances, failing to perform a duty required by law when prevented by some insuperable cause. Flash flood is a particular event. It is not man-made. Also, in the case of a priest who heard confessions of 2 or more persons confessing that they had conspired against the government, and the Catholic priest who heard the confession did not report it to the proper authorities. If somebody learned, this priest never did so, that of reporting, he could be charged for violation of Article 150. But is there any defense that he could successfully put up? Yes. There is a lawful cause why he did not report it as soon as possible. And what is it? The constitutional provision guaranteeing the free exercise of religion, meaning it recognizes the canons of different religions. And under the canon of Catholic religion, priests are prohibited from disclosing those matters learned in confidence by them during confession. So, they are exempted, prevented by some local cause. Then we have this espionage, Article 117. Now, espionage generally means the gathering and transmitting of any information that is detrimental to the security of the state. As a general definition, it could be made like that. But on the manner of commission, Article 117 provides the 2 modes of committing the same. There are 2 paragraphs there. In the first paragraph, the offender is any person, whether a citizen of the Philippines or a foreigner, or a private individual or a public officer. There is no distinction. And then he enters any warship or reservation, military reservation, without local authority. And his purpose is to obtain information, data or photograph of confidential character relative to the defense of the Philippines. And number 2, that pertains to a public officer who by reason or by virtue of the position he held in the government, he has custody and possession of those information or data that are mentioned in the first paragraph thereof, and then delivers the same to the representative of a foreign country. So, espionage is not dependent on the citizen to become guilty. Any person, for that matter. Unlike in treason, where both citizens and resident agents are the ones who could be charged and be convicted of the crime of treason. Now, the public officer under the second paragraph, if the documents, photograph information relative to the defense of the government are not of confidential character, will he be guilty of espionage? The answer is no. But he is liable for infidelity in the custody of papers or documents under the provision of Article 226 of the revised penal code. That is the crime. Because under that second paragraph, the element is that information or data must be of confidential character or nature, referring to the defense of the country. So, if it is not of confidential nature, but still, They are documents or paper that are entrusted in his official capacity as public officer. The removal thereof, the giving away thereof to any person will then constitute the crime of infidelity in the custody of document or papers, which is squarely defined and penalized in the provision of Article 226 of the revised penal code. Under Title 7, crimes committed by public officer. Under the first paragraph, the first mode of committing espionage, it is not necessary that the offender has actually obtained those data or information of confidential character relating to the defense of the country. It is enough that it is proven by evidence that his purpose in coming to that place without local authority is to secure and obtain those documents, data, photograph. Even if he is not actually able to secure and get those information, he is already guilty of violating Article 170. Now, there are other crimes covered since it is also stated in the syllabus. It is worthwhile to also revive it from your memory. Like, for instance, we have the crime of violation of neutrality. And correspondence to enemy country or enemy held territory, or flight to enemy country. Now, with respect to violation of neutrality, it implies that there is a war between the above nations, but the Philippines is not involved. And to maintain the neutrality of the Philippines, the proper government authority issues rules and regulations for the maintenance of that neutrality. And then any person who violates that rules or regulation that maintains the neutrality of the country in the war, that violator will be deemed guilty of the crime of violation of neutrality. Then the crime of correspondence to enemy country or enemy held territory. How is it committed? There are three modes of committing the same. There is a war between the Philippines and the foreign country. Number one is, if there is prohibition to make any correspondence to that enemy country or enemy held territory, any kind of communication by means of letters, whether it contains harmless, even if it is merely love letter, as long as the prohibition says no communication whatsoever shall be made between the Philippines and that foreign country or enemy held territory, the offender is already liable. The second one is assuming there is no prohibition, but the communication or letter is carried out by means of sign, ciphers, or symbol. That is already violation, even if there is no prohibition imposed by the government. And lastly, even if there is no prohibition, but the communication itself carries information that is detrimental to the security of the state, then that is already punishable. And if the nature of that communication is such that it will help the enemy country defeat our defenders, then the penalty shall be the same as in prison. The same penalty for prison shall be imposed under the provision of communication against communication with enemy country or enemy held territory. Then we have the crime of flight to enemy country. This will be committed only by any person, whether a citizen or resident alien, who, after the government has prohibited or imposed a prohibition to fly to enemy country, he flies there or attempt to fly to that enemy country. The mere attempt to fly, as long as there is prohibition, consummate the crime of flight to enemy country, which is penalized and defined under Article 121 of the Revised Penal Code. And then crime against the law of nation, which is, of course, always to be remembered, piracy and mutiny in the high seas or in Philippine waters, Article 122. That Article 122 in its original provision does not have this crime of piracy or mutiny in Philippine waters. It is only by virtue of the Republic Act 7659, the heinous crime law, which introduced that amendment by adding or in Philippine waters. So, piracy and mutiny could be committed either in the high seas or in Philippine waters. While you read the provision of Article 122, you will have actually the idea of what is piracy, because it is specifically defined there. But you could not see any that will give you the idea what is mutiny, except the mere mention of the word mutiny. So to be able to know what is mutiny, you have to read your textbook. And what did you learn from your textbook? Mutiny is the creation of disturbance or commotion in the vessel, in authority, in defiance of the authority of the ship commander or ship captain. That is how mutiny should be understood. Because we don't have anything that will give you idea what is mutiny under the provision of Article 120, except that definition of piracy. Now, how is piracy committed? It is committed by attacking any vessel or seizing the cargo of the vessel or seizing the belongings of the complement of the vessel, whether crew members or passengers. Those are the acts constituting piracy under Article 122. And who are the offenders? The offenders under Article 122 are only strangers to the vessel. Complements, passenger or crew members are not included. But Justice Florence Regalado, in his book, Convictus in Criminal Law, the only remote possibility that a passenger or a crew member could be likewise liable for piracy is if conspiracy is proven. Because conspiracy creates the pendulum between the minds of those strangers and the passengers or crew members, which will make them equally liable, because once conspiracy is proven, the act of one is the act of one. But absence conspiracy, only strangers to the vessel could be offender in the crime of piracy. Now, how do you define piracy now? Well, the internationally known definition is that piracy is a depredation or robbery in the high seas, done without lawful authority and with animo curandi, in the spirit of lawlessness against the community of nations. That's why it is called a crime committed against the whole community of nations. Thus, piracy, wherever committed, may be punished in any of the countries where pirates will seek refuge. In mutiny, of course, they challenge the authority of the ship captain. They create disturbance or commotion. And the offenders here are complements of the vessel. They could be the crew members together with the passengers, or passengers alone, or crew members alone. And in mutiny, unlike in piracy, intent to gain is not an element. Intent to gain is only incidental to the commission of duty. But in piracy, it is always present. The element of intent to gain is there in the crime of piracy. In Article 123, it provides for the so-called qualified piracy. That is the caption of Article 123. There is no mention about qualified mutiny. But there is also qualified mutiny. Because if you read Article 123, it speaks of the offenses mentioned in the preceding article, which is Article 122. And there are two offenses mentioned there, both piracy and mutiny. So you should not be misled by the caption of Article 123, which says qualified piracy. Mutiny is not mentioned. And how it become qualified? When any of those enumerated in the three paragraph circumstances that are found in any of those paragraphs are present. Number one is when the offender shall board or fire at the vessel. So, you could easily conclude that this qualifying circumstance number one will apply only to strangers because they will board the vessel. Whereas, those the mutineers are already on board. So, it applies only to the case of piracy, not to mutiny. But the second and third could apply to qualify both piracy and mutiny. That of abandoning the victims without leaving them any means for survival. Whether piracy or mutiny, that could be employed. And number three is when the crime of mutiny or piracy is accompanied by murder, homicide, physical injuries, and rape. So in other words, there could be no more complex crime of piracy or mutiny with murder, or with homicide, or with physical injury, or rape. Because the moment those crimes are committed during the occasion of piracy or mutiny, that is already qualified piracy or qualified mutiny. No longer to be charged with two separate offenses or shall complex the same with each other. Don't forget that we have a special law punishing piracy in Philippine waters, PD 532, where it is committed or seizing vessel or seizing the cargo thereof or the belongings of the complements, whether fuel or passengers thereof, by means of violence or intimidation or force upon things, while the vessel is in the Philippine waters, committed by any person. So, you will now draw the distinction between piracy under Article 122, which could also be committed in Philippine waters, with this offense of piracy in Philippine waters covered by Presidential Decree 532. Take note, first, in the crime of piracy under Article 122, there is no mention on the manner how it will be committed. But in piracy, under PD 522, it states, by means of violence or intimidation of person or force upon means. And the offender is any person. So in piracy in Philippine waters, whether he be a stranger or a member of the complement or a passenger, as long as he commits that attack or seizing of the vessel or cargo inside that vessel by means of violence or intimidation of person or force upon thing, that is piracy in Philippine waters. But suppose those pirates or even the complement in the middle of the night, they steal without the consent of the owner the cargo belonging to the ship or belonging to the passengers or crew members. Will that be considered piracy in Philippine waters under PD 532 or even in Article 122? The answer is no. Why? In PD 532, it specifies the manner by which those property shall be seized, either that it is by means of violence or intimidation of person, or by force upon things. If it is taken without the consent of the owner, and no violence or intimidation of person or force upon things are employed, the crime is imported under Article 308. And if it is committed with abuse of confidence by the crew members, then it will be qualified theft, which shall be covered by Article 310 of the revised penal law. Then what is Philippine waters? And what is a vessel for purposes of applying this PD 532? Now, vessel refers to any watercraft used for movement of persons or transporting goods through Philippine waters. And it includes any watercraft which may consist vessel or even fishing boats. And what is Philippine water? Oh, any water belonging to the Philippines. Those that are surrounding, connecting all the islands of Philippine archipelago, regardless of depth, width, or dimension. And those waters which the Philippines has historic or legal title, including the territorial water, seabeds, and other portion of the waters over which the Philippine government exercises jurisdiction. That is the meaning of Philippine waters. So I hope, by the way, suppose persons assist the pirates under PD 532 or acquires and obtain any of proceeds of the crime of piracy, or gain or derive profit thereon. What is the liability of those persons? Now, under the provision of PD 532, they shall be considered accomplice in the commission of the crime, accomplice to the principal, and they shall be punished according to the rules of the revised penal code. So this is a situation where accomplice is punished by the special law, but the penalty is found in the revised penal code. As a rule, in violation of the special law, only the principal is liable. There is no accomplice nor accessory. The exception only is when the provision of law itself provides punishment for mere accomplice or as an accessory in the commission of the crime of piracy in Philippine waters. So there is no accessory here, because even those who derive profit are considered accomplice, and they shall be penalized 1 degree lower than that penalty prescribed for the principal in the crime of piracy in Philippine waters. Then the other penal laws, special law, that is considered included according to the syllabus, is the anti-hijacking law. The anti-aircraft hijacking na tinatawag. Ano bang pili nga Republika? Basta anti-hijacking, hindi naman kayo nire-require na examine yan, nasabihin pa ang Republika at saka yung mga PD number. Baka magkamali pa kayo ng pagkasabi ng number, baka i-minus pa sa inyo yun. Kaya according to law na lang. According to law. Kaya ako lang naman nababanggit ito as reviewer ninyo. At least naman, alam ko yun eh. Bakit hindi alam niyo siya? Sabi ba't alam namin? Kung hindi ko man alam na rin natin na yan ay part of the law. Sabihin natin, dapat tayo hindi nagkakainggita. So, what are those acts punishable under this anti-hijacking law? Number one is by seizing the control of the airplane or compelling that aircraft which are registered in the Philippines when such aircraft is in flight. What is the meaning of the aircraft is in flight? When all the exit doors are closed from the place of embarkation up to the time it reaches the place for this embarkation. That is in flight. Yung kanilang exit door is still closed. That is the meaning of that, when the exit door are closed during when the aircraft is in flight. So it applies only to aircraft that are registered in the Philippines. The second act is when seizing the control of an aircraft that is foreign aircraft or compelling the same to land in the Philippines. There is no requirement that it shall be in flight, only in Philippine registered aircraft where the requisite of in flight is provided. The third act is when carrying any substance to aircraft used for public conveyance, substances that are corrosive, poisonous, explosive, or flammable. They are prohibited. And when it comes to cargo aircraft, the same substances carried and loaded in violation of the rules and regulations by the Air Transportation Office. I think it is no longer the name of that office, it has been changed. But whatever is the name, it refers to that office regulating the flight of aircraft, whether domestic or foreign aircraft. Those are the punishable under the special law known as the Anti-Hijacking Act. Now, another special law, this is a very new one, which really requires some focus in order that the same may not be missed by you during the bar examination. Kasi meron dahilan kung bakit isinama specifically ito rito. So I say, it is dangerous for you to be afflicted with amnesia, whether partial or complete during examination time. So, iwasan ang sakit na kalimot. Yan ang giling ko sa inyo. Now, this Human Security Act, which is Republic Act 97, not 97. Magkamali ako na Human Security Act of 2007. Republic Act 93, 72. This is the Republic Act. Now, according to the Black's Law Dictionary, terrorism refers to or involves violent acts that are dangerous to human life. It seeks to intimidate the populace and influence the policy of the government. It is a crime against the laws of nation. Now, under the provision of Human Security Act, what is or how do you define terrorism? Now, terrorism is a crime which is committed by any person who commits any of the following crimes divided into two classifications. One, 6 felonies are specified in the definition of terrorism. What are these crimes? Piracy and mutiny under Article 122, rebellion or insurrection under Article 134, coup d'etat under Article 134-A, murder, Article 248, kidnapping and serious illegal detention, Article 167, and crimes involving destruction, Article 324. 6 felonies that are specified in the definition of terrorism. And or any of the following crimes punished under special law. Another 6 na naman ito. Isang dosen na itong lahat na crimes na ito, if committed, it may form as an element of the crime of terrorism. Now, what are those 6 crimes punished by special law? Arson under PD 1613. Then, violation of Republic Act 6969, otherwise known as Toxic Substances and Hazardous and Nuclear Waste Control Act. Then, violation of Republic Act 5702, Atomic Energy Regulatory and Liability Act. And then, number 10, Anti-Hijacking Act, Republic Act 6235. Then we have the 11th, Anti-Piracy and Highway Robbery Law, PD 532. And finally, PD 1866 as amended by RA 8294, which is the crime of illegal possession and use of firearms and explosive law. The offender that commits any of the crime. And this commission shows, thereby showing or creating any condition of widespread or extraordinary fear among the populace to coerce the government to give in to unlawful demand. So, be sure, madali naman intindihin this any crime na in-enumerate, 12 yun, 6 covered by the revised penal code, and the other 6 punishable by the special law. And the commission thereby causing, thereby sowing, and creating a widespread condition, widespread and extraordinary fear or panic among the population, in order to coerce the government to give in to unlawful demand. Now, if you will see how these specific crimes are committed, if for instance a person commits murder and it creates widespread chaos or fear among the populace, and the purpose is to coerce the government to give in to some unlawful demand. Alright? It becomes terrorism. But remember, if it is only homicide that is committed, it is not included. Even if it's so fear, widespread at that, it is not terrorism because the law specifies that it should be murder. It should be murder. Unlike in some provision of the revised penal code, where the use of homicide is in its generic sense, that covers even murder and infanticide, like the robbery with homicide in paragraph 1 of Article 294. You learn that that use of homicide is in generic sense, which covers even murder and parricide or infanticide. But in the specific definition of terrorism, it should be murder that is committed. That's so that created widespread fear and panic among the population. If piracy in Philippine waters is committed, and it creates widespread and extraordinary fear among the populace, and the purpose is to compel the government to give in to some unlawful demand, then it will give rise to terrorism. However, if the information is filed for terrorism, and these crimes that I enumerated, which are all 12 in all, if let's say murder is the crime committed, a predicate crime but which created widespread panic and fear among the population, if during the trial in court, the elements of terrorism are not proven, but murder, which is alleged together with the specific elements, are proven, then the court can convict the accused merely of the crime of murder and not terrorism. Because murder is necessarily included in the crime of terrorism, which, if properly alleged with all the elements of murder proven by evidence during the trial, but the other elements of terrorism, like creation of widespread panic, are not shown by the evidence, then the accused shall be convicted only of murder and not terrorism. The same is true with piracy, or let's say rebellion, codita, kidnapping, or arson. If all the other elements of terrorism are not proven, but these specific crimes, which are properly alleged together with the elements in the information, are proven by competent evidence, then the offender shall be legally convicted of these individual crimes and no longer for terrorism. Now, there is also a crime of conspiracy to commit terrorism under the law, Human Security Act. It is defined there and is penalized. So, all conspiracy to commit terrorism is punishable. The act of accomplice is also punishable. An accessory to the crime of terrorism is also punishable. But the law, this Human Security Act, provides exemption. Very specific, according to that provision of the Human Security Act of an accessory. Those accessories who are such with respect to their spouses, ascendants, descendants, legitimate, natural, and adopted brothers and sisters, or relatives by affinity within the same degree, except accessories who profits himself or assisted the offender to profit by the effect of the crime, shall be exempt from criminal liability. But it does not specify this provision of Article 20 in the revised penal code. This exemption is specifically provided by the provision of the Human Security Act without express reference to the provision of Article 20 of the revised penal code on exemption of certain accessory. We will have a short respite at 10:30 para naman makapag-relieve tayo. Ano ha? Pero maya-maya pa kasi wala pa eh. Inuurasan ko na baka mapasobra. Eh magalit naman kayo kung tuloy-tuloy ako. Alam mo kung isa para ako yung diesel engine eh. Pag nag-iinit pa, gusto ko tuloy-tuloy na agad ang takbo eh. Ha? Kaya from time to time, I'm looking at my watch. Now let's go to the fundamental, the crimes against fundamental laws of the state. This title, or crimes embraced on this title, is very important to all of us, because all these crimes are against the provision of the Constitution, especially the Bill of Rights. Like for instance, arbitrary detention. What is the particular constitutional provision? No person shall be deprived of liberty without due process of law. One bar examination, all my students expressed elation and happiness because my favorite question was asked in the bar examination. So automatically they said, aba, mukha ni sir ito nakikita namin sa question na ito. Ito ang madalas na ibibigay niya sa book 2, during first year o kaya kahit nasa review. What is that? What are the different classification of the crime of arbitrary detention. There are three. The three successive articles, 124, 125, and 126, are the ones that make arbitrary detention divided into three classifications. Article 124, arbitrary detention. Proper, I should say, because that is the only among the three articles that mentions arbitrary detention. So I say arbitrary detention proper. And how is it committed? It is committed by any public officer or employee who detains another without any legal ground. It mentions about public officer or employee. Thus, it includes all public officers which are covered by the definition of the term public officer, which you can find in Article 203 of the revised penal code. Remember, the term public officer is defined under Article 203. But if you will see that definition, it covers all public officers in the government, from the highest position, the President of the Philippines, down to the lowest functionary of the government. Are they included in the definition of the crime of arbitrary detention? The answer is no. There are only two classifications of public officers who could be offended in the crime of arbitrary detention. And they are, number one, those public officers who have the power to order the arrest of a criminal. And number two, those public officers who have the direct power to effect the arrest of a criminal. So, judges, prosecutors belong to the first. Mayors, governors, President of the Philippines, they have the power to order the arrest. Even barangay captain. Now, with respect to the other category, those who have the power to directly arrest offenders, then we have the members of the law enforcement agencies, like the policemen. And this will include even the, what I used to mispronounce, barangay tagay. Pero barangay tagay, barangay tagay kasi nag-visit ako doon sa mga barangay na nag-duty. Eh walang ginawa kundi magtagay na lang na magtagay ng mga demonyo. Kaya tuloy natin yung demonyo sila paminsan-minsan. So, Emir Clerk, Chief Clerk in an office is a public officer. The Secretary of the Sangguniang Bayan is a public officer. The Secretary to the Mayor is a public officer. But if they detain a person without legal ground, definitely they will not be held liable for a violation of Article 124 because they are not included there in the phrase public officer or employee. That crime would fall under Article 167 or 168, which is illegal detention, not arbitrary detention. And what is the meaning of detention? Does it necessarily mean that they shall be, or the person detained shall be placed in an enclosure? The answer is no. Even if they are not placed inside the enclosure, outside the house, outside the cell. But the person detained could not live at their own free will because there is always a guard, or that they could not live even without a guard because of duress that is already embedded in their minds by the offender. At pumalis ka dyan, pag nakita kita agad, dead ball ka na. I will also massacre your family. So, sa takot ng taong nakatiting, nandun lang siya sa labas. Paikot-ikot siya ron, pero hindi siya makalayo. According to the Supreme Court, that is covered by the term detention. And that decision of the Supreme Court applies to both detention and illegal detention under Article 167 or 168, and in the definition or in the crime of arbitrary detention. Now, what are the legal grounds for detention? Then that other paragraph of Article 124 says, commission of a crime, whether consummated, prostrated, or attempted, or when the police officer have reasonable ground to believe that that person has committed a crime, he or detained. So outside of those, it is not. What is the other legal ground mentioned? Violent insanity of the person detained. And the last one is those suffering such illness which is contagious, that requires confinement. So tatlo yun. Commission of crime, violent insanity, such illness that will require confinement to hospitals of those who are sick, of those necessarily they shall be contagious diseases or illness. Now, the second classification is arbitrary detention by delaying the delivery of a detained person to the proper judicial authority. Delivery by the offender, who is a public officer, meaning to say, he will only file the proper complaint. It is not required that the person detained, bubuhatin niya, dadalhin sa judicial authority. No, it's not. Pwede nakalagay sa counsel, pero tapos na ang kanyang investigation, yung complaint ready, ipapile na lang niya doon sa proper judicial authority. Hindi kasama yung tao. That is the meaning of delivering of a detained person to the proper judicial authority. Eh kung isinama niya ang tao, ay di lang ang mabuti, ay paano kung matakasan siya? Di otro kaso pa sa kanya. Madidemanda pa siya ng infidelity in the custody of a person under detention. Now, who is that proper judicial authority? They are judges of the ordinary courts. It does not include the prosecutor. Even if we have rules on inquest proceeding, a person arrested by the police for having committed a crime is, as a matter of the rules of court, Section 6, Rule 112, should be brought before the inquest fiscal, inquest officer, who shall determine whether the arrest was valid and whether there is probable cause in order to warrant the immediate filing of information against the accused. But the presentation of the accused to the fiscal is not covered here. What is then the effect of bringing the accused within that number of hours mentioned in Article 125 to an inquest officer? That will insulate the public officer from being prosecuted for arbitrary detention, because it is not the police officer who will eventually find the information in court. It is the fiscal. So why will you call the fiscal? I mean the police officer. Why the information was not immediately filed in court? It is incumbent upon the prosecutor. So the policeman is insulated from being charged. It is a matter of defense on the part of the policeman, because they follow the rule established in the rules of court. Those who are affected or arrest under the warrantless arrest provision, they shall bring the person to the duty inquest officer. In Manila, we have 24 hours duty. I was then the chief inquest prosecutor of the city of Manila before I opted to retire, because I'm already fed up with government service. I want to return to the life of an ordinary citizen of the Philippines. But when I retired, I became a person with dual citizenship. I am a Filipino citizen and a senior citizen. Dual citizenship. All right. Article 125 does not cover a situation where the arrest was by virtue of a warrant of arrest. This is the provision that covers warrantless arrest. A police officer who is armed with a warrant of arrest issued by the court, he arrests the person named as the accused in that warrant of arrest. He does not pay him to the judge or the court, nor place him inside detention cell. He brought the person who he arrested by virtue of the warrant in his safe house. He placed him there for 1 week before he ultimately presented it to the court. That policeman will not be guilty, nor be considered to have violated Article 125, because there is already a process issued by the court that accused who was arrested had been subject of a proceedings. And Article 125, wala pa itong judicial proceeding. The person there who is detained was the one arrested under the warrantless arrest provision. And that's why there is duty or obligation on the part of the policeman to comply in order to prevent him from being charged with violation of Article 125, arbitrary detention for delaying the delivery of a detained person to the judge to proper judicial authority. Now, for how long shall the policeman or public officer who effected a valid warrantless arrest would detain him without filing the complaint? Well, the law enumerates. For those crimes committed by that person who was detained by him, if the penalty prescribed by law for the offense committed is afflictive in character, meaning to say prison mayor and above, then the policeman may detain him within a period of 36 hours. Within that 36 hours, he must file the complaint in order to comply with the duty of delivering the detained person to the proper judicial authority. But if it is already over 36 hours when he files the complaint before the proper judicial authority, then he is now to be prosecuted for violation of Article 125, delay in the delivery of a detained person to the proper judicial authority. Now, if the offense committed by the detained person is punishable only with a correctional penalty, then he shall have the right to retain him for only 18 hours. Within that 18 hours, he has to comply with his duty to file the complaint. If it exceeded that number, the same. It is violation of Article 125. And lastly, when the penalty for the crime committed is, it's only a light penalty. Light penalty. Those punishable by arrest or a fine of not less than or not more than 200 pesos. They are light penalty. So, they could be detained. This detained person could be detained only for a maximum period of 12 hours. Within that period, the officer has to file the complaint. If it goes beyond 12 hours, then he will be guilty of violating Article 125. Suppose the policeman has actually filed the case against the arrested or detained person, but it is already beyond those number of hours, 36, 18, or 12. Will that filing of the complaint cure the illegality of detention, thereby exempting him already from the penalty for violation of Article 125? The answer is no. The subsequent filing of the complaint by the police officer will not cure that illegality of detention. He is still to be proceeded against for violating Article 125. But the person detained may waive the provision of Article 125. How? By executing a waiver of the provision of Article 125. It is valid, provided that when he signs that waiver, he is assisted by a counsel, whether of his own or given by the police, as long as he is not a policeman himself. Because this lawyer who will assist him must be an independent counsel. It is not a policeman. A lot of policemen are lawyers, but they are not authorized to represent the detained person who wanted to waive the provision of Article 125. If he waives it, then the fiscal will subject the complaint against him to a regular preliminary investigation. Meanwhile, he is under detention. He could not claim that he is illegally detained because he had already executed that waiver of the provision of Article 125. Under the rules, the preliminary investigation shall be terminated within 15 days. But you know, that is only it is not mandatory because in our experience, the preliminary investigation will continue or will reach up to 6 months. 2 months, 60 days. Sometimes 90 days if there is a special reason and the Chief of Office approves the request of the investigating officer. If not, if he is not able to terminate that, well, either that he shall suffer the penalty for to be meted during administrative proceedings, and meanwhile, all his allowances will be suspended. Even the salary will be suspended. Kaya yung mga prosecutors natin sa field offices ng Department of Justice, natatakot sila, lalo na kung yun lang ang source of livelihood nila, tatapusin din yung preliminary investigation to comply, termination thereof within the prescribed period. So, yung tatawag na inquest proceedings should be understood in relation to Article 125 of the revised penal code. Marami pa ang hindi nyo actual experience about this inquest so-called. It is in relation to Section 6 of the revised rules of criminal procedure. Whenever there is a valid warrantless arrest effected by police, the police is duty bound to present the arrested person to the duty inquest officer, who shall determine two things. Was the arrest valid under the provision of Section 5, Rule 113? Is there probable cause to support the filing of information in court? If this no concur, then the fiscal may advise, all right, continue detaining that person. But if the arrest is not valid, and even if it is valid probably, but the fiscal's finding is that there is insufficient proof to support a probable cause against the accused, then he will order the release of the accused and set the case for preliminary investigation. That is my power when I was the chief inquest prosecutor. Even the first gentleman Arroyo, kinokontak din ako. Kung minsan pinapagalitan pa. Eh, lumala pa naman ako. Sabi ko, sir, tama naman yung ginawa ko. Hindi naman pwede yung ganun eh. Then, Nonong Cruz, the legal counsel in Malacanang, will talk to me. Chief, saan ba? Galit na galit sa'yo si first gentleman. Bakit daw ganun naging resulta ng inquest? Eh, kako sir, kako ganun. Secretary, eh, ganun naman talaga yung nasa pala. Meron ka ba authority? Yes, sir. O sige, papupuntahin ko yung bata ko dyan. Pakala mo yung authority mo. Kung maaari, yung excerpt na, para hindi na kami mag-research pa. So, pupunta rin pa yung assistant lawyers ni Nonong Cruz, yung dating legal counsel na ni Mrs. Arroyo. Pagkaraan nun, pinahapunan, tatawag sa akin si Nonong. Chief, mag-relax ka na. Naintindihan ng tama ka raw, sabi ni President. I know, the President will understand me. The correctness of my action. Ay, abogado rin naman siya. Di ba? Abogado siya. Classmate na niya si Ombudsman Mercedes Gutierrez. Hindi pareho silang magaling.
Kaya pala. Pareho.
Okay. Wala akong naging kasakin. Minsan, si Mrs. Estrada naman, si Doktora. Yung bata rin, violation ng 7610. Bakit daw ganun? Nagreklamo sa kanya nila. Eh, ma'am, meron ba kayong katabing abogado dyan? Eh, wala. Eh, sige, tatabahin mo na. Mag-usap kayo. Usap kami. iwanan ko doon sa abogado. Siya nagpaliwanag kay Dr. Lloyd Estrada. Tapos, biglang tumawag sa akin si Lloyd Estrada. Chief, thank you. I became educated in that point. Tama pala yung ginawa mo. So, kaya kung ikaw ay naabala ko, kita mo. Mabait naman si Dr. Well, kaya ko lang naman sabi, no, if you know the law, and you know that you acted in good faith, kahit na pa sinong-sipo na sila, hindi dapat katakutan. You stand for what is right. Ano? Alam mo kasi, pagka ganito, if a man surrenders when he is wrong, then he is honest. If a man surrenders when he is not sure, he is wise. But a man who surrenders, even if he is right, then perhaps he is a husband. Okay, it's already 10:30. Let's take a break. Yung mga that is probably the reason why it's included under crimes against fundamental laws of the state. Hello. Now, the last kind of classification of arbitrary Article 126, delay in the release of that detained person. Reading that article, there are three distinct situations which could be each penalized if committed by the detaining officer. Number one is delay in the execution of the judicial or executive order to release the detained person. When you speak of judicial order, it means order issued by the court for the release. When you refer to executive order, it could pertain to release order coming from the prosecutor. If without reason, the public officer who is in custody does not execute the order of release, then he shall be guilty under the first form of violating Article 126. Here, remember that in both Article 125 and 126, the detention is legal from the beginning. It becomes arbitrary only later on. In Article 125, when there is a delay in the delivery of the detained person to the proper judicial authority, that arbitrary detention is committed. In the case of Article 126, from its inception, the detention is valid and legal. But it becomes arbitrary only when the officer is liable for any of those three acts enumerated. The second one is delay in the giving of notice of such order to the detained person. Now, delaying the giving of notice of the executive or judicial order of release without just cause shall also be act of arbitrary detention. And lastly, delay in the proceedings in any petition for the liberation of a detained person. So this pertains to petition for habeas corpus, the speediest remedy that may be availed by a person who claims to be illegally detained of his liberty. If the officer delays the proceedings, then he shall be guilty for violation of Article 126. Then we have the crime of expulsion under Article 127. Again, public officer or employee who without any local authority shall expel a person from the Philippines or compel him to change his residence. Now, with respect to the expulsion, remember only the President of the Philippines and the Bureau of Immigration and Deportation, after appropriate proceedings, can expel an alien from the Philippines, the undesirable alien. Can public authority in the Philippines expel a Filipino citizen who is undesirable? The answer is no. If a Filipino is undesirable in his own country, what country will be willing to receive an undesirable Filipino? So it pertains only to a foreigner. And also, the court may order the deportation in a judgment of conviction. But remember, the deportation is always accompanying the sentence of imprisonment. And deportation will follow only upon service of sentence. You know, there was a Chinaman who was convicted and sentenced to suffer long term of imprisonment and deportation. Upon reading the judgment, the sentence, he stood up and said, Your Honor, pwede po ba ako hiling lang ng counting pabor? Sabi na, bakit? Anong gustong pabor? Pwede po ba una muna deportation? Now, with respect to the last portion, that is compelling a person to change his residence or domicile, this is a violation of the constitutional provision of liberty of abode and of changing the same under the Constitution's Bill of Rights. Now, if it is a private individual who commits that act of compelling a person to change his residence without lawful cause, the crime would be grave coercion under Article 286. That is the right. The legal way of compelling a person to change his residence is by order of the court, like in ejectment proceedings, or when there is an expropriation proceeding, or when the accused is convicted of a crime and sentenced to suffer the penalty of disquero. By force of that penalty, if the prohibited area where he could not enter is where his residence is located, then he could not enter that area because it will be a violation of the penalty of disquero, and he will be subject to punishment for violating Article 157, the crime of evasion of service of sentence. Then, ito, siguro, importante ninyo dapat na malagay sa isip. Halos sigurado ako na may lalabas na question dito. What are the three forms or what are the different classification of violation of domicile? Now, there are three. They are covered by three successive articles, 128, 129, and 130. Now, under Article 128, I would say that is the so-called violation of domicile proper, because that is the only article among those three successive articles which has for its caption violation of domicile. And who is liable for that crime? Any public officer or employee who, without proper judicial authority, shall enter the dwelling of another, number one, against his will, number two, when that public officer conduct search without the previous consent of the owner, and number three, when that public officer surreptitiously enters that house or premises, and when discovered and when demanded to leave by the owner, he refuses to leave. By his refusal, he becomes guilty of violating Article 128. Each of these three acts, if committed, is punishable. So, repeat, the public officer must be without proper judicial order, meaning without search warrant. And then he enters the dwelling of another against his will. Number two, he effects search without the previous consent of the owner. And number three, when he enters the house or premises surreptitiously, but when discovered by the owner and demanded to leave, he refuses to leave. Let's go to the number one. That entrance against the will of the owner does not necessarily mean that it is entrance without the permission of the owner. It has been explained in many decisions of the Supreme Court that that phrase against the will must be understood to mean entrance against the express prohibition or entrance against the implied prohibition to enter. Where is there express prohibition? If there is the owner there in his house and when asked by the police or any public officer if he could enter, and the owner of the house, may warrant ka ba? Wala po. Ayaw kitang papasukin dito. Express prohibition. Assuming na yung may-ari, pero laki-laki naman ang karatula, do not enter. No? Express prohibition din yun. Pag pinasok mo yun, kahit na wala yung may-ari, that is violation of domicile. What is an example of implied prohibition? Alright, ito si Mang Tomas. Hindi siya yung may-ari ng Mang Tomas Lechon, ha? Si Mang Tomas dito, kapit-bahay namin. Na walang hanap buhay. Okay? Nandun siya harap ng bahay, pumasok yung polis, kung dumating. Mang Tomas, pwede po ba pumasok sa bahay niyo? Mag-uusap lang po tayo. Sabi ni Mang Tomas, ay, ayaw ko, wala akong waran. Wala akong gano'n makipag-usap sa polis. So, the policeman pretended to leave. But he just go around the house and finding that there is an open window, he climbed the window and enters the safe. Now, what is that entrance? Is it against the express prohibition or implied prohibition? It is considered, according to the court, implied prohibition because windows are never for the purpose of entrance. Windows are intended for young women to look out and see the passing young and passing men. And for men to look outside and see the pretty faces and beautiful lips of women. That is the purpose of a window, but never for entrance. So we have not. Suppose Mang Tomas was persuaded to give permission to enter. Okay, sabi ni Mang Tomas, sige, gusto mo pala akong makausap. Okay, ano ba yan ating pag-uusap? Once inside the house, the policeman never asked his permission. He draws his pistol, but it is not aimed to Mang Tomas. And then went inside all the rooms there and conducted search until he was found a unlicensed firearm, caliber .45 pistol. So, because of the discovery of that unlicensed firearm, he seized the same and arrested Mang Tomas for and charged him with violation of PD 1866 as amended by Republic Act 8294 for illegal possession of unlicensed firearm. So, it was filed before the fiscal. Then, on the, as a counter charge, the accused, I mean to say, Mang Tomas filed a counter complaint against the policeman for violation of Article 128, violation of domicile. Question, which of these two charges could prosper? Is it the charge filed by the police for illegal possession of unlicensed firearm? Because Mang Tomas was found to be possessing an unlicensed firearm, or the charge against the policeman by Mang Tomas for violation of domicile. Let's dissect the facts. Ito ang kasama sa multiple choice question. To give you idea on how to answer multiple choice question first, power of recall. What we are doing here now is to improve your power of memory, which includes power of recall. Recall the provision of law and the precepts or principles that are applicable, and then from the facts, learn how to analyze. Now the facts are there. How will you analyze? Because the question is, which one will prosper? Alright. Since this crime of violation of domicile is violation or is committed in violation of the Constitution, what is the provision of the Constitution that is violated by crimes punished where the crime committed is violation of domicile? The right of the citizen against unreasonable searches. That is the provision of the Constitution. When Mantomas gave his permission to enter for them to talk, that's all right. But it does not carry with it the consent to conduct search of the house. Because that fall under the second act that is punished under Article 128. Conducting search without the previous consent of the owner. It implies that aside from the permission to enter, the policeman must ask for a consent because of the word without the previous consent. It implies that the policeman should ask consent to effect the search. Now, you will say, hindi niya piligian, di ba meron tayong principle na merong express waiver or implied waiver of the constitutional right? Well, the Supreme Court in the case of People versus Banto, under the same set of facts, the Supreme Court said the conduct of search is in violation of the Constitution because there is no valid waiver of the rights. There are prerequisites before the right against unreasonable search under the Constitution could be waived according to the Supreme Court. One, there must exist that right. The right exists in favor of that person, Mantomas. And Mantomas is aware of such right that exists in his favor. And number three, that he shall knowingly waive his right to it. Since absent any of these prerequisites, or all the prerequisites are absent, then that is violation of his right. And it does not conform to the second punishable act mentioned in Article 125. The search was without the previous consent of the owner. Since there is violation of his constitutional right, all those evidence that persist in violation of that right shall be rendered inadmissible in any court as evidence. So Mantomas, the charge against Mantomas shall be dismissed. Because that confiscation or seizure of that contraband cannot be used as evidence against him because of the violation of his right against unreasonable search. Then Mantomas' complaint shall prosper because the public officer was without judicial warrant and he effected a search without securing the previous consent of Mantomas. That is how this Article 128 should be understood, especially with respect to the first and second act mentioned therein. What about the third one? The public officer or policeman was without any search warrant. He secretly, surreptitiously, able to enter the premises. But because perhaps he created some noise, the owner discovered him. And then the owner was now very curious. Bakit ka narito sa bahay ko? Hindi naman kita kilala. Lumabas ka. Okay. Pag lumabas siya, wala siyang kasalanan sa Article 128. Pero kung hindi siya lumabas, despite the demand of the owner, then that third act is being committed. He shall be liable for violation of domicile. But even if he lives upon being demanded by the owner, but the question is not what is the violation of Article 120. That is not the question. The question is there any crime committed by that police officer? So, hindi na kamukha doon sa unang answer ang magiging sagot nyo. Doon sa una, kung lumabas na siya, wala siyang violation of 128. Pero, hindi naman na nangahulugan na wala siyang crime na nakomit. Noon bang pumasok doon yung police at nag-search, hindi na namin ang may-ari. Halimbawa kayo may-ari ng bahay, nakita niyo yung police. Ano ang magiging reaction niya? Ay, naku, salamat naman, kahit hindi kita kilala, pumasok ka sa bahay ko. Ganun ba magiging reaction niyo? O pasamang masama ang loob niyo, gusto niyo nang sugurin ng polis dahil sa bakit siya pumasok niya nang walang pahintulad niyo. Ganun ang magiging tunay na reaction niyo. Kung ganun maging reaction niyo, ano ang crime na nakumit ng police? Then you will consult Article 287, the lightest kind of coercion, which is unjust vexation. That is the crime committed by the police. What is unjust vexation according to the latest decision of the Supreme Court? It is any conduct or act of a person, although not capable of inflicting physical harm, nonetheless causes irritation, vexation, or annoyance upon an innocent person. That is the crime committed by the police. Not violation of domicile under the last act mentioned in Article 120. It is falling under Article 287, the so-called unjust vexation. All right, the second form, Article 129, that is maliciously procuring a search warrant or using unnecessary severity in executing one that is validly issued. But take note of the opening sentence of this article. In addition to the liability that may attach to other violation or offense committed, the penalty under that provision shall be imposed upon any person or a public officer who shall procure maliciously a search warrant or shall exceed authority or employ excessive severity in the execution of a search validly issued. What is the legal significance of that first portion, the opening sentence of Article 129? It implies that the officer may have committed another crime other than violation of Article 129. Why? Because in addition to the liability for some other offense that may have been committed, the penalty of provided in Article 129 shall be imposed likewise. So there is no complex crime there, but two separate crimes. Maliciously procuring a search warrant. How is search warrant being secured? By means of application for the issuance of search warrant. And what is one of the requirements? To attach thereto an affidavit. An affidavit. Now, suppose the applicant executes an affidavit and then he made a deliberate assertion of falsehood on a material matter required by law, under law. And because of that falsity, he was able, the court was persuaded to issue a search warrant. Alright, the search was effected, the result was negative. Because there was actually none that could be found in the premises to be searched. Perhaps the applicant only applied for it to cause some harassment or whatsoever against the person to whom the search will be effected. Now, in that situation, we will follow the first sentence of Article 129. What two crimes were committed here? There is the crime of perjury, first, because he made a deliberate assertion of falsehood in an affidavit required by law on material matter required by law under oath. And number two, the reason for the procurement is malicious. So two crimes are to be prosecuted against the offender: perjury and maliciously procuring a search warrant. And he will be convicted of these two offenses if proven by strong and competent evidence. Now, with respect to the employing unnecessary severity, suppose there is a search warrant. The object of to be searched are, let's say, paraphernalia, drugs paraphernalia, or contraband like firearms that are not covered by license. So they have a legal reason to search. But then there was unnecessary severity and there are other intentions on the part of the police. Instead of just opening the wardrobes, the cabinets, without destroying, they destroy the same left and right. But they have a purpose. When they see a jewelry box, which certainly will not contain a firearm, they take it and packet it the same. But they use force upon things in doing so. Excessive severity. Although they were able to find this contraband, nakakuha sila ng firearm doon sa ibang lalagyan. But the fact that they exceeded their authority or employ unnecessary severity because of their intention to take something more than that firearm, then what two crimes will they be charged? Violation of Article 129 or employing excessive severity in the conduct of sex. But they also use force upon things for the purpose of robbing. So they shall also be independently charged of robbery in order to apply the first portion of Article 129. In addition to the liability for some other offense that may have been committed, the penalty under this provision shall be imposed. So there could be no complex crime because the provision speaks of independent and separate penalty. Please have that in mind. Marami kasi hindi nakakaintindihan dahil kayo nagpa-practice na. Pero yung mga pulis magaling. Pag nagpa-imbestiga, ang demanda, lahat na makikita sa libro, theft, malicious mischief, lahat na. And violation of domicile. Mas magagaling yung mga investigador ng polis. Pero yung mga practicing lawyer, hindi nila sinasabi yun. Kasi hindi nila nakita yung provision na yun ng Article 129, yung first portion, in addition to the liability for some other offense that may have been committed. The penalty of so and so shall be imposed. Then let's go to Article 130, the last crime of violation of domicile. This is committed by the public officer in those cases where search is proper, but they effected the search without the presence of the owner of the house or a member of the family, or in the absence of those two, in the absence of two witnesses who belongs to the same locality. Now, what is the purpose of the law in punishing search conducted without witness? To prevent abuse of power, and more particularly to avoid this habit of the policemen to plant evidence to innocent victims, to implicate them for some false prosecution of an offense. That is the purpose. So, there is no owner of the house, no members of the family. Pero itong mga searching party, search warrant could be issued by a court in a place other than where the search shall be conducted. Di ba? Okay. Yung Manila Court nag-issue ng search, Quezon City Court nag-issue ng search warrant which shall be conducted in Manila. Kasi alam na nila yung tao rin sa bahay na yun, umalis, nagbabakasyon, so walang tao. They brought two witnesses from Quezon City. And when they arrive at the place, they break open the door in the presence of the two witnesses and began searching. And then, after searching, they got all those that are covered and have been signed by the two witnesses which came from Quezon City, and not belonging to the same locality where the search was conducted. What is the crime committed by those police officers? The same crime, violation of Article 129. That is the crime. It is as if a search was conducted without any witness at all. It could easily be understood why the law requires that the witness should be coming from the same locality. Because those people in the same locality can properly observe what the police will do and probably still in favor of those person of the owner of the house. Pero pag nandoon galing sa ibang jurisdiction, hindi naman galing doon, ito'y kakuntsaba ng mga pulis. Kahit na anong gawin nila ng mga pulis, pwedeng gawin. At kung kasama nila yun, nakakuntsaba nilang witness, hindi naman magsasabi ng masama laban doon sa mga pulis na nagsama sa kanila doon. So para din walang the crime is still violation of domicile by searching without the presence of the required witnesses provided under Article 130. That is the crime. Article 130, I mean, yun pala yung last. Kamay lang ako ng pagkasabi dito. Alright. Let's go now to Article 131. That is 131, prohibition, interruption, and dissolution of a peaceful meeting. Now, this is also committed by a public officer who have no legal ground. And that public officer should not be a participant in that peaceful meeting. Because if he is a participant in that peaceful meeting, it is not the crime that will be charged against them. It is violation of Article 153, that is disturbance of public order or unjust vexation as the case may be. But if the public officer is not a participant in that peaceful meeting, and then without any legal ground, he interrupts or dissolves or prevents the holding of that peaceful meeting, then that public officer is guilty of Article 131. Now, suppose in the crime of crime against this interruption of religious worship, crimes against religious worship, there are only two kinds of crimes against religious worship: interruption of a religious ceremony and offending the religious feeling under Article 133. Now, Article 132 punishes any public officer who shall prevent or disturb the holding of a ceremony or manifestation of any religion. Whereas, in the case of Article 133, crimes against religious worship, it is committed by any person. At the door of the distinction, Article 133 punishes any person. But in Article 132, definitely, it is a public officer who shall stop or disturb the holding of a ceremony or any religious manifestation. Suppose there is a religious rally or religious meeting at the Luneta grandstand. And in that meeting, the speaker was, let's say, a bishop of the Catholic Church. All those religious meeting is under the aegis of the Catholic religion. Then came two unruly members of the Special Action Force. And when they hear the bishop speaking, and part of the speech is pertaining to advising the faithfuls not to indulge in excessive drinking, upon being heard by the sub forefront, they began angry. They fired their gun and thereby dispersed the said religious meeting. What is the crime committed by the two? The Special Action Force PNP? Will it belong to the crime punished by Article 131? Will it belong to the crime against religious worship, interruption of religious worship? Now, you should know the differences or difference between Article 131 and 132. In Article 131, it must be a peaceful meeting that is not a religious worship or religious manifestation. Is a religious rally or a religious meeting a religious worship? Now, it has been heard, it is not. What is this religious ceremony or religious manifestation? These are the traditional rites or ceremony of a particular religion. Especially Catholics, marami silang religious right. It is being recognized and acknowledged and being protected. Like for instance, the saying of Mass, the procession in honor of the different saints during fiestas. If any of this occasion, which is considered religious ceremony or religious manifestation, is interrupted, stopped by any public officer, then that public officer is guilty under Article 132. But since a religious meeting or a religious body is not a religious ceremony, then those two members of the Special Action Force of the PNP shall be guilty of violating Article 131. It will only constitute interruption or dissolution of a peaceful meeting. Now, with respect to Article 133, the offender, there is any person who shall perform an act which is notoriously offensive to the feeling of the faithful, whether it be during a religious ceremony or in a place that is devoted to religious worship. So there are two things to be considered. If a person, an offender, performs an act that is notoriously offensive inside churches. Churches and chapels are places that are devoted to religious worship. Even if there is no religious ceremony actually going on, as long as the act is committed inside those places which will offend the feelings of the religious, and the act is considered notoriously offensive, then that offender shall be guilty of a crime against religious worship under Article 133. Example, here is a person who appears to be tipsy. He went inside the Quiapo church. You know, there were several icons lined up. Accidentally, he lost his balance. He said, hit the protruding toe of one of the icons. Nasugatan siya dito. Nagalit siya. Sinay pa mo ako, babalikan ko mamaya. After 1 hour, bumalik siya, may hawak ng pamano. Dahil ito, walang visa to. Pinokpok niya yung icon. Aba, hindi nabasa. Ngayon, ano ang crime na nakamit niya? Hindi naman pwedeng physical injury dahil hindi naman buwan. Hindi yung karaniwang malicious mischief. Kung nasa labas yun, kahit na nasa labas yun, halimbawa, at may nakakitang religious, members of the religious, baka dito rin babagsak yan sa Article 133. Pero ito yung nangyari doon sa loob ng simbahan. So, the crime is an act performed or committed inside the church, and the act is notoriously offensive to the feelings of the faithful. Then he will be charged and prosecuted for violating Article 133. But if it is outside of the church, and there is, let's say, mass, and you know, in some places where there are no churches or chapels, and there is, for instance, Barrio Fiesta, those group of elders who are Catholics will organize that a religious ceremony, that mass will be held. They will invite a priest from the town proper. So there is now a mass. There is no church. Now during at the height of the ceremony, two persons who probably doesn't want the homily being said by the officiating priest, pinukol nila ng bato yung pare. Tinamaan yung pare. Nagkaroon ngayon ng bukol sa ulo. Yung mga tao na yon by being dispersed. Now, what is the crime committed by that person? Then it will fall under Article 133 because there is ceremony. He performs an act that is notoriously offensive. Hindi ba offensive sa mga member ng katot? Pupulin ng bato, tinamaan sa ulo ng kanilang parit. So that is notoriously offensive. The crime is violation of Article 133, offending the religious feelings. Kung halimbawa mahal na araw, ano ang religious ceremony na madalas nating maobserbahan? Pabasa ng pasyon. Now, there was a case decided by the Court of Appeals. In the chapel, there was a pabasa of the passion. Then a group of persons began erecting tents to encircle the chapel where the singing of the passion was being held. So these elders was offended or were offended by that act. Pinahuli nila yung mga tao. E dinimanda nila ng violation of Article 133. Convicted. So they appealed to the Court of Appeals. And on appeal, they were acquitted. Ayun, they were acquitted of the violation of Article 133, but nonetheless, they were convicted under the provision of Article 287 for unjust vexation. To become an act notoriously offensive, that act must be addressed to the dogma of the religion. But when it is only incidental that they created noise, because erecting tents is not directed against the dogma of any church or religion, but it is offending. It causes vexation, irritation, or annoyance to those persons. So this is, the appellate court said, if ever the accused are guilty, it is for the crime of unjust vexation and not for violating Article 133. Alright, we are now in a very crucial insofar as it's concerned these crimes against public order. Ano ba mga popular na crime ngayon? Rebellion, sedition, codita? O wala na? Hindi, meron pa. Dahil meron pa tayong mga brother Muslims who are engaged in the NPA, also are engaged in rebellion. Okay. Let's go now to Article 134. Rebellion or insurrection. You know, some authorities say that insurrection no longer exists. At kanilang legal basis, under the 1987 Constitution, unlike the previous Constitution of the Philippines, that word insurrection had been eliminated. What remains now in the Constitution is only the word rebellion and no longer insurrection. Kaya wala naman makikita ngayong mga charges before against a certain person charging them of insurrection. Lahat ang nakalagay na charge for rebellion. Walang insurrection. Now, how is the crime of rebellion? And what is the nature of the crime of rebellion? Is this a crime against national security? The answer is no. Because the crime against national security, yung kinuha natin, yung didiscuss natin kanina sa Title 1. Etong rebellion is crimes against public order. A crime against public order belonging to Title 3 of the revised penal code. All crimes against national security belongs to Title 1, not belonging to Title 3. Now, rebellion is committed by rising publicly and taking arms against the government for the purpose of removing from the allegiance to the government of the Philippines or its laws, the Philippine territory or any of its part, or any land, naval, or other armed forces, or to deprive the chief executive or the legislature of their powers and prerogatives. So there are two specified purposes in rebellion. That of removing the allegiance from the government of the Republic of the Philippines or its laws. The Philippine territory or any part thereof, of any land, naval, or other armed forces. And number two is to deprive the President, who is the Chief Executive, or Congress, the legislature, of their powers and prerogatives. But ultimately, you could say that the main and ultimate goal of the rebels is to overthrow the existing government in order that they could establish a government of their own. That is the ultimate goal of the rebels. Suppose 100 people they arm themselves and rise publicly, and they went to the Supreme Court and take over the powers of the Supreme Court. What is the crime committed? Is it rebellion? All right. Strictly speaking, you will consult the definition. What does it say with respect to the powers of the government? Only two branches of the government. It is the Chief Executive and the Legislature. Does it mention the judiciary? There is none. Now, what is the crime committed by those 100 persons who are armed and then prevented the Supreme Court from performing their duty? Then it will fall under the crime of sedition under Article 139. The offender rise publicly and tumultuously for the purpose of preventing the public officer from the execution or performance of their function or duty. That would be the crime. It will not become rebellion because there are only two departments of the government. If their functions are deprived by the rebel, the crime is rebellion. Now, our crimes committed by the rebels, and which are murder, homicide, robbery, theft, rape, while they are engaged in rebellion, could they be prosecuted for a complex crime of rebellion with murder and homicide? Or shall they be prosecuted for separate crimes of rebellion and separate crimes for all those private crimes that they have committed? Now, it has been ruled, and it is still fresh in your mind, the case of People versus Caamato Hernandez and the case of Enrile versus Judge Salazar of the RTC of Quezon City, where the Supreme Court reiterated that common crimes committed on the occasion of rebellion shall be considered absurd if they are committed in furtherance of rebellion. But if there is no political motive that could be proven why these common crimes are committed by the rebels, then there shall be rebellion as one charge and as many counts as of murder as there are people killed independently of the charge of rebellion. It is only when those killings were motivated politically where it could be considered that those common crimes are committed in furtherance of rebellion. Kahit na 1,000 pang tao ang pinatay ng mga rebels, the same crime of rebellion is committed. There is only one penalty. But if the rebels kill people because of personal revenge and hatred, which could not be connected to the political motivation, then this killing shall be considered as separate crimes from rebellion, as many count of murder or homicide. But about the crime of robbery or theft committed by the rebels, the same principle. If the purpose of the rebel in robbing the people and the government of their money is to use the money for the procurement of their goods and armaments, then that crime of robbery and theft are considered absurd. But if their purpose in robbing and stealing property and money of the people, including the government, is to pattern their own personal pocket, to send their children to the exclusive schools, buy cars for their children while schooling, that will not be considered absurd in the crime of rebellion because it is not politically motivated. But personally motivated. Rape could in no way be considered absurd because there is no political color that could be ascribed in rape. Meron ba nanalo laban sa gobyerno ng mga rebelde kung ang kanilang gagamitin lang ay mang-rape ng mga babae? Wala. Lalo lang silang manghihina. Wala silang karapatang malalo. So, it has been here. This crime of rape is motivated by the personal lust, the bestial instinct of man, never connected to the political motivation in the crime of rebellion. So, rape is always a separate crime from rebellion, if committed by the rebel. Now, there is one special law that is mentioned by here in your syllabus. PD 1866 as amended by Republic Act 8294. This is the law regulating ownership, possession of firearms. Now remember the case of People versus Silino Sr. It was clearly explained by the Supreme Court that if the crime committed by the offender is with the use of unlicensed firearm, and the crime committed is, number one, murder or homicide, or when it comes to rebellion, sedition, and attempt to commit codita. 5 lang yun. 5. Doon sa unang crime na dalawa, murder or homicide, don't forget that the use of unlicensed firearm is only a special aggravating circumstance. The unlicensed firearm shall not be subject of separate prosecution. It is either homicide or murder only. But once that firearm is alleged in the information for murder or homicide and proven to have been used in the killing, that will only be considered as a special aggravating circumstance. If it is a special aggravating circumstance, it could not be offset by any ordinary mitigating circumstance. But with respect to the other crimes, I also included in my enumeration per the provision of law. Rebellion, sedition, and attempt to commit codita. If firearms are used, then it is considered absurd and could not even be considered as aggravating circumstance. But with respect to other crimes outside of the fight and illegal possession, unlicensed firearm is used in committing them, then that is where the Supreme Court expressly provided the procedure, like robbery, kidnapping with the use of unlicensed firearm. And this kind of crime, because they are not included on those 5 expressly enumerated by the law, 2 informations must be filed in court. One for kidnapping or robbery, as the case may be, or any other crime outside of those 5. And the other information for illegal possession of unlicensed firearm. Does it mean that they shall be convicted of both crimes? It depends. If, for instance, in the crime of robbery, and the unlicensed firearm is also alleged in the information, once the accused is convicted of robbery with the use of that unlicensed firearm, then that other information for illegal possession of unlicensed firearm will be dismissed. It shall no longer be prosecuted. For what reason? Because under the provision of Republic Act 8294, a person may only be convicted of simple illegal possession of unlicensed firearm if such firearm has not been used to commit another crime. If it has not been used to commit another crime. It is like this. If a person has a gun, unlicensed, he was walking in the busy street, he was noticed by the police because he has a firearm tucked on his waist. So he was confronted. He was asked, meron ka ba diyang baril? May lisensya ka ba? Wala siyang maipakita. So in that situation, if he is charged for illegal possession of unlicensed firearm, he will be convicted. Why? because definitely there is no crime in which the unlicensed firearm was used. Pero dito sa explanation ko, based on the case of Siligo Sr., decided in 2007, if in the information for robbery, the accused was acquitted. And since the charge was dismissed, there was acquittal, it was not proven that the gun had been used to commit a crime. So the information for illegal possession of unlicensed firearm will now proceed and be successfully concluded that will result to his conviction because the gun or the firearm is proven to have not been used to commit another crime. Assuming that the accused was convicted of robbery, but it was proven likewise that the unlicensed firearm was not used in any way in committing the robbery, then this information for illegal possession of unlicensed firearm shall also proceed because the gun, the unlicensed firearm, is not proven to have been used in committing another crime. That is the explanation of the Supreme Court in the case of People versus Siligo Sr., decided in 2007. Ngayon, merong maganda akong i-advise sa inyo pag may mga baril kayo na wala lisensya. Mapapansin kayo ng pulis nagkalakad. Tapos nakabukol. Kahit na kayo may t-shirt o may jacket, napansin. Oy Brad, meron kaya tang barila. Tumalikod ka. Bunutin mo yung baril mo, iputok mo sa taas. Commit alarm scandal. Kuhulihin ka ng pulis. Ngayon, ano sabi ng you could not be punished for illegal possession of unlicensed firearm if that gun had been used to commit another crime. Eh, ginamit ninyo ng pag-commit ng alarm scandal, which is punishable only by arrest of minor. Absurd na yun doon. Magkas kayo, ano ba ang penalty under the new law? Kapag ka ang baril na nahuli ay wala lisensya. Caliber 38 and below has a penalty of 6 pressure correctional in its medium in the maximum period. If it is caliber about 38, kahit kasama na yung basuka at kanyon, basta nagdadala ng tao, ang penalty, arrest pression mayor in its minimum period. Meaning, 6 years and 1 day to 8 years. Yun ang pinakamataas na penalty ngayon sa illegal possession of unlicensed firearm. O ngayon, kahit na caliber Armalite rifle ang ginamit ninyo, paputukin nyo sa taas, may alarming scandal. Wag lang tatama sa ipaha. Dahil sa pagtutuma, delikado. O, kita nyo, didemand naman kayo pareho. Siyempre, over dito ng Siligo Sr. Didimanda pareho. Ano ba ang ginamit sa alarming scandal? Baril. O, kung baril, guilty ka na alarming scandal. Magmumag ka na ng discussion ngayon sa illegal possession of unlicensed firearm. Your Honor, I could no longer be convicted of illegal possession of unlicensed firearm because that firearm had been used to commit the crime of alarming scandal. Ganyan ang batas. Ganyan ang batas. So, understood, klaro na yan. Kaya wag na kayong matakot na baka mahuli kayo. Kaya lang, pagka kayo puputok sa taas, huwag mong pakikita sa polis. Kasi pag gulat pa lang, baka kalay paparilin mo siya, paparilin na kanya, di ba? Uunahin ka na. Huwag mong papakita. Okay, we will continue this afternoon at 2 o'clock. Order issued by the court between the institution of the action and before finality of judgment. All orders in between the two shall be deemed as interlocutory order. Now, what is the test whether the order is interlocutory? Now, if in between the start of the action and before finality of judgment, the judge issues an order, the test is, upon issuance of the order, is there something more to be done by the judge on the case? If the answer is there remains something to be done, then the order is interlocutory. Otherwise, the order shall be considered a final order, not a mere interlocutory order. Article 207, by the caption alone of the article, you could already see to be liable under that. The judge must have deliberately caused or intention of causing injustice, because it says malicious delay in the administration of justice. Many judges have been charged before the Supreme Court under this provision, but very seldom, if ever, does a judge become liable, especially so, considering that if the delay is caused by several factors, like for instance, the repeated postponement of parties, absence of judge because he became ill, or his incontinence, or the judge when have retired. So another judge should be appointed to continue the proceeding. Now, the delay, there could yet be considered as malicious delay. Now, if there is no malicious delay, but the case remain pending for quite a long time, can the judge be held liable, criminally liable? Yes, but not under the provision of Article 207. In the absence of any malice, that judge could not be held liable under Article 207. But he may be charged under the provision of the Anti-Graft Incorrupt Practices Law under Public Act 3019 by causing undue injury upon any person by reason of inexcusable negligence. That would be, but not under Article 207 because it requires the element of deliberate intent to cause injustice to any party to the cause, to the action. Now, under Article 208, this pertains to the so-called dereliction of duty of public officers or officers of the law. You read the provision, there are two kinds of officers that are mentioned there. Public officer or officer of the law. Certainly, they do not mean one and the same. Otherwise, the provision could have just started by saying any public officer. Now, who are these officers? Public officers. They are public officers up to the level of prosecutors or fiscal because they have the duty to institute criminal action in court. What about those officers of the law? These are members of the law enforcement agencies who will arrest criminals and then file the complaint, deliver the detained person from the arrested to the proper judicial authority. The filing of the complaint is a duty of the police officer under the provision of Article 125 of the revised penal code. Otherwise, they open themselves to prosecution for arbitrary detention. Now, how is the violation committed? Under the provision of Article 208, the so-called prevarication, or the rejection of duty of those public officers mentioned already. That is by maliciously failing to prosecute the offender or maliciously tolerating the commission of a crime. If the prosecutor, despite the overwhelming evidence supporting probable cause to file the case against the respondent, but the fiscal instead fails to file and institute the information in court, then he may be guilty under that provision of law. In the case of a policeman, assuming there is an order from the President of the Philippines through the Secretary of Local Government to start and stamp all forms of illegal gambling, particularly betting, in the respective jurisdiction. then the order stated that it must be immediately implemented. So here is Barangay Chairman X. In his place, or in his barangay, there is an operation of betting. The operator is his compadre. So when the operator of the betting learned that the barangay chairman will now stop his operation, the operator went over to the office of the barangay captain and said, "Compadre, di ba? You have to give me about 2 months. Kaya na muna akong makapag-operate kahit na 2 weeks." Sabi niya. Sabi niya, meron ng order dito si Presidente. Sabi niya. Pero hindi na mapapansin niya. Anyway, sabi niya, makukusa ako na ihinto niyan after 2 weeks. Tandaan kita ka mo sa papel. So, the barangay chairman was persuaded. Now, what is the crime committed by the barangay chairman? Well, it is violation of Article 208. Being a public officer who has the duty to prosecute the offender, they maliciously tolerate the operation of illegal gambling. If, however, the barangay chairman was persuaded because when the operator of the betting illegal gambling in the case came to him, he said, "Compadre, ipagpatuloy ko na muna itong operation." Eh, hindi pwede yan eh. Nandito na yung utos ng Presidente, baka bak-inspection, nandiyan ka pa. Sabi niya gano'n, hindi naman siguro gagawin yun. Sabi niya, meron akong dala dito para sa iyo. Alright, 50,000 pesos for the 2-week extension. Sabi naman nung kapit, kung tingnan lang ba naman, itatakasunod tayo. Okay? Pinagpatuloy. Now, what is the crime committed by the barangay chairman? Will it be plain violation of Article 208? The answer is no more. Why? Because he refrained to perform the duty in connection with the performance of his official function in consideration of that bribe money. The crime now will fall under the third kind of direct bribery defined in Article 210, refraining to perform a duty which is required by law to be performed in consideration of a gift or present. There was bribe. But if there was no bribe money, and he allows the continuance of the operation, the crime would only fall under Article 208. That is malicious tolerance in the commission of the offense. The same is true with respect to chiefs of police or mayors, as the case may be. You know, this operation will not proliferate unless there is pressing from the local leaders or local executive. If the mayor and the chief of police are in cahoots with this gambling operator, then you could see that everywhere in the town there are people who are collecting bets in the betting operation. But if they are really strict, because there is a law to be implemented by these local officials and the police of the town, walang nag-ooperate yan. Walang nag-ooperate. I remember when I was a young lawyer, when Marco said, "No illegal gambling." Oo, lahat ng mga kolektor at saka lahat ng mga gambling operators, pinakulong ng mga provincial prosecutor, provincial director. Natakot sila. Hindi pa na nagbibiro nung i-implement yung package of illegal gambling operation. Pero ngayon, para kang sasalita sa bingit. Yung governor magkakaroon ng publication doon sa piece of announcement. In my province, completely, there is no illegal operation. Pero pumunta ka naman doon, lahat ng bayan, mayroon nangungulekta ng bet sa betting. So ito ako nito play of box lang ito. There is really no will to implement this law on illegal gambling. But we are talking about the law itself. As a student, Sabihin niyo batas lang. Do not say walang batas. Baka kayo mabisgrasya sa bar examination. And then, discuss a betrayal of trust of attorney or solicitor. Eliminate the word solicitor under Article 209. We don't have any solicitor at present. The solicitor there does not refer to any lawyer belonging to the office of the Solicitor General. Solicitor there refer to persons who have no formal knowledge of law before, but is allowed by court to appeal in the proceedings before the court. They are the persons referred to as solicitor. But that is not allowed anymore. So only attorneys, those who are full-fledged members of the Philippine Bar. Now, what are the punishable acts covered by betrayal of trust? There are three. The first one is by causing damage to the client through malicious breach of professional duty or inexcusable negligence. Example of this is, for instance, this is a client. Ejected ka ng kaso, hinawakan ni abogado. Kaya napanalo yung may-ari ng bahay na plaintiff dahil hindi nagbabayad for 1 year na yung tenant. May talo pa ba yun? Ang first round, natalo yung plaintiff dahil sa kapabayaan ng abogado. Hindi pa siya nag-appeal within the period of perfecting an appeal. So that is damage caused because of the malicious breach of professional duty or gross inexcusable negligence. The lawyer could be held liable under the first act punishable under Article 209. The second is revealing the secret learned by the lawyer from his client in his professional capacity. This is also a breach of the lawyer's ethics. But you have to analyze and know how this will apply. It will apply only if the secret he learned is pertaining to the case he is actually handling. Like for instance, here is a case of murder. The lawyer, Attorney X, is very brilliant, and so he made a nice defense, and the accused himself was made to believe that he would really receive acquittal from the court. And so the lawyer, the accused, one afternoon, confided to his defense counsel, Attorney X. You know, Attorney, malakas ang kutob ko na makaka-acquit tayo dito. Ang galing-galing mo, abogado, sabi niya naman. Pati ako, kumbinsido sa mga argumento mo. Ngayon, oras na ako'y maka-acquit dito, ang susunod kong patalin ay yung kapatid ng biktima dito sa kaso nito. Huwag mong pagsasabi sa idea na ito, tayo ang dalawa. Alright. Question. Suppose the counsel reveals that secret confided to him by his client. Could that violate or could that be considered violation of the provision of Article 209? Will he be made liable for that second act covered by the provision? The answer is no. Why? Because this refers to a future case, not the case that he is actually handling. Besides, he is an officer of the law. He has the duty to cause the prevention of the commission of this crime, which his client is planning to commit. He could report that to the police and say, bantayan nyo kahit kung kliyente ko, masama ang iniisip ito. Oras na maka-acquit ito, meron ka magsusunod na patayin. That will not constitute violation. Pero kapag yung kanyang revelation is secret, that has direct connection with the case the lawyer is handling, that is where this violation is committed. But never it pertains to future case, or even if it is a current case, it is not the lawyer who is handling the case. That is how this second act should be understood. And the third one is, of course, maraming nangyayari ito. Pati kung pa-practice ako, nangyari sa akin, pero hindi naman ako nadimanda kasi alam ko yung paragraph na yun. What is prohibited there in the Municipal? If the lawyer handles the case of the opposite party, the adverse party, without the consent of his client, after he had received or learned matters of confidence from that first client, to become free from any liability under that article, par and in the third act, if ever he wants to change loyalty, as the formal permission or consent of his first client. If the first client gives him the consignment, then go. There is no violation of the law, at least under the provision of Article 209. But if there is none, and then the lawyer changed loyalty at the battle of the game, oh my God, the first client would certainly run after him. By the case of damages, but most importantly, violation of Article 209 for the trial of trust of an attorney. That would be the result that would solve that problem. So that is the trial of trust. Now, interesting article from Article 210 up to Article 312 in the meanwhile. This pertains about those who are guilty of bribery and those who will be guilty of corruption of public officials. The one who gives bribe is not the one guilty of bribery. It is always that officer who receives bribe who shall be guilty of bribery. But the offerer or giver of bribe shall be guilty under Article 212. The crime is corruption of public officials. Under Article 210, there are three ways by which the crime of direct bribery may be committed. One is by agreeing to perform or by performing an act that constitutes a crime in connection with the performance of his official function in consideration of a present gift or promise. Here, the mere agreement to commit that act which constitutes a crime for a consideration, but it is in relation to the performance of his official function, makes him already guilty of consummated direct bribery of the first kind. Now, suppose he commits that act. He did not merely agree. He actually performed that act which constitutes a crime. What will be the crimes for which this public officer shall be prosecuted? This time, there are two crimes now for which the officer shall be prosecuted, because under that first paragraph of Article 210, in addition to the liability for that act which he had performed, the penalty under that provision shall be imposed, which is prisoner. So it speaks of two distinct penalties. Therefore, there could be no complex crime here, because in complex crime, there is only one penalty. The law specifically says so, but there shall be two penalties. And what are the crimes? Assuming that the first act, let's say, let's correlate it with Article 204. The person to whom the bribe was offered in consideration of rendering a decision that is contrary to law or not supported by evidence is the judge, who is handling the case for the case where the offerer of bribe is interested or is a particular in. Sabi noong nag-offer ng bribe, judge, maawa ka naman sa akin. Alam ko na may balita akong makakakwit dahil may nakaw at ibigay sa ng kaso sa pag-offer sa akin. Pero Judge, maawa ka na. Sabi, ay, hindi ko magagawa yan. Malinis ang conscience ako. Bigyan ng nilabas yung maleta. May kalahating milyon pala. Sabi na, ano yan? Para kanina yan. That's para sa yan. Pag binigit mo na ako, pagkabinat bigyan na ako, mag-desisyon ka pa sa akin. Malakas ang ebidensya. Nakita niya may kalahating milyon, malakas na agad ang ebidensya. Binisay niya, contrary to law. At no evidence to support the conviction or acquittal, reason, or any result that is favorable to the one giving the right. What happened? What crime shall the judge be considered guilty? There are two crimes now. One, knowingly rendering unjust judgment, violation of Article 204. But because he accepts bribe, and the act he has committed is in violation of law, if he constitutes a crime, he shall then be guilty and of direct bribery under the first form of direct bribery as covered by Article 210. That is how the first form. Yung isa by agreeing, isa lang ang penalty rule. When he agrees to commit an act that constitutes a crime in consideration of the crime, and such act was performed in relation to the performance of his official function, that mere agreement of his makes the crime of direct bribery consummated. But since he did not perform the act, then there is only one penalty. But the moment he performs that act, which is a crime, then aside from that crime that he has committed, accepting bribe, that is direct bribery, he shall also be penalized for the crime he had committed. If it is falsification, falsification. If it is knowingly rendering an unjust judgment, then that is another crime for which he shall be penalized. Now the second paragraph, it is by accepting a debt by the public officer, and that in consideration of an act that does not constitute a crime. So, in the first form, the act which he will agree to perform or will perform constitute a crime. But in the second form, it does not constitute a crime. The act that he will perform does not constitute a crime. But the act must be unjust. Yun ang sinasabi sa inyong mga memory aid at sa mga elements ng crime sa mga libro. Nakalagay doon, the act is unjust, but the act does not constitute right, but it is an unjust act. Laging tinatagdag nila yung kulatiyan. It is an unjust act, but it does not constitute a crime. What is the consideration? He accepts it. Suppose he accepts promise for the act that does not constitute a crime. Where the acceptance by the public officer for that act that does not constitute a crime makes him criminally liable under the second time of direct bribery, the answer is no. Because if the purpose of the law is if he accepts present promise or gift for an act that constitutes a crime, he will be guilty of direct bribery, then the law would have said so. But that second paragraph merely mentions accepting gift. In the case, a different name than the consideration in the first form of direct bribery. What is gift? It is a tangible thing. Something that everyone could lay hand on, like this microphone, this bottle. Pag sinabing promise, nako, bawal, marumi, baka magkasakit pa. Hindi na tanggapin yun. Kinakailangan pera, kinakailangan jewelry, kinakailangan kotse. That is the form of gift that must be accepted by the public officer in consideration of that act that does not constitute crime but is unjust. Make promise, and if it is accepted by the public officer, that is not a gift under the concept of the law. He does not commit any crime of direct bribery. Example of this, actual case, the case of People versus Mariposte. decided sometimes in 2005 or 2006. Mariposte was a sergeant of the police in the Legazpi City. He participated in the surveillance of suspected robbers who was the author of robbery in a business establishment owned by a Chinese businessman. The Chinese businessman lost many items, including several tons of shilling. So, through the efforts of Mariposte's men, they were able to trace the whereabouts, not all of the loot in the robbery, but the tanks, the shilling tanks, which are still full. They were able to find where these tanks were stored by the robbers. But the robbers were not arrested. So Mariposte reported dito ni Ami. Sabi niya, Sir, na-recover na po namin. Nalaman na po namin kung nasa saan yung mga shilling gas tank na nanakaw sa inyo. But, teka muna, saan yun? Ba't hindi niyo deliver sa akin? Kasi po, sabi ng mga bata ko, kinakailangan ko, magbigay kayo ng 40 boys muna dahil nahirapan sila. Anong 40 boys yan? Ako na nga itong nanakawan, ako pa magbibigay sa inyo. Pero yun po ang kalakaran. So, this Chinaman pretended that he will think over whether he will give what is called as 40 boys. So, bumalik ka na lang dito, mag-usap ulit tayo. Unknown to Sergeant Mariposte, the Chinese businessman complained to the captain of the police in the headquarters of the Legazpi Police Department and revealed this demand of Sergeant Mariposte. So this angered and infuriated the captain of the police. So said, all right, you pretend to have agreed giving the money. Kunyari, tumawad ka muna ng konti. Tapos, mag-agree ka na. At sabihin mo, bumalik sa ganung araw. Magpaplano kami ng entrapment. So, the appointed date came where Mariposte was now to deliver this gas tank, shilling gas tank. And in return, he will receive the money for the boys. When the money was already received, the policemen who were already around part of that entrapment operation approached them and placed Mariposte and his men under arrest. Mariposte was charged of direct bribery before the RPC because it was an under-arrest case. Section 7 of Rule 112 was observed. He did not ask for preliminary investigation, so the proper information was filed in court. There was trial. Mariposte's explanation is that he was not the one who was asking the money, but it was one of his men. But the court did not believe that. So a judgment of conviction was handed down, convicting Mariposte of direct bribery of the second time, accepting it in consideration of act that does not conflict with life. Is that correct? The answer is yes. The return of the stolen articles is not an act that constitutes a crime. But it became unjust because he is still demanding consideration for the return of it. So the Supreme Court sustained the conviction for direct bribery of the second time, accepting it in consideration of an act that does not constitute a crime. But the act is unjust. That is a concrete example of the second form of direct assault, case of people versus Mariposte. Now the third form of direct bribery is the last, appearing in the last portion of Article 210. That is, by agreeing to refrain or refraining to perform the duty required of him to do in consideration of gift or present in relation to the performance of his official function. So there is a duty for him to do certain act. But he omitted to do such act. He fails to do that act which is required of him to do as part of the performance of his official function. But there is a consideration. The consideration is gift or present. And he accepts the same. By mere agreeing, according to the provision, will make him already liable. Now, if he does not have, if there was no consideration, then his crime would fall under Article 208. That will be dereliction of duty, or the so-called prevarication in Spanish. So all those that are covered by Article 210 are simple direct bribery, because there is the so-called qualified bribery. What is qualified bribery? Then Article 211-A says, any public officer entrusted with law enforcement who shall pay to arrest or prosecute an offender who has committed a crime where the penalty for the crime is reclusion perpetua in perpetua, in consideration of some promise, reward, or present. So here, there is a particular public officer who could be guilty of qualified bribery. Whereas in the simple direct bribery, in all the three forms, any public officer may commit the crime. Here, only those charged with law enforcement. And what are they? They are members of the law enforcement agencies of the government. In the bar examination of last year, there was a selection type question. Who among the following is guilty of qualified bribery? RTC judge, chief of police, fiscal, mayor. Yung mayor, dinagdag ko na lang, tatatlo lang yung pinamilihan doon. Ginawa ko na lang na ABC para kunyari multiple choice question. A, B, C, D. Ang A, judge. B, prosecutor. C, chief of police. And D, municipal mayor. Who shall be liable? Of course, letter C, the chief of police. Because he is a public officer entrusted with law enforcement. My students and all those juries who heard my lecture would always be happy. And I know that they have gotten the correct answer. Because as my student, I have already hammered out their head the distinction between simple bribery and qualified bribery. And same thing that I'm doing now for you, emphasizing when is the bribery simple, when is it qualified bribery. So you must understand that in qualified bribery, there is only one particular set of public officers who could be offended. That is, those public officers entrusted with law enforcement. And that public officer charged with law enforcement paid to arrest or prosecute an offender who had committed a crime where the penalty of that crime is either reclusion perpetua and mortem. And the failure to arrest and prosecute is because of consideration of price, reward, gift, present, or promise. Now, if it is the public officer who demanded for that consideration, according to the last portion of Article 211, the penalty is death. But the public officer should be thankful because he could no longer be meted the penalty of death if ever he is convicted, even if he was the one who demanded that bribe or present or in consideration of that act of not arresting and prosecuting an offender who has committed a crime where the penalty is reclusion perpetua or death or reclusion perpetua and of death. Now, if it is not the officer who has demanded the event, the bribe money, what is the penalty? Then whatever is the penalty imposed upon that person whom he paid to prosecute, the same penalty shall be imposed upon the public officer. By way of illustration, suppose a person murders, ex-murdered wife. It was committed in the presence of the police officer. The police officer, when he confronted and accosted the killer, he was offered bribe. He received 10,000 pesos. Sabi niya, Chief, kaya mo na yung ibang mga kasama nung makakaisto sa akin, ako na lang para tatakasin mo na ako. So, in consideration of 10,000 pesos, demand, escape. That is the crime committed by the police. Now, remember, there is no penalty mentioned there. But remembering Article 248, the moment matter is mentioned, the law says, the penalty of reclusion perpetua to death shall be imposed upon any person who shall kill another by means of the following qualifying circumstances. So the word murder alone connotes that the penalty is reclusion perpetua to death. So the crime committed by the police officer who paid to arrest and prosecute that offender is qualified bribery. Suppose the question is X commits homicide in the presence of the police. The police arrested X, but because he was given bribe money of 20,000 pesos, X was allowed to escape, and the police did not prosecute him. What is the crime committed by the police? Then it is only simple bribery. Why simple bribery? Because the crime of homicide is penalized only according to Article 149 with the penalty of reclusion temporal, not reclusion perpetua or death. So, the crime committed by the policeman, although he is entrusted with law enforcement, is under Article 210. Training to perform the duty required of him to do. What is the duty required of him? To arrest the criminal. But he refrained to arrest him. Why? In consideration of that bribe which he received. But since the penalty for the crime is not reclusion perpetua and for that, it is only simple bribery. But if it is murder, it is qualified bribery under Article 211. Another one is, if for instance, the crime committed is selling of any dangerous drug, and the policeman has arrested him in flagrante delicto, but the policeman allows him to escape when he received certain consideration of amount of money. What is the crime committed by the police? Then you should remember the provision of Section 5 of the Dangerous Drugs Act. If it is selling, whatever is the quantity, the smallest up to the highest, the law says the penalty of life imprisonment or death shall be imposed upon those who shall sell, transport, or give away any dangerous drug. Since that is the penalty, necessarily the act of that policeman constitute qualified bribery, because the crime of illegal selling is penalized with a penalty of life imprisonment to death. But if what was done by the person whom the police arrested is only possession of drugs paraphernalia, So he was caught with the instrument and paraphernalia used for sneaking or using any dangerous drug. Alright, the man who was arrested offered him bribe money. The policeman allowed him to escape. What is the crime committed by the policeman? Of course, it is not qualified bribery because the penalty for mere possession of any drugs paraphernalia according to Section 12 of Republic Act 9165 is only a maximum of 4 years. So it falls under the provision of Article 210, that is simple bribery, not qualified bribery. So I think that is already an exhaustive explanation of what is qualified bribery. Now, Article 211, the crime of indirect bribery. It is committed by any public officer who shall receive or accept gift in consideration of his public office. Now, what is the difference between indirect bribery and direct bribery? In direct bribery, there is always a consideration. But in indirect bribery, there is no consideration except that he is holding that public position. And that is the main consideration. The one who gives the bribe money to him has no pending case before him. Like for instance, during birthday celebration of the judge, a rich businessman in Chinoy came over and said, "Judge, because I love you as a friend, I have now a very precious gift to you. This is the gift of a brand new car I bought for you as your birthday gift today." So the judge was very happy. Anong kulay yan? Baka ayaw ko, hindi ko natanggapin yan. Alam ko ang paborito mong kulay. At saka alam ko ang brand na gusto mo. BMW. Training ring. Nako, galing naman yan. Thank you, my friend. Tinanggap niya. What crime was committed by the judge? It is indirect bribery under the provision of Article 211. Pero kung halimbawa nagpunta niyan, "Judge, mahal na mahal kita. Yung iyong ballpen dyan, halos wala nang tinta. Ibili na kita ng isang set na pen at saka fountain pen. Tapon mo na yung lumang ballpen na ginagamit ko yan." Tinanggap. Birthday naman yan. Wala namang kaso yung tao. Will that be considered? Now, there is an exception to it. If the gift given is only the traditional gift during occasion, and it is not of costly, then it will only be considered as a simple gift, which will not make the judge guilty of indirect bribery. Eh kung halimbawa naman na riswat, "Judge, mangit lang itong aking regalo sa iyo, pagpasensyahan mo na. Kalahating milyon lang ang bili ko dyan." Ayun ba, ordinary gift yun? Hindi siya. Guilty na rin yung judge doon. The only reason why he's given that precious gift is because of his public position as the judge. Now suppose, ang sabi noong nagbigay na sinuan, "Judge, dahil mahal na mahal kita bilang kaibigan, meron akong gift sa'yo. Pinapangako ko sa'yo na sa susunod na taon, first day of January, tatanggapin mo yung paborito mong car, BMW brand new, color flaming red." Naku, salamat, tinatanggap ko ang promise mo. Nadinig ng halimbawa, si ITG o ng NPA agents, pinaristo si Judge, guilty ka ng indirect bribery. Tumanggap ka ng bribe. Nasaan yung bribe ko na tinanggap? Meron ba? Wala, yung promise, hindi ba gito? No, hindi ka pala nag-aral lang ito eh. Hindi mo alam yung gift na sinasabi yan sa Article 211. Meron ba sinabi dyan na promise? Wala, gift lang ang nakalagay dyan. So the concept of gift done is the same as the concept of gift in the second form of direct bribery. It must be a tangible thing. Something that could be held by anyone, but not laway, not promise. Kasi yung laway baka yun yung magkasakit pa siya. Hindi tatanggapin ang action. Pero kung naghintay yung humuli, first day ng January next year, and diniliver doon sa judge, tinanggap ni judge, huling-huli siya. That is violation of Article 211. The crime would be indirect bribery. But never at the time when he accepted the promise, because it does not conform with the language of Article 211 that the judge must receive in consideration of his office, public office, shall be tangible thing, a gift that is tangible thing. Then, corruption of public wealth. By the way, with respect to direct bribery, whether qualified or simple, or indirect bribery, there is only one stage. It is always consummated, not prostrated, nor attended. But in the case of corruption of public official, under Article 211, the bribe offerer or the giver of bribe may be made guilty either in the attempted stage or consummated stage. No prostrated stage in the crime of corruption of public official. Having attempted corruption of official arise when, for instance, the offerer of bribe, he went to the public officer and said, "Judge, dahil mabait kayo, kahit wala akong asundo sa inyo, ito po, meron po akong regalo sa inyo." Ano yan? Ito po, isang relo. Pagdamutan na po nyo ito. Ito po, binili ko po sa 100,000 pesos, regalo ko sa inyo. Bakit po ako nire-regaluhan? Wala naman akong birthday. Eh, darating din naman ako birthday ninyo eh. Binunahan ko na. Hindi tinanggap ng judge. Tumawag nung kanyang polis doon sa labas, "Ay, hulihin mo ito." Binibigyan ako ng gift na ganito. Now, what is the crime committed by the offerer of bribe? It is attempted corruption of public official. Why? Because the public officer refused to be corrupted. He did not accept. Once the public officer accepted that offer and the gift that was given, then both of them shall be guilty of consummated direct bribery with respect to the officer and consummated corruption of public officials with respect to that giver of bribe. But once the public officer refused to be corrupted, he does not accept it. Then only one shall be held liable. Attempted corruption of public officials. Then we have fraud against the treasury. There are two paragraphs there. The first part, fraud committed by those public officers charged with the procurement of supplies, and two, by reason of their taking advantage of position, employ escrow in order to defraud the treasury. Ang madalas na nakakasuhan nito yung mga procurement officer. They entered into a contract with the supplier. Sabi, bibili ka tayo ng 100 units of laptop. Pero nakipagpuntsaba siya. 80% lang or 80 pieces lang ang diniliver. Pinalabas nila na tinanggap lahat. Yung 20, conversion, monetized. Pinaghapian nila. Then that is a crime falling under the first paragraph of Article 213. Yung second naman is about illegal exaction. The legal exaction, the law says, the offender there shall be those public officers charged with the collection of fees, taxes, dues. But remember, even if those are public officers charged with the collection of taxes, the personnel of the Bureau of Customs and Bureau of Internal Revenue are not punishable if it is violated, if that provision is violated. Where shall be, what is the law that governs them? Now, if the Internal Revenue Code or the Customs Code has similar provisions punishing illegal extraction, then they will be charged under those respective code. If there is none, then what will apply? The revised administrative code of the Philippines. Never the provision of Article 213, because you will find in the last portion of that article that personnel of the Bureau of Internal Revenue and Bureau of Customs are not covered by that provision of law. Now, what are these different acts of illegal extraction? By demanding an amount greater or any amount greater or different from that is to be collected. So the collector, for this public officer by way of example, the collection officers of the local government, those that are employed in the Permits Bureau, for instance, and in the national government, those revenue earning agencies like the LTO, the LTO collection agents, they are covered by that article because they are not personnel of the Bureau of Internal Revenue nor personnel of the Bureau of Customs. The second one is by voluntarily failing to issue official receipt for the tax they have collected. And number three is by accepting in lieu of what is required by law as payment, will receive anything of value, like if it is in the market, bigger, sir, wala pa kami ibang bayad ng tax. Kumuha na lang po kayo dyan ng 50 kilos of pork. One sack of rice. Kinuha yun ng collection agent. He commits it under that third act constituting illegal extraction. Because that is not the form of payment that must be accepted by tax collectors of the government. Now, under the first, the collector demands an amount higher because this collection agent of the municipality or city, for instance, is already known to the taxpayer. When the collector approached them or the businessman was approached, ay kabisi, magbayad ka na ng iyong tax. Dito sa tanda kong may assessment sa iyo, 100,000. Walang problema, bayad agad. Huwag mong i-issuehan ng cheque, cash mo na. Cash. Pero actually, yung assessment is only 50,000. So it was over the amount that is legally due for payment as tax by that businessman. Now, it was a Friday when he collected that amount. Lack of time, he did not bring it to the office for turnover to the cashier. The following day, there was a derby in the cafe nearby. Sabi niya, pwede na siguro ito muna gawing kapital, baka manalo pa. Ang ginawa niya, pinusta niya, pinusta. Noong una na nanalo, swapan, hindi pa nagkasya. Pero tumaya hanggang maubos yung 100,000 pesos na collection. Wala siyang pera pambayad. What is the crime committed by the collection agent of the government? First crime, of course, for demanding an amount greater than what that was supposed to be paid by the taxpayer. He commits illegal extraction under the first form. But did he commit any other crime? Yes. The 50% there, 50,000, belongs to the government. And what is the crime he committed? That is malversation of public fund. What about the 50,000 in excess? He merely held that interest for the real owner. He might misappropriate the same, then he is guilty of estafa. So those are the three crimes the collection agent has committed under that situation. They demanded an amount greater than the amount which was supposed to be paid as tax. but he misappropriated the amount collected. That pertaining to the government, the disbursement thereof for personal use constitute the crime of malversation under Article 217. And with respect to that 50% which does not belong to the government, but belongs to the taxpayer, it being merely held by the collector, and he appropriates the same, then that constitutes the crime of estafa. All right, further on these crimes committed by public officers. Let's go now to Article 217 in relation to the so-called illegal use of public funds, otherwise known as technical malversation, which is penalized under the provision of Article 220. Now, under the provision of Article 217, there are two modes of committing malversation. One is intentional malversation, and the other one is malversation through negligence, but the penalty is the same. The penalty is the same under the same provision, 270. How is it committed? Malversation of public funds or property is committed by any public officer who are accountable for public funds or property. Take note, he must be accountable, because not all officers are accountable for public funds or property. And then he appropriates, misappropriates, or takes away public funds or property, or through negligence or abandonment allows other person to commit those acts of malversation. So that negligence results to the malversation of public fund, and that is considered as the other form of malversation of public fund, malversation through negligence. But there are several rulings of the Supreme Court until recently that if the offender, a public officer who is accountable for public fund or property, is charged therein. But during the trial, what was proven only is malversation through negligence, because through the negligence of that person, other person was able to get those public funds or property and appropriate the same. According to the ruling of the Supreme Court, the accused could still be convicted under that original information without need for amending the same, because malversation through negligence is only the lesser mode of committing malversation of public funds. The penalty for the deliberate or intentional malversation and malversation for negligence is the same under the same provision of Article 270. Now, you will note that in the definition of the crime of malversation of public fund, it says that the offender shall be a public officer who is accountable for public funds or property. Now, may a private individual be held liable for malversation of public funds? And if so, in how many instances? A private individual may be guilty of malversation of public funds in the following instances. One, when he acted in conspiracy with that accountable public officer, or has acted as an accomplice of that public officer in the commission of that crime. Number two, when a private individual in any capacity is entrusted with national, provincial, or municipal funds, and he misappropriates the same funds. And next is when he is constituted either as administrator or depository of such property or money that is legally seized by public authority, even if those property or money belongs to private individual. So, with respect to the last instance, he is a private individual, but he is named an administrator or depository of property or money that was legally seized by a proper authority, like sheriff. Sheriff is a proper authority. He seized money or property on the strength of the writ of execution. If he entrusted what has been seized legally to a private individual who is constituted as depository or administrator, and this depository or administrator takes away, malverse or appropriate that money that was entrusted, then he is a private individual guilty of malversation of public funds. That is the provision under Article 222, where it made private individual guilty of that crime as if he were a public officer. Now, how do you differentiate malversation of public funds under Article 217 and the so-called technical malversation, which is that illegal use of public funds defined in Article 220? Now, there is also a public officer. He is assigned as administrator of a particular fund or property. But that particular fund or property has been appropriated by law or by ordinance for a specific public purpose. And that administrator, the public officer to whom the money is entrusted for his administration, use that fund or money for another public purpose different from that specific purpose for which the same was appropriated by law or ordinance. Let's say in the city of Manila, there was a strong typhoon which destroyed a school building in a certain barangay. But there was also a important bridge that was also destroyed by the current of the flood waters. Now the bridge was prepared to be funded by the city council. There was an appropriation of 10 million for the construction, for the reconstruction of that bridge that was damaged by the typhoon, earmarked for that specific public purpose. It is now entrusted to the mayor as the administrator, and who will be the supervisor of this project to be constructed with the use of that money appropriated by the ordinance. But then came the constituent in that place where that public school building was destroyed. It is a city elementary school. So they were also demanding and clamoring that the mayor also pause the construction of that public school building. But the mayor said, I could not provide you the money. There is no funding yet that is passed by to an ordinance for that purpose. But mayor, nalaman namin, meron pang natitirang 5 million dahil nararaan na naman yung tulay. Meron ka pang 5 million cash yan. Kahit na initial lang, para malagyan lang ng bubong, ipagawa ko na ito. Politiko si mayor. So sige na nga, saan yan hintay natin yung pera na ma-appropriate ng city government. Pinayagan niya magamit yung 5 million pesos for the initial reconstruction of the school. Yung kalaban niya sa politika, eto lang. Nako, si mayor nagmalverse ng pera. Dinimanda na ngayon sa ombudsman. Ngayon, with that act of the mayor, prosper, is there a violation of Article 220? Was there diversion of public funds for another purpose, which is the very act that is punishable under Article 220? Theoretically, yes. Why that fund have been appropriated for a specific public purpose? It is earmarked only for the construction of that bridge. But that money was later on diverted to another public use, which was not covered by the ordinance appropriating the same for that purpose. Hence, there was a violation of Article 220, for which the mayor shall be held liable. Now, what is the difference between technical malversation and malversation under Article 217? In technical malversation, there must always be a specific law or ordinance which is passed appropriating a particular fund or property and designating that fund for a specific public purpose. That is the first thing. Whereas, a malversation of public fund, it is a general fund. It is not appropriated for any specific purpose. Second, there is idea of gain in malversation of public fund under Article 217. Whereas in technical malversation, from the very wordings of the law, there is no idea of profit or gain because the money was merely used or diverted to another public purpose by the administrator of that public fund or property. That is the main distinction between malversation of public fund or property under Article 217 and the so-called technical malversation, which is defined and penalized under Article 220. Actually, the caption of Article 220 is illegal use of public fund, not technical malversation. Now, when is there a presumption that the public officer has committed malversation of public fund? When a competent authority demands for the production of that public fund, like those representative of COA. If he could not produce it on the spot, then there is now a presumption that he personally used the fund for his own benefit. However, if the public officer was able to present that afterwards immediately, then there is no such presumption that could arise that he has murdered. But if there is no reimbursement of the money, and the reimbursement is made before the prosecutor when the case was already being investigated under preliminary investigation, and consequently there is probable cause in the case was filed in court. What is the effect of the reimbursement of money while it is still before the prosecutor's office? Then according to some decision of the Supreme Court, it will only be considered as a mitigating circumstance analogous to voluntary surrender. If he is convicted of the charge of malversation of public fund before the court, the penalty shall be mitigated. It will be reduced in its minimum period, provided that there is no aggravating circumstance to offset that mitigating circumstance. Suppose the reimbursement of money was made when the case is already being tried, and then he is convicted by the court. What will be the effect of the return of the money? It will not affect the penalty. The penalty shall remain the same. He shall not be entitled to mitigating circumstance. But such return of money will only relieve him from civil liability, but not from the penalty for the crime of malversation of public fund. Infidelity of public officer. That's one infidelity in the custody of prisoner. I have touched this preliminarily when we take up Article 156 and 157. Again, to repeat, Article 156 of the revised penal code penalizes any person who shall remove a person from jail by any means. And that is committed by a private individual or even by public officers who has no direct charge or custody of the prisoner whom they remove from jail. But if he is a public officer who has direct charge or custody of that prisoner, and then he connived with the prisoner escape or consented to the escape of the prisoner, then it is violation of Article 223, and the charge shall be infidelity in the custody of prisoner. What about the prisoner who escaped? What is his liability? Then he shall be prosecuted for violation of Article 157 if he is already serving sentence. The crime is evasion of service of sentence. But if he has not, or he is not yet a prisoner by final judgment because the case is still pending trial, then as a rule, he shall not be liable for any crime at all. The only exception is if he acted in connivance with the offender, then he could be held liable for the crime. If he is a private, if the one who assisted in escape is a private individual, then delivery of a prisoner from jail. There is no decision with respect to the liability of that private individual if the person who allowed him to escape is a public officer who had direct charge of the custody of that prisoner. There is also the reduction of duty or infidelity in the custody of prisoner through negligence that is covered by Article 224. Now, may a private individual be guilty also like a public officer for infidelity of the custody of prisoner or persons under arrest? It depends. I'll give you an illustration and I will not give immediately the answer so that your mind could still work and find out what is the crime committed. Now, here is Mang Petro, a private citizen. While walking in front of the Quiapo Church, he saw a snatcher snatch the bag of an old woman who had just come out from the Quiapo Church. So he immediately collared before the thief or the snatcher could go away. He was able to recover the bag. And then he returned it to the old lady, the victim, and said, "Ma'am, pumunta na kayo doon sa nearest police station at ito yung tao dito ay aking hatid para tayo kayo ng formal na reklamo." Meanwhile, this Mang Petro is already escorting the arrested snatcher. But along the way, this arrested snatcher proposition to him, "Sir, total wala namang permission ng wala nang permission dahil naibalik naman, wala naman akong ginawa noon. Pakawalan nyo na ako. Siguro pareho din po tayo nangangailangan. Ako nakagawa ko ng kasalanan kasi yung aking bunsong anak may sakit, wala akong hanap buhay, wala pambili ng gamot. Kayo po, nakasilelas lang. At parang malayo pa ang pupuntahan nyo, baka wala po kayong pamasahe. Pero pa po ako rin doon, 500 pesos, tanggapin nyo na pa. Tinanggap, pinakawalan. What is the crime committed by the Mang Petro? Will he be liable for infidelity in the custody of a person under arrest? You know, the arrest was valid because it was in conformity with the provision of Section 5 of Rule 113 on warrantless arrest of the rules of criminal procedure. That is the provision of law on warrantless arrest. Arrest in flagrante delicto. So he is now in custody of a person under arrest. Will he be guilty under the provision of Article 225? The answer is no. But it does not mean that the Pedro has not committed any crime. What is the crime committed? It is the crime of obstruction of justice. PD 1829. Why is it so? He could not even be guilty as an accessory to the crime of bribery, because it is not covered by any of the provision of Article 19 of the revised penal code on accessories. He is not covered. Since he is not covered, then he shall be charged for obstruction of justice under PD 1829. One of the sections there, or one of the punishable act, is when any person who knows of having knowledge that a person has committed a crime, and he connives, conceals, or assists in his escape, that man shall be liable for obstruction of justice. And that is where Juan Pedro falls violation of the provision of the law on obstruction of justice. But when then could a private individual be held liable as if he were a public officer and his crime is infidelity and the custody of a person under arrest? When the person, when the prisoner or arrested person is entrusted by a public authority to a private individual or a limited custody. Like for instance, there was an operation, bypass operation under the, to implement the dangerous drugs act. Two policemen went to the place and they were able to arrest one of the suspects who sold them this shabu, who sold it to the police pusher buyer. But the policeman asked the one who sold them this dangerous drug, saan ka ba kumuha nito? Naku, nandiyan pa po, maaabutan po ninyo. But that is an inner portion of the alley where there abound lawless elements. If they will bring the arrested pusher inside, there is the risk that he might be put away by his cohort. So to avoid the happening of that situation, in the street corner, they know of somebody. So they brought this pusher to that place of demand, whom they know, a private individual, and said, oh, pwede ba, partner, i-entrust ko na namin ito, nahuli namin ito. Nakaposas ito, kung pakakawalan. So tinanggap naman ang custody, itong private individual. It is a public authority who entrusts custody of that person under arrest. Now, when the policemen are already there, this arrested poser made a sad story, making the heart of the custodian, the private individual, cry because of pity. Nagola siya, pinakawalan niya. Now, what is the crime committed by this man? That is a situation now covered by Article 225. A private individual who shall become guilty of infidelity in the custody of a person who is under arrest. Because the man whom he had allowed to escape had been entrusted to him by a public authority. Unlike Mang Pedro, there is nobody, no public authority who entrusted to him that person who he called being his master. That's why Mang Pedro could not be covered by Article 225. That is the difference between the situation of Mang Pedro and that private individual to whom the policeman entrusted that person under arrest. So it's not clear already. That is the situation where a private individual could be liable for infidelity in the custody of a person under the arrest. Then we have infidelity in the custody of documents of papers, Article 226. The global concealing or destruction of papers or documents that are entrusted by a duty of his office to a public officer. And then he removes the same, conceal, or destroy. This, of course, did not result to damage to private interest because what is damage from the act itself is damage to public interest. So there is no more need of proving damage to a private individual because the mere commission of violation of that act constitutes already as a crime resulting to the damage of public interest. Now, a letter carrier of the post office, the government office, who is entrusted with mail matters for delivery to the respective addresses. Now, this letter carrier, who is an employee of the government and therefore public officer, is officially entrusted of those mail matters. Then he takes those mail matters or any of them, destroys it, and get valuables that may be contained, money or whatever, jewelry. Now, what is the crime committed by that letter carrier? There have been a decision of the Supreme Court from old back up to the present. You know, you have to associate this provision with qualified theft. If it is mail matter that is taken, it is qualified theft. If the offender is a private individual or maybe a public officer but who has no official custody of those mail matter, the crime is qualified theft. But if it is a letter carrier who has official custody of those mail matter and takes away those mail matter, he is not guilty under qualified theft. Under Article 310, he is guilty of infidelity in the custody of paper or documents and the Supreme Court violation under Article 226 of the revised penal code. There are a lot of decisions that you must have read probably in your reading of your book of prayers, either under the provision of Article 310 or cited again in the provision of Article 220. Just read those provisions concerning revelation of secret. Siguro naman alam din na kasi pag sinabing revelation of secret, yan ang crime na nakukomit ng mga chismoso at saka chismosa. Siguradong madaling maintindihan yan. Let's go to the... teka muna. Medyo na nanunuyo na yung lalamunan ko. Ganun din siguro kayo. Let's have a break for a while and then we will resume after that. Two policemen entrusted, turned over the arrested criminal to the investigator. He was brought inside a small room and then investigation went on. Every time that the answer of X, the brother, is not pleasant to the ear of the investigator, he is also pummeled with fistic blow. Additional injury were inflicted. What crime is committed by the investigator? Will that constitute maltreatment of prisoner? The answer is no. The answer to the question, when is there maltreatment of prisoner, is that after investigation, and that arrested person is booked for an alleged crime committed by him, and then placed behind the prison cell. Even for a single moment, he becomes a prisoner. At ano ba ang paliwanag ko? Sa umaga, pag nakikinig kayo ng mga news, ng mga reporter, field reporter, tuwing may hinuhuli ang pulis at nilalagay sa selda, ang sabi, ang description ng radio announcer, ang nahuling kriminal sa ngayon ay humihimas ng malalamig na bakal. Pagka gano'n ng description noong radio announcer, meaning to say, nasa loob na ng kalaboso. So, yun na ang prisionero. Oras, whoever, remember, the officer liable for maltreatment of prisoner is the officer who has control or charge of that prisoner, not any public officer. That is the provision of law. And so, there was maltreatment. Inflicting harm, either that he wants to get confession or impose punishment that is not allowed by the rules and regulations, and even if it is allowed, the carrying out of the punishment is cruel and dehumanizing. Now, if the act of trying to compel the person arrested to confess and violence or intimidation is employed by the police officer, and he is not yet a prisoner, the crime will only be grave coercion. But the moment he is already a prisoner, that compelling him to confess by means of employing violence will now constitute maltreatment of prisoner. How many crimes will that public officer who commit maltreatment of prisoner be prosecuted in charge? Now, take note of the language of the law. In addition for the liability for the other offense that they have been committed, that penalty prescribed in Article 235 shall be imposed. So, if that maltreatment results to physical injuries, or the victim almost died because of severe wound or injury inflicted, were it not for the timely medical attention, then 2 crimes will be charged against the police officer. One for maltreatment of prisoner, the other one either for serious physical injuries or prostrated homicide, as the case should be. That is how this provision of Article 235 should be applied. You know, there are only few provisions of law which says in addition to the liability for some offense. One of them is Article 235. The other one is Article 129, when it says in addition to the other offense that they have been committed, the penalty of the provision shall be employed. So therefore, there is no complex crime because the provision itself provides for separate and distinct penalties for the 2 offenses. Now, anticipation of duties of public office under Article 236. A person was appointed to a public office. But before he could discharge his office, there is a requirement by law. He must post bond before he could start discharging the duty of the office. But he immediately proceeded to discharge the duty and failing to post the required bond. The crime committed is violation of Article 236 because there is anticipation of duties of public office. In the case of prolonging performance of duties and powers, if a judge, for instance, had retired, reaching the compulsory age of 70, but even if he had reached this compulsory age of 70, he continued to write decision, issues order on the jury that since his replacement has not been duly appointed and qualified, that there may be a hiatus that will be created if he will immediately vacate the position. So he continues to work as judge. Will he be liable? The answer is yes. Because under the law, once the judge is compulsory retired, there is no holdover capacity to be spoken of, no, to speak of. Automatically, he has no authority to perform any more duty. If he prolongs, then he will be guilty under Article 237. A public officer who had taken out of office, and then after 3 years, he just called on the head of office and said, "Sir, consider me resign from my position. I will not go back to office anymore." Will he be committing any crime? Yes, he will be. Because under the public office, you cannot just abandon your office if you don't want anymore to serve in the government. There must be tender of formal resignation. And he could not just leave the office. He has to wait the approval of that resignation paper. Otherwise, if he leaves the office without waiting for the resignation to be approved, he might suffer the penalty under Article 238. Because a public officer cannot just leave the office. There must be some clearance that shall be secured before his resignation could be approved. Now, this Article 239, 240, and 241, take note that there are only specific officers who could commit this crime. This is different from the usurpation of official function under Article 177. Under Article 177, it is committed by any person who, under false pretense of a public position, he performs a duty. Whereas here, in usurpation of legislative power, under Article 239, the offender should be either a judicial officer or an executive officer who issues rules and regulations of which power belongs to the legislature. That is, if he issues rule, the effect of which is to repeal a certain rule that is passed by the lawmaking body, then the judge or the mayor or the judicial officer or the executive officer who usurp that legislative power shall be guilty under Article 239. In usurpation of executive function under that provision of law, only a judge or judicial officer could be held liable by assuming the function, let's say, of an executive office like the mayor. In usurpation of judicial function, it is only an executive officer. You know, there was time under the rules of court that the mayor is allowed to conduct preliminary examination in order for him to issue a warrant of arrest. Now, during that time, he could not be held liable under this provision of usurpation of judicial function because he is authorized, provided that the judge is absent at the time when he acted in performing the duty of a judge by conducting preliminary examination in order to establish a probable cause that would warrant the issuance of a warrant of arrest. But now, that power or that power had been eliminated in our rules of procedure. No other public officer in the government could issue a warrant of arrest or search warrant, as the case may be, except a judge, because under the Constitution, no warrant shall issue except upon probable cause that is personally determined by the judge. So no other functionary in the government except the judge, by virtue of that constitutional provision, who would issue a warrant, whether search warrant or warrant of arrest. Now, unlawful appointment. You know, this crime of unlawful appointment normally arises every after election. Now, there are positions which are coterminous to the mayor or position upon the loss of that, let's say, vice mayor, mayor, as the case may be. Marami silang position dyan na coterminous. Yung iba, positions which are needing qualification under the law. Now, how is this crime under Article 244 committed? That is when the appointing public officer shall appoint or nominate a person to a particular position, knowing that that person has no qualification to occupy the position. But to become guilty, said the Supreme Court in one decision, there must be a law providing for the qualification in the office to which the recommendee or the appointee shall be appointed. Because if there is no qualification required by law, there is no law providing qualification for the occupancy of that position, then this provision would not apply. Because the law says, knowing that he is not qualified. So it requires really that the law should provide what are the qualifications for a person who shall be appointed to that position. Suppose the mayor, knowing that that man is not fitted to work for that position where the law provides the necessary qualification. He knows that that person does not have. He strongly recommends to the appointing authority can the mayor be held liable for violating Article 244? The answer is no. Mayor letter recommendation is not included in the Punishable Act. It must be nomination or appointment. Recommendation is not a nomination nor an appointment. Hence, that does not constitute violation under Article 244. This Article 245, the last article on crimes committed by public officer. This is the crime known as abuses against chastity. This crime is different from crimes against chastity. Crimes against chastity are those that includes acts of lasciviousness, adultery, concubinage, seduction, whether simple or qualified, abduction, whether possible or consented abduction. Those are the crimes against chastity. But this provision, Article 245, penalizes abuses against chastity. How is this committed? There are two ways by which this crime may be committed. Under the first paragraph, the public officer guilty are the ones who have pending matters for his action, or with which he has to consult a superior. And then he makes immoral advances or solicit any immoral advances to a woman who are interested in the matter pending for action by that public officer. So, judges and prosecutors and the public officer who are required to act on certain matters. A prosecutor, for instance, he has to act on cases assigned to him for preliminary investigation. This is a matter pending before him. If a woman, remember, the victim of this is only a woman, not a man. So, if a woman follows up, inquires about the status or action on the case pending before that fiscal, and the fiscal who appears to be a maniacs. Next is immoral advances. Then, if there is only one, for instance, pwede bang ma-identify ang ganda-ganda mo naman? Sabi naman ng babae, sir, hindi naman ako gano'n, sabi ng gano'n, no? Saka may asawa na kayo. If the fiscal refrains anymore from insisting on what he wanted on that woman, then there is no cause of action to charge him. But if the fiscal becomes persistent, inulit pa niya, that will be another thing anymore. He will be held liable under the provision of the abuses against chastity. On the other hand, kung yun naman na woman na interested on the matter, eh, panay na ang pa-charging sa fiscal o sa judge, ayaw siyang pansinin. Nagalit si Miss, ang ginawa niya, nagdemanda laban sa fiscal. Ano ang crime? Sabi nung investigator, bakit mo dinidemanda sa fiscal? Eh kasi ininispuan niya ako. Eh wala rin naman ginagawa sa fiscal eh. Eh nga po eh, wala rin ginagawa, hindi man lang ako pinapansin, kaya ako yung naanoy eh. Kaya ang just vexation demanda ko yan. Pinakailangan papansin hindi pala para makaiwas sa demanda ang fiscal. Ano? Now, the second is public officer who has the charge or custody of woman prisoner and makes indecent or immoral advances on that woman prisoner. But the later portion, even if it is not the woman who is in custody, but the jailer makes immoral or indecent advances on the wife, sister, or relatives by affinity. The same crime is committed by the jail officer or any public officer who has custody of that prisoner. But remember, if you look at the enumeration of those women on whom that advances are being made, mother is absent. Why is mother discriminated against? Are the lawmakers not able to see mothers who are peculiar tender daughters, who could also be the apple of the eyes of the jailer? nagkakamali sila. Talking from experience, ang dami ko na nakilala na napakagandang ina. Hindi. Kung naman yun lahat naman niya kayo nakakita na kayo na mas magagandang ina di ba? Hindi naman nagsisinungaling ako, di ba? In these crimes committed by public officers, there was question in the last bar examination. Can a public officer who are made liable for those crimes covered by Title VII be also liable at the same time for violation of the Anti-Graft and Corrupt Practices Law? Now, according to Justice Mario Lopez, my counterpart, he said, "Oo, padre, marami na kaming decision. Even if he is charged for violation of the provision of the revised penal code under Title VII. In addition, the officer could be convicted likewise for violation of the Anti-Graft and Corrupt Practices Act." Now, I want you to go over with the provision of Republic Act 3019, the Anti-Graft and Corrupt Practices Law. From the decisions that are already cited or elaborated in the extract, the most violated is that paragraph which punishes causing undue injury upon any person, including the government, or giving unwarranted benefits to either party. And with respect to the other public officer, entering into transaction that is grossly disadvantageous to the government. Oftentimes, those are the charges that are filed before the Ombudsman and found their way to the Sandigan Bayan. So, you just read it because the provision of the Anti-Graft Law is worded in a simple manner that it is easily understandable. Now, if a public officer is charged whether violation of the revised penal code, crimes committed by public officers, or under the provision of the Anti-Graft or Corrupt Practices Law, when shall the court order his suspension? And if the order of suspension is issued, is it mandatory? Now, under Section 13 of Republic Act 3019, before the public officer charged in an information for any crime punished by the revised penal code or even the special law, the issuance of order of suspension is not automatic. The rule is there must be a pre-suspension hearing. There must be a hearing, pre-suspension hearing, to determine the validity of the information filed against the public officer. And once the court is able to determine that the information is valid, order of suspension is mandatory. It is mandatory upon the finding of valid information, validity of information, but not before the pre-suspension hearing. Now we have reached. I will take up few articles because we still have a little more time, half hour, on this very important portion of the Book 2 of the Revised Penal Code. According to the Book of Reyes, Justice Aquino, the most important portion of Book 2 of the Revised Penal Code is Title 8. Crimes committed or crimes against person, because it involves destruction of human life. That is the reason. I read a case where the ponente, that is a homicide case. The ponente is Justice Perfecto, and he made a sermon in his decision. But what attracted my attention is the use of the different terminologies describing the killing depending on who is the victim. Part of it, as far as I could remember, it says the killing of the father is parricide. The killing of the mother is matricide. The killing of an offspring, pronicide. The killing of the wife, uxoricide. Killing of an enemy, hosticide. But if the victim of killing is one of the guests in a social gathering, the term is hospiticide. Hospiticide. If the victim of killing is head of the state or a monarch, the term is regicide. And if there are multitude of people who were killed, which we call ordinarily as massacre, like the Maguindanao massacre, the proper term is genocide. And any person who kills another by the side of the rebel, the term is not riverside. It is still homicide or murder, as the case may be. Not riverside. You might mistake it to be riverside. Now, the first crime against person is Article 246. This is the crime of parricide. If you have not fully understood yet how this Article 246 should be understood applied, then perhaps my brief lecture on this will guide you. Now, parricide is committed by any person who shall kill his child, father, or mother, whether legitimate or illegitimate, or other ascendants or descendants, or the spouse. Now, with respect to the other ascendants, meaning pataas, and other descendants, there must always be legitimacy of relationship. If the victim is illegitimate grandfather or illegitimate grandchild, there is no parricide. They must always be legitimately related to each other, the offender and the victim of the killing. If it speaks of ascendants, other ascendants, and other descendants. There is no relative by collateral. Collateral relatives are not included. Killing of brothers against brothers and sisters against sisters. They could not be considered parricide because based on the definition of parricide, the relationship is always on the straight line, not collateral. It's either upward or downward. That is the relationship, blood relationship. So, pag ang pinatay ay kapatid ng tatay, kapatid ng nanay, that is not parricide. Because that is not the killing of other ascendants or other descendants. They are collateral relatives. With respect to the killing of the spouse, of course, there are husbands who have many wives. But only those legal wives are included. Not the number 2 or number 3 or number 4 as the case may be. What is the best evidence to prove the legitimate or the legality of marriage? Of course, medical, marriage certificate or marriage contract as the case may be. What about if there is no documentary evidence that could prove marriage? Is there no other kind of evidence that could be used to establish validity of marriage? There are several decisions. First, with respect to those who are witnesses in the celebration of marriage, the principal sponsor, secondary sponsor, their testimony could be sufficient to establish the validity of marriage or the legality of marriage between the two, provided that there is no objection to its presentation. And additional evidence, oral testimony in open court by the accused himself, who is charged of killing his wife. If he admits in his testimony before the open court that he is married to the victim, that is admission against his penal interest under the rule of evidence. If it is an admission in open court against penal interest, it is admissible as against the declarant. And that would be sufficient to cause the conviction of the accused for parricide. Suppose Mary and Johnny are married to each other. But after 10 years of married life, they were not blessed to have a child. So they opted to adopt. They were able to find a pretty baby boy in the orphanage. And then they applied or they filed a petition for adoption. Having all the qualification and none of the disqualification, the court granted the decree of adoption. What is the effect of the decree of adoption on the child? The decree of adoption endowed the same right as well as the right of a legitimate child. So, this adopted child grows up and under the care of the loving parents. When the boy was grown up, there was an altercation between him and the father. And at the height of the altercation, this child or this grown-up man now was able to get hold of the gun of his father and shoot the father, who died as the consequence. What is the crime committed by this boy who had grown up but later on killed his father? Will that decree of adoption make him guilty of parricide? The answer is no, because the relationship by adoption is only a creation of law. It is a relationship by legal fiction. What the law requires is relationship by blood in the direct line, whether upward or downward, not by any kind of relationship. Adoption will never make this adopted child a natural child of the adopting parent. Even if the law says he will be endowed with the same right as that of a legitimate child, that does not create blood relationship. It remains to be a relationship created by legal fiction. And therefore, that could give rise to a crime of parricide. Now, if the party had been married white because of their irreconcilable differences, they opted to file a legal separation, and there was a decree of legal separation. After 15 years of being legally separated, the man court again the woman for 3 years, continuous 3 years. He asked the woman if he will accept his offer of love, and the woman said, "No, my heart had already turned into a stone. It will never beat for love, for my love for you." So it made the man infuriated. He starts to get the woman. Will that constitute a crime of parricide or only homicide or murder as the case may be? Since it is only legal separation, the marriage tie remains. So parricide is still the crime. They still remain to be validly married. What is the effect of legal separation? Only separation from wedding bond. It never cuts off or sever the marriage tie. So the crime would still be parricide. You know, a husband was charged with parricide, with prostrated parricide, because the husband hit the head of his wife, hitting her on the skull, on the head, almost breaking the skull, which caused almost her death, were it not for the timely medical attention. So they were not reconciled. The wife now filed the case. It is prostrated homicide pending before the RTC. Now the RTC judge became curious. So he asked the accused, Mr. Accused, totoo ba na pinukpok mo o pinalo mo ng siya itong asawa mo sa ulo? Opo, Your Honor. Bakit mo ginawa? Kasi, Your Honor, hindi ko mabuhat ang mesa namin dahil napakabigat. Kaya pang lambalak pa rin, no? Tapos yung husband, nadimanda rin ng prostrated market dahil itunulak yung isang babae doon sa bintana ng isang mataas na building. Mabuti na lang at hindi namatay. So, dinamanda siya. Pagkatapos, tinanong ng judge yung akusado, bakit mo itinulak itong babae na ito? At halos namatay siya kung hindi nagamot sa ospital? Your Honor, by mistake. Why by mistake? Sabi niya, mistake of identity, Your Honor. Bakit mistake of identity? Nakatagapod po, akala ko po yung mother-in-law ko.
Galit. Bitter. Bitter. Ay, sir, ha? Boy pa ba? Boy pa ba, mother?
Alright, death or physical injuries inflicted under exceptional circumstances. The leading case here is the case of people versus Francisco Abarca, who like you was reviewing for the bar when his fatal incident happened. He gunned down the paramour of his wife. He was reviewing for the bar in Leyte, like in Tacloban, Leyte. But because he was not feeling well at that afternoon, he came home a little early than the usual time of his going home. But when he arrived home, he found all doors of the house and windows are closed. So he eavesdropped when he was already in the house. He heard two voices, one coming from his wife and the other one from a man who is not him. So the more he wanted to enter the house, until at the back of the house, he was able to find a hole enough for his body to slip into it. He was able to enter. But when he tried to open the master's bedroom, it could not be opened because it is locked from inside. So he went up a table and then he looked down over the bed and then he saw the loving wife into the arms of a loving man who is not him. The man was attracted by the noise created by Abarca. He got hold of his caliber .45 pistol because he happens to be a constable. And Abarca could not do anything. So he ran away. He went to another barrio where he has a relative and borrowed an Armalite rifle. When he went back to his house, the paramour was no longer there. So he continued searching for him until almost 1 hour thereafter. He saw the paramour of his wife already playing mahjong in that barrio. So with his cocked Armalite rifle, he shouted, "Patay ka na!" And then he squeezed the trigger, the bars of fire hit that man and died instantaneously. However, some bullets, stray bullet hit two victims in the locality. So, Abarca was arrested and consequently charged for murder with respect to the killing of the paramour of his wife. With respect to the two others who did not die because they were treated at the hospital, 2 counts of prostrated murder were charged against Abarca. Now, during the trial, he admitted he being killed. He narrated what he had observed and what he had witnessed. He surprised the wife in the act of sexual intercourse with her paramour. But since he could not do anything because he was outside of the master's bedroom, and the fact that he was pointed at with a caliber 45 by the paramour, he could not do anything except to run and look for a weapon that he could use to kill that paramour. When he was able to successfully borrow that Armalite, the man, the paramour, was no longer there, and he continued searching. So that ended the defense of Abarca. The RPC convicted him of murder. He said, "Your explanation could not be taken with merit because the existing law on jurisprudence on that point is that in cases of death under exceptional circumstances, you should have, or the spouse should have surprised the other spouse. And if you are not able to kill the victim, either the other spouse or the paramour, or both, while in the act, you must have killed either or both of them immediately thereafter. Since there was already 1 hour that had passed before you are able to shoot and kill that paramour, then it will no longer fall under this position, because the Supreme Court has ruled that the surprise, the chase, and the killing must form part of one continuous act. You have already occasion from the time you went to the patio to borrow that armored rifle, went back to your house, and continue searching. You have already all the opportunity to regain the coolness of your thinking and your composure. But you did not refrain. Instead, you still killed the man, which is no longer falling under the trace or immediately thereafter. The Supreme Court ruled that it still falls under that phrase or immediately thereafter. Because what is important is the killing was the result of the proximate training, the result of the outrage that is still overwhelming Abarca at the time. Even if there was almost 1 hour that passed, he was still blinded by that thinking of having surprised the wife in the arms of another man who is another man having sexual intercourse. So he was acquitted by the Supreme Court. That is the case of people versus Abarca. The killing did not happen immediately or did not happen while in the act of sexual intercourse, which according to the Federal Supreme Court decision, the killing there must be in the act while the victims are in the act of sexual intercourse. Or if not, it should be killing immediately thereafter. Now take note that Article 47 never defines any crime. You could not see in the records of the court, since time immemorial up to the present, of a person charged where the caption of the designation of the offense is death under exceptional circumstances. There is none. Then what is this? Article 247, if it does not define any penalty, then that article only creates a special extenuating circumstance that if the spouse so surprised the other in the act of sexual intercourse, kill the spouse and the lover or paramour as the case may be, or immediately thereafter, he shall be entitled to exemption from criminal liability for murder or homicide as the case may be. Then he will only be penalized with the penalty of discharge, according to the last portion of Article 247. The only exception is the husband who surprised the other spouse under that situation could not claim this benefit if he abandons the wife or has facilitated or promoted the prostitution of the wife. He is not entitled to that exception, from criminal liability. Now, the other set of offenders who could be entitled to this extenuating circumstance of Article 247 are parents of the daughter who is below 18 years old and still living with those parents. When any of the parents or both of the parents surprise their daughter having sexual intercourse with her lover, if the parent or any or both of them kills either or both of them, then the parent shall be entitled to the special extenuating circumstance, and they shall be exempt from criminal liability for murder or homicide, but they shall only be penalized with the penalty of discharge. Now, this was asked in the public examination of 2008. What is the purpose of the penalty of discharge in Article 247? The Supreme Court explained that discharge under Article 247 should not be strictly interpreted to be a punishment imposed upon an offender. Rather, it should be taken as a form of protection upon the spouse who had killed those victims or have inflicted serious injuries on those victims from the revenge or retaliation that may emanate from the relatives and sympathizer or friends of those victims who were killed. That is the pronouncement of the Supreme Court in the case of People versus Abaca. The penalty of disquero, which is provided under Article 247, is not strictly to be considered as punishment, but only a mere form of protection. Now suppose the injury inflicted is not serious, but only less serious physical injuries or slight physical injury. What is the criminal liability of the spouse who inflicted it? Then that will already constitute absolutory cause. There is no more provision of law that penalizes it. If only less serious physical injuries or slight physical injuries are inflicted, it is now covered by the absolutory cause. There, what is the meaning of absolutory cause? Those are causes which will make which otherwise the offender is guilty and to be penalized. But by reason of public policy, they are not already made a punishable act. So, the spouse shall not be prosecuted anymore, if only less serious or slight physical injuries are inflicted. The title is Death or Serious Physical Injuries under Exceptional Circumstances. Now, what is the designation of the offense to be charged against the spouse who killed the other or the paramour, or the parents who killed the daughter, or the lover of the daughter, as the case may be? Then the designation shall be with respect to the information when the victim is the other spouse, it should be poison. With respect to the killing of the paramour or lover, then the designation is homicide. Now, what will happen to Article 247? It could only be invoked as a matter of defense during the trial. This is a situation where the reverse proceedings under the rules of criminal procedure will be applied. The accused shall admit the killing, but he will say, Your Honor, I will invoke the provision of Article 247. So instead of the prosecution, who shall present their evidence, it is now the defense who will be allowed to present evidence, because there is no more necessity to prove the death or the killing as the case may be, because the accused himself had admitted killing the victim. The reverse proceedings. So, as a matter of defense, it is incumbent upon the accused to establish all the requisite elements of that special extenuating circumstance. Then, if he is able to satisfactorily prove by competent evidence that all those elements covered by Article 247 are present, then the court shall exemptly pronounce that he is exempt from criminal liability, but he will only be penalized with the penalty of disquero. What if the daughter is below 18, has married, like for instance, a seaman. A seaman marries that young daughter, and then the seaman leaves that girl to the parents. The girl is still below 18. She is still living with the parents. If the parent surprises her having sexual intercourse with another man, and the parents kills either or both, can the parents be entitled to the exempting circumstance? Answer, no more. Because even if she is still below 18 and living with them, that right to invoke the exemption under Article 247 is only the other spouse, not the parents anymore. Only parents whose daughter has not married yet could invoke this defense under Article 247. You will argue, but the marriage is void because the girl is below 18. Now, do you remember that principle? Nobody shall have the right to interpret the validity of marriage. It must be declared by the court, so that marriage is presumed to be valid. And in so far as the situation is concerned, that daughter is already a married woman. And only the husband has the right to invoke that special extenuating circumstance under Article 247. Now, I will tell you, when I told you about the People versus Abarca, that is the straight application of the provision of Article 247. But I will give you an instance of the reverse application. Reverse application. Okay, here is a married couple. Let's say Mary and Peter. Mary was a real estate agent who used to close, according to her, big land transaction where he earns a huge amount of commission. They were living in a small apartment. But after a few years, when the couple, of course they are childless, when they were taking their breakfast, the wife breaks a news. Honey, I have a happy news to you. I have closed a very big land deal and I received a huge commission. I bought 1 unit of condominium in Makati. At the end of the month, we will transfer there. So Johnny immediately embraced the wife and said, you know, I love you. You provide a good life for both of us. Then they transferred. After 1 month came the birthday of Johnny. Again, the wife surprised Johnny, her wife, her husband, opened the bag and said, Johnny, I have a birthday gift for you. Here is the key of a brand new car I bought for you as a gift. You look down at the window, that red car parked in front of this condo unit, that is your car, my birthday gift. Again, Johnny embraced the wife and planted kisses repeatedly on the lips to the delight of both, of course. And so Johnny, after the breakfast, said, all right, you test drive your brand new car. And so when Johnny was about to proceed, he was called back by the wife and said, oh Johnny, probably you want to enjoy yourself. Here is your money as capital for in the casino. So a large wad of money was given, amounting to 200,000. Again, another embrace and sweet kisses again. So Johnny left. After 2 days, Johnny went home. It was nighttime. He was very sad because all the 200 pesos lost in the casino. But the car is still there. So he went up to their condo unit. Because he had a key of his own, he was able to open the main door. But when he was already going to enter the master's bedroom, it was closed from the inside. But there are giggling boys inside. The giggling boys of his wife and another one. So he was sunk in anger. He prepared his caliber 9mm pistol, and with all force, he breaks open the door. And when it was open, he surprised the wife and the paramour already engaged in sexual act. The woman, upon seeing the husband already poking the gun and ready to squeeze the trigger, she jumped out of the bed and kneeled before Johnny and said, Johnny, my love, please give me a chance to explain. Ano ba iyong papaliwanag? Huli-huli ka, naglalaro ka ng apoy. But then Johnny gave them. Anyway, papatayin ko rin lang kayo. Sige, pagpaliwanag ka na. You know, Johnny, do you know where I got the money which I used to buy this condo unit? Yes, you told me it was your youth commission in your landed estate deal. Johnny, I lied to you. It did not come from that land transaction. That big amount of money came from this man, pointing to the new lover. So Johnny became tongue-tied. And then the wife continued, Johnny,
2 days ago, I give you your birthday gift. I bought it 1,300,000 pesos. Do you know where I got the money for buying it? Yes. According to you, it was all already related to social deposits of your big land deed. That is again a lie, Johnny. The money came from this man. And so Johnny broke intently on the nude body of that lover of his wife. And then he said, kung ganoon pala, balutin mo niya ng kumot, baka siprin yung mama niya. So that is the reverse application of Article 2. Ladies and gentlemen, resuming with this lecture. Now, before I leave the topic of rape, simple rape is punishable by reclusion perpetua. But there are several cases of qualified rape where under 266, Article 266 does state, there are enumeration of this qualified rape. When the rape is committed on a minor below 18, and the offender is the father of the victim's mother, the stepfather, within the third relative minor. This is qualified rape of the first child. The stepfather of the victim. The difference lies that to become victim between the victim's mother and the rapist, to the court has ruled on that point in order to clarify stepfather relationship with the victim are two different parties and the victim's mother to become the relationship of the step. Now, the rape by those public officers who have this also qualified. Those rape committed were the victim, those committed by the offender who knows that he is an other sexually transmitted disease. That is qualified. Offender should know about such affliction. Rape, but one of the elements that must be present is that the rapist is pregnant at the time when the rape is committed. Also, rape of religious vocation, like nuns. If nuns, but meron nare-rape na nun, pero hindi qualified kasi kuminsan. So, go with some young women friend, pero hindi alam ng marami na yun pala ay mother. So, without the rapist knowing that she is member of the ecclesiastic. Then those public officers, like members and takes of their public position in order to facilitate the commission of rape of a wife in the presence of the husband, the relatives by consanguinity within the third civil degree. That is within the presence of the husband, members of the family. And remember that before this new law on rape, raping the aggravating circumstance of ignominy by any ordinary litigant. But now, it becomes vision of Article 266, that's it. I'll begin with the topic 76, but I reserve the discussion, especially when it comes to trafficking of women, which are punishable under the both. I will consider this week. I will touch what is the effect, and the other one is also punished in that special law. Which one shall be responsible? The accused shall be charged 2 counts on the provision that under the Constitution on double jeopardy is the solution to that situation. So we will now against security and liberty. Now, Article 267 penalizes the crime of kidnapping and serious illegal detention. Now, what is illegal detention? How do you define illegal detention? When is illegal detention serious? And when is illegal detention qualified? All of these questions could be answered by the same article, Article 267. Illegal detention is defined as the deprivation of liberty, kidnapping, detention, or in any other manner deprive a person of his liberty illegally. And the offender in illegal detention is a private individual. But don't be misled that only purely private individual who would commit the crime of kidnapping and serious illegal detention, as it is stated in the provision of Article 267.
Because even public officers like policemen, if they acted beyond their duty, they shall be considered as acting in their private capacity. Thus, you have read in the papers and even in cases where policemen are charged and convicted of kidnapping and illegal detention. They are not actually private individuals, but because they acted beyond their authority, and that is considered to be act committed in their private capacity. Now, how is illegal detention considered serious when any of those four enumerated circumstances is present? When the detention of the victim lasts for more than 3 days, that is number one. When the crime is committed by simulating public authority. Number three, when threats to kill were made against the victim. And lastly, when the victim is a minor, except when the parent is the accused, or a female, or a public officer. So please focus your attention in that fourth circumstance. Once the victim is a minor, or a woman, or a public officer, regardless of the length of detention, as long as the main purpose is to deprive the victim of his or her liberty, the crime is already serious illegal detention under Article 267. And when is it qualified? When the purpose of kidnapping is to extort money for ransom, or as well as a consequence of detention, the victim is killed or dies, or when the victim is raped during detention, or subjected to torture or any dehumanizing act. In all those last cases that I enumerated, that is considered qualified kidnapping and illegal detention. There is only one penalty there, it's death penalty. What is the meaning of detention? Well, I told you when I discussed arbitrary detention, the same concept. There must be restraint of liberty. There is no need that they shall be placed inside an enclosure. Even if they are not placed inside an enclosure, but they could have lived as they wish, the place where they were, because of duress, or that they were always guarded. That is also detention, either in the arbitrary detention provision in Article 124 or under the provision of Article 267. Now, with respect to the qualified kidnapping, that is for ransom, is it necessary that ransom money must have been actually received by the kidnappers to make it qualified kidnapping? The answer is no. As long as the purpose of the kidnapping is to extort for ransom, that is sufficient, regardless of whether or not ransom money was actually received by them, by the offenders. In the case of death of the victim, when the victim, after in the detention, the main purpose is to detain him, but as a consequence of detention, the victim was intentionally killed. That is qualified kidnapping. Or the victim dies. Here, in that case, the victim dies. He is not intentionally killed. He could have died by any means, by negligence, or the victim himself cut off his life by hanging himself, or commit suicide. As long as he died as a consequence of the detention, that kidnapping and serious illegal detention becomes a qualified one. There is no more crime of kidnapping with murder or with homicide. As long as the killing happens in the course of detention, or in the course of detention the victim dies, then the charge could be denominated kidnapping with homicide or murder as the case may be. But it will not depart from the fact that that is the special composite crime or qualified crime of kidnapping. There is no ordinary complex crime of kidnapping with murder or kidnapping with homicide. No more, because of the amendment of the provision of Article 267, which says when, as a consequence of detention, the victim is killed or dies, that erases and eliminated the possibility of that crime under Article 48, kidnapping with murder or homicide as the case may be. Now, when shall the forceful taking of the person and then later on the victim is killed be considered as qualified kidnapping and or merely a crime of plain murder? Now, the Supreme Court has clearly made a distinction whether the taking and killing of the victim will only constitute plain murder, and when shall it be a qualified case of kidnapping where the penalty is death. The yardstick is when the purpose of the kidnapper is indeed to kill the victim. They kidnap the victim, bring him somewhere else, and then kill him. The main purpose being to kill him, the crime is murder. But if the victim is taken and the principal purpose is to detain, but subsequently they kill the victim, that is where the crime becomes qualified kidnapping. It is the special complex crime of kidnapping with homicide or with murder as the case may be. As long as there is killing, the penalty is the same. Now, in the case of rape, when is the forcible taking of a woman and after rape be considered a crime of qualified kidnapping with rape? And when shall it be rape only? And when shall it become a crime of forcible abduction with rape? Ito ang magandang mga questions sa multiple choice. Bibigyan kayo ng pass, then you will be made to choose what is the proper crime to be charged against the offender. Is it forcible abduction with rape? Is it rape? Or is it qualified kidnapping with rape? Now, in many cases, the Supreme Court has explained this. When the main purpose of the forcible taking of the woman is indeed to rape, then the crime is only simple rape. The forcible abduction is deemed absurd. But if the taking is attended with due design, and then later on the woman abducted is raped, that is a complex crime under Article 48. That is the crime of forcible abduction with rape. It becomes rape only when the principal purpose in taking the woman is to rape her. It is plain and simple rape. When is it qualified kidnapping with rape? When the principal purpose is to deprive her of liberty. And then, as later on, she was raped. Then it becomes qualified kidnapping, or the so-called spatial composite crime of kidnapping with rape. Now, if you will look at the provision of Article 268 on slight illegal detention, you will find that the manner of commission is the same. There is taking or kidnapping or detaining or in any manner deprive the victim of his liberty illegally. The offender is also a private individual. But take note, with respect to correlating it with the court circumstance under Article 267, you will be asked, who could be a victim of slight illegal detention? Now, read again the last circumstance that makes the crime serious under Article 267. When the victim is a minor, except when the parents are the accused, or a woman or female, or a public officer. If it is the minor, then immediately it is kidnapping and serious illegal detention. If the victim is a female, the same. The crime is under Article 267, kidnapping and serious illegal detention. And if the kidnapped victim is a public officer, the same. So who could be victim of slight illegal detention? There is only one. He must be a male who is not a minor nor a public officer. Because the moment she is a woman, the crime is immediately falling under Article 267. That is the result if you read carefully the provision of Article 267, particularly that fourth circumstance, and then correlate it with Article 268 on slight illegal detention. There was a stay or misplaced Supreme Court decision that is even cited in the book about that woman victim of kidnapping, but before the expiration of 3 days from her detention, she was released voluntarily. The Supreme Court ruled it is like illegal detention, forgetting the fact that under the last circumstance that makes that kidnapping qualified, there could be no slight illegal detention if the victim is a female or a woman. Automatically, it will fall under Article 267, and no way could that fall under the provision of Article 268. But after that decision, the Supreme Court probably realized their boo-boo in that decision. There was no more subsequent decision that still sustained that earlier decision, which they said that the woman victim of kidnapping was released before the expiration of 3 days by the kidnapper, where it was held there that it was only slight illegal detention. That is very erroneous, grave error. Hindi naman katakataka na nagkakamali lang ang Supreme Court, nagkakamali din ang Supreme Court. Kaya lang ang problema, pag sila nagkamali, it forms part of the law of the land. Pag naman yung mga lower court judges, subject to disciplinary action for ignorance of the law. Pag Supreme Court, wala. They shall be subject to impeachment para sila mapurataan. But as long as they sit there, kahit anong pagkakamali nila ron, they could not be charged. Except only after they are impeached. Under Article 268, that is privilege mitigating circumstance. When the victim of kidnapping or illegal detention is released before the expiration of 3 days, and the release was voluntary, and that the release was done before the institution of the criminal prosecution of the offender. So, within 3 days, they must be released. The release must be voluntary, and number 3, that the release was before the institution of the criminal action. If those 3 requisites are present, then it becomes privilege mitigating circumstance in the crime of slight illegal detention. But this privilege mitigating circumstance does not apply to Article 267. It is only particularly applicable in slight illegal detention, but never in kidnapping and serious illegal detention. There is no such privilege mitigating circumstance. Now, as a rule, when there is an accomplice in the commission of the crime, the penalty shall be 1 degree lower than that penalty prescribed by law for the principal. But examining the provision of Article 267, any person who provides the place for the commission, meaning to say, providing a house where the kidnapped victim is detained, without being a co-conspirator in the commission of the crime. What is that act generally described? It is an act of accomplice. But then, the penalty for that person who provided the place for the incarceration or detention of the victim is the same penalty as the principal in the crime of slight illegal detention. No difference at all. And that is an exception under Article 60 of Book 1, that those rules established in Book 1 regarding the penalty that is lowered by 1 degree in the case of an accomplice, or 2 degrees lower in the case of an accessory. They apply only when there is no specific penalty prescribed by law. But in the case of this Article 268, there is a specific provision. It says that the same penalty for the principal in the commission of slight illegal detention will be the same penalty for the one who provided for the place where the victim is detained. Under Article 267, with respect to the minor offender, does it mean that the parents would not be held liable for kidnapping their minor children? Well, if you speak of Article 267, yes, they could not be, because that is an exception, except when the parents or any of them is the accused. But it does not say that they could not become criminally liable. They could be criminally liable not under that provision, but under Article 270, and the penalty for the parents shall be found, in Article 271. It is only arresto mayor. Kidnapping of minor or refusal to return the minor. But actually the word kidnapping there is somewhat misplaced. Because if you will read the provision of Article 270 with respect to kidnapping or failure to return of minor, the mode of commission is never by means of kidnapping. Because according to the language of that article, a minor is entrusted to the custody of the offender by the guardian or parent as the case may be. Then later on, that person to whom the minor is entrusted deliberately refuse to return that minor to the guardian or parents as the case may be. So is there kidnapping in the language of the law? The word kidnapping in Article 270 appears to be misplaced. And this it missed the eyes and understanding of our lawmakers when they made certain amendments to the provision of Article 267. But we could not do that by amending it by ourselves. It takes the lawmakers to amend that. What is the penalty again? If he is found guilty of kidnapping his minor child, arresto mayor. How shall it become possible that the parent may be guilty? Well, example, the couple is married. They beget a child. But later on, one of them petitioned for the declaration of nullity of the marriage on ground of psychological incapacity. For example, then there was severance of marriage relationship because of the declaration of nullity. But in that decision, there is portion there awarding the custody of one of the parents. If the child is minor below 7, automatically to the custody of the mother. But almost always, there is a right of visitation granted or given to the father. Now, assuming that that is already the situation, they are living apart from each other, and the child is in the custody of the mother with the right of visitation. One day, the father of the child goes to the house of the wife and said, I am missing the hugs and kisses of our child. Pwede ba pahiram mo muna sa akin kahit 2 araw? Dahil gusto ko naman pakipasyal sa enchanted kingdom. Yun naman wife, alibasa working mother, wala mapag-iwanang madalas doon sa kanilang anak, o sige, pero ipangako mo, on the third day, ibabalik mo. Sabi naman ng tatay, o sige, ibabalik ko yan. Yun ang pangako ko. But after the third day, wala pa. It turned out that the father had no intention really to return the child. He brought the child there in Batangas, the home province of the father. It came to the attention of the wife that the child was brought by the father in Batangas. Now, what is the crime committed by the father? That is where Article 270 will apply. That is failure to return a minor to the person who has rightful custody of that child. And if convicted, only a minimal penalty will be imposed. The provision of Article 271 will apply. It is only arrest of mayor according to Article 271. Now, illegal arrest or unlawful arrest, Article 269. This must be correlated with Article 124 on arbitrary detention. In arbitrary detention, it is only public officer who could commit the same by detaining a person without any legal ground. In the case of unlawful arrest, violation of Article 269, the offender is any person. It could be a private individual or a public officer. Then they arrest a person outside of those instances allowed without warrant under, we need to say, not within the provision of Section 5, Rule 113 on warrantless arrest. Or there is no reasonable ground to arrest. That does not make the one who arrested to be guilty under that article. Because it says, what is the purpose? The purpose is to bring that person arrested to the proper authorities. If there is no such purpose, then the crime could only be illegal detention or arbitrary detention if he is a public officer. But if there is a purpose to bring him to the proper authority, when he made that arrest, the crime would fall under Article 269. That is illegal arrest. Any person, according to that provision of 269, may be guilty. So, he could be a public officer, or he could be a private individual. As long as the main purpose is to bring him to the proper authority. The best illustration of this is when a person who have no legal ground to arrest shall arrest that man and with intention of falsely charging him. So, the purpose is to bring him to the authorities so that person could be falsely charged. Then the person is guilty, whether public officer or private individual, shall be held liable under that Article 269. Now, what is this crime of slavery? Under the provision of Article 272, that is slavery. Take note that there is one mode of committing the same, that is the same or similar to the crime of kidnapping and serious illegal detention. The offender shall sell, purchase, or kidnap any person in order to enslave the person, the victim. So if the main purpose of the victim is not to deprive the victim of his liberty or her liberty as the case may be, but to enslave, then it will fall under the provision of Article 272, the crime is slavery. And it becomes qualified if the victim is a woman and the woman is placed in prostitution, immoral activities. Now, I was telling to the practitioner, kung meron kayong kaso, hindi mo na kayong kukuha ng bar, magiging abogado rin kayo. Suppose your services is hired by an accused charged of kidnapping of a woman. when you feel that there is no way by which you could secure the acquittal of the accused, because the charge is under Article 267, where it is automatically serious illegal intention if the victim is a female under the fourth circumstance. Now, to be able to give a little advantage to your client, because she is sure of serving the sentence of reclusion perpetua, then you tell him that in your defense, you have to testify by admitting you kidnapped the woman, but your purpose is to enslave her and place her in the prostitution houses. If the court is persuaded, then you will only be convicted under Article 272. And your client would be free from the possibility of a penalty of reclusion perpetua. The penalty is only prison mayor. That will pattern your pocket, assuming your client is wealthy. You will be given a bonus. If the original attorney's fee or acceptance fee is 200,000 or $500,000, probably it could be made double. And of course, you will not refuse acceptance of that money because you deserve it. You know, you may be ignorant of your law once in a while, but you should not be ignorant of your law by this time and also by the time you are taking the examination. But remember, once you become lawyers, you may once in a while become ignorant of your law, but it will not excuse you from collecting your attorney's fees. So become lawyers first before you become ignorant of your law. In 2005, bar exams, the provision of Article 273 and 274 was made basis of the bar question. What is the crime committed? Let's say X is a creditor. Here is a neighbor. The creditor, of course, is wealthy. He lends money. Then here is a neighbor. Let's say Aling Maria, who had a son studying in Manila, in college, but came enrollment time, like this period of schooling. This is enrollment period. Aling Maria is lacking of money for the matriculation fee of his son for purposes of enrolling him in college in Manila. So he went over to the house of X. He borrowed the sum of 10,000 pesos on the agreement that Aling Maria will pay it at the end of 2 months from the receipt of money. Now, Aling Maria is unable to pay the loan. And so, X was very mad at her. And then he said, alright, meron kang anak dyan na dalagita, 17 years old. Pagtrabaho niyo dito sa bahay ko. At hanggang sa mabayaran niya yung inutong mong pera. Now, applying Article 273, if that minor works under the employ of that creditor against her will, on the pretext of reimbursing the indebtedness of her parents, then the creditor is guilty under Article 273. That is the crime of exploitation of child labor. And suppose it is not, because when the girl, the young daughter of Aling Maria was presented, sabi ni Mr. X, naku, ang liit-liit na katawan na walang alam na trabaho yan. Mabuti pa, ikaw na lang, Aling Maria, na magtrabaho dito at hanggang sa mabayaran ng utang mo. Ikaw ay gagawin kong tendera doon sa aking tindahan sa palengke. Now, question. What crime is committed by the creditor? It will not become a crime under Article 274. When the debtor is compelled to work, it must be with respect to 2 works mentioned in Article 274, because that crime is service rendered under compulsion in payment of debt. what are those two words in which the debtor is compared to what? Foreign laborer or domestic servant. Domestic servant. So, pinilit siyang magtinda sa palengke. That is not a crime that could fall under Article 274. At most, it will be a crime of coercion. Coercion is the crime. It will not fall under the provision of Article 274 for services rendered under compulsion in payment of debt. Then we have abandonment of persons in danger and abandonment of one's own victim. Article 275. Now the first paragraph speaks of abandonment of a person in danger of dying. The offender finds him in an uninhabited place. Despite the fact that he could help that victim without risk to himself, that victim was left alone by the offender. That act would constitute violation of Article 275, the first paragraph thereof. What is an uninhabited place? The first time you come across that is under Article 14. When the crime is committed in an uninhabited place, whenever it facilitates the commission of the crime. So, we learn that an uninhabited place is a place where there is no possibility or almost no possibility of help or assistance that would come on the victim or a person. That is an uninhabited place. An example of this is, for instance, the forested area at the foot of the mountain. It is seldom visited by persons. Now, if it so happened that a hunter went there, and along the way, he finds this man who had several wounds in the body, and by mere looking at the person, he would die. But he's still alive at that time. He could have given a help, but he did not help the victim, which he found in an uninhabited place. The only defense there is, he is unable to help the victim who is in danger of dying, because doing so will also put his life in danger. But if there is no such circumstance, then he shall be held liable under the first paragraph. The second paragraph speaks of abandoning one's own victim. A driver who runs over or sideswipe a pedestrian. Instead of stopping in order to help, he stayed away. That is the so-called hit and run. Hit and run. If the spot of hit and run, assuming that he was arrested and charged with the crime of reckless imprudence resulting in serious physical injuries because the victim did not die. Now, according to the last paragraph of Article 365 on imprudence cases, quasi-offenses, if there is already an allegation which qualifies that crime of reckless imprudence resulting in serious physical injury, of that allegation that the offender abandons his victim without giving help, there being no danger to himself if he gives assistance to that victim of his. Well, once convicted in that reckless imprudence case, that will become a qualifying circumstance. The penalty is higher. Now, if it is already alleged and made the crime of reckless imprudence qualified, then he could no longer be charged separately for violation of the second paragraph of Article 275. But if it is not alleged there in the information for reckless imprudence, then apart from being convicted in the crime of reckless imprudence resulting to physical injuries, he could be separately prosecuted under the provision of Article 275, paragraph 2, abandoning one's own victim. Now, the last, the third paragraph, huwag na natin pag-usapan yan, hindi na pinapatupad yan. Dahil kung yan pinapatupad, strictly, hindi na tayo magkikita-kita rito, wala tayo nasa kulungan. Bakit ka mo? Nakalagay dyan ang offender, one who abandons a minor below 7, failing to bring him to the safely, to the authority or to the parents. Meron bang gumawa sa atin yan? Ang dami-dami ng SDG yan. Tagkalat, abanto. Wala. Pero meron bang hinuli sa atin? Wala rin. So, hayaan mo na yan. Hindi na masyado importante. Basta sa mahalaga, alam mo yung provision yan. Yung third paragraph yan ng Article 275. Okay, let's go to the so-called trespass to dwelling. Article 280 and the so-called other forms of trespass, Article 281. Now, these other forms of trespass is sometimes known as trespass to property in order to distinguish it from trespass to dwelling under Article 280. Now, what is dwelling again? It is any edifice or structure devoted principally for rest in comfort. If a house is also a store, and there is only one passage for the portion of the store and the living quarters inside the house of the owner, that could not be considered a situation where dwelling could be considered as aggravating circumstance if the crime is committed therein, because it could not be considered as an edifice or structure principally devoted to rest in comfort. But purposes of this qualified trespass to dwelling, then it is a different thing. We are not considering the use or aggravating circumstance, because dwelling could not be appreciated anymore as a separate aggravating, because the crime itself defines it, and dwelling is part of the definition. You learned that from Article 62, the effect of aggravating circumstances, whenever any aggravating circumstance is inherent or part of the definition of the crime, it could no longer be appreciated as a separate aggravating circumstance. So when the crime is trespass to dwelling, there is no aggravating circumstance of dwelling that could be appreciated. It is part of the definition of the crime. And how is it committed? The same manner as in Article 128. When the offender, who is a private individual, enters the dwelling of the latter against the will, or against the will of the owner. Now, against the will, as I explained under Article 128, which is the same, that should apply here, dwelling should be entered into by the offender against the express prohibition, or at least against the implied prohibition. Mere lack of permission of the owner when the offender enters the same may not at all constitute trespass to dwelling. Especially so if there is no express prohibition nor implied prohibition. And there are three instances where the offender, even if they entered into the dwelling against the will of the owner, the offender shall not be considered to have committed the crime. When the offender enters the dwelling of another, even against the will, but his purpose is to prevent serious harm, to avoid serious harm to himself, or to the owner or occupant of the house, or to any third party. That is the first. The second is when the offender enters the dwelling of another against the will of that occupant or owner, when his purpose is to serve humanity or justice. And lastly, entrance to taverns, restaurants, inns, or similar establishment whenever they are open. Now, I told you, I have not mentioned that according to certain authorities, these three instances, which will not make the offender who enters the dwelling of another, the dwelling of another against the will of the owner, will also, by analogy, apply to the provision of Article 128 with respect to public officers, who without any valid judicial warrant shall enter the dwelling of another against the will of the owner thereof, if he has these purposes mentioned in Article 280. But that is not expressly stated in the provision of Article 128. That's why, according to the authorities, the application thereof is only by analogy, analogous to the provision of Article 280. Now, suppose a person enters the dwelling of another with intent to rob. He first opened the door, but before he could go inside further, he was accosted and collared by the owner, who was awakened because of the noise he had created. For what crime shall the offender be charged? Is it attempted robbery, prostrated robbery, or it shall only be trespass to dwelling? Answer, the last one, trespass to dwelling. Because even if the intent of that person is to rob, but he has not committed any overt act which is directly connected to the crime he intends to commit, then that is still indeterminate intent on his mind. And you cannot treat the intent of a person unless an overt act directly connected with the crime he wanted to commit is performed or done by the offender. So, the crime committed by that offender who breaks open the door and enter the house, and without doing anything more, shall be guilty only of consummated trespass to dwelling. But if he is able to hold any valuable there, and before he could pick that out, he was arrested, then attempted robbery. But if he is already holding that thing that he had taken, but before he could get out of the door, he is apprehended, then that is prostrated robbery in an inhabited house. But once he stepped out of the main door, even only one step, and he is apprehended, then that is consummated robbery in an inhabited house. Now let's go to other forms of trespass, otherwise known as trespass to property, Article 281. How is it committed? Now the offender enters a fenced estate or closed premises which is not inhabited, and there is manifest prohibition to enter, and the entrance was without the permission of the caretaker thereof. So that is trespass to property, closed premises, or fenced estate, when the same is uninhabited. Eh talaga naman walang uninhabited kung yun lang man lupa, nilagyan lang ng kahit na mataas na pader. Di fenced estate lang yan, fenced estate. Eh yung mga bodega or any house that is not occupied but doors are closed shall only be considered as closed premises. I'll give you one example. Here is an apartment unit. There are 5 doors in the apartment. The last door was not occupied by any tenant because she was driven away by the owner through the ejectment proceeding for failure to pay the lease rental for the last 1 year. So there was a case of ejectment filed, and then the owner of the apartment wins the case, and then a writ of execution was issued, and so the occupant was driven away. It is now restored to the owner. So the owner now makes some renovation work to make it appear that this is new again. Kumbaga sa bagong paligo na naman. Medyo bumago-bago. Pinapinturahan, nagmukhang maayos na. Pagkatapos, ang renta naman ay napakataas. Yung dating 3,000 a month, naging 10,000. Kaya maliit lang yung apartment doon. So, 3 buwan, 5 buwan, 6 na buwan, bakante, walang nakakuha. Dahil namamahalan sila doon sa renta. So, laging nakalock lang yun. Then, one evening, 2 persons destroyed the door, and they entered there, and they made it their living quarters. The barangay who found out what happened telephoned the owner. And the following day, the owner now comes with in the company of two policemen whom he requested to accompany him in order to control those two persons. The two persons were arrested. Question, what is the crime committed to be charged, assuming that the policemen had arrested and the owner is pursuing a case against those two who intruded into the privacy of that vacant apartment. Is it trespass of dwelling, or shall it be other forms of trespass under Article 281? Answer, it is only a closed premises, and therefore the crime is violation of Article 281. It would have been a different thing if that apartment unit is not a vacated unit. It is still occupied, although the tenant went abroad and he will stay on vacation in the state for the whole 1 year. If during that 1 year period, those two buds into that apartment unit in the absence of the occupant, then the further charge against them shall be violation of Article 280. It will constitute trespass to dwelling and not trespass to property under Article 281. Alright, great threats. Dito meron magandang question dito. What distinctions could you offer when it is robbery extortion and extortion by means of threat? You know, these are two different things because you will look at the provision of Article 282. It provides that any person who shall threaten another with a wrong that constitutes a crime, subject to certain or to demand of money or certain condition, that is grave threats. Grave threats. The wrong threatened to be committed is a crime. Like for instance, the person, the offender, threatens another because hindi siya binibigyan ng pera. Oy, Pedro, pag hindi mo ako binigyan ng 100,000 pesos, bukas, susunugin ko ang bahay mo. Alright? Natakot si Pedro, nag-deliver ng 100,000 pesos sa offender, kay X. What is the crime committed? Is it robbery, extortion, or great threats under the first paragraph of Article 282? Extortion through great threats. Answer, Article 282, it is extortion through great threats. The crime or the wrong threatened to be committed amounts to a crime. What is the crime if he will burn the house of Pedro? That is arson. But since there was a demand for money or certain condition is imposed, that becomes great threats under the first paragraph of Article 282. What about in robbery? Robbery is also committed with violence or intimidation of person. With intent to gain it, and he unlawfully takes the property belonging to another. But the difference lies in that in robbery, the wrong or the danger is immediate. The effect of the intimidation is immediate. In threats, future, not immediate. I will burn your house if you don't deliver me the money. So it is not immediate. It could not be a case of robbery under Article 294. But it will only fall under the first paragraph of Article 282. Extortion by means of grave threats. The penalty is higher if the threats is made through a middleman, through an intermediary. Now what is the penalty? It depends. If the threats resulted to the accomplishment of his purpose, like for instance, he was able to get that 100,000 pesos, so he did not commit arson. According to the provision, the penalty shall be 1 degree lower than that penalty for the crime of arson. But if the purpose is not accomplished, the law says, under the first paragraph, 2 degrees lower penalty shall be imposed upon the offender. Now, this kind of grave threats, which is punishable only by arresto mayor, is on the second paragraph of Article 282. It is only arresto mayor. Although the threats is also amounting to a crime, but there is no demand for money or that there is no condition attached to the threats made on the victim. Then we have the crime of light threats. Now, easily, you could already discern the distinction between the first two grave threats under Article 282 and Article 283. Because the offender there threatens another with a wrong that does not constitute a crime. But there is subject, the threat is subject to a demand of money or certain condition. The same as in the first paragraph. The only difference is that the wrong threatened to be committed does not amount to a crime. This is one of the two provisions of the revised penal code that is considered as analogous to the crime of blackmail or blackmailing. In three times in the previous bar, the question asked was, is there a crime of blackmailing under the provision of the revised penal code? If so, in what provisions of law could there be blackmail or blackmailing? So there are two provisions. Article 283, that is amounting to blackmail. Threatening to commit an act that does not constitute crime, but that is subject. It is subject to demand for money. The other one is under Article 363, 356 of the revised penal code. That is threatening to publish a libel or offering not to publish a libel in consideration of some of money. The penalty under Article 283 and the penalty under that article in crimes against honor is the same. Arresto mayor. The same penalty. And what is blackmailing? Blackmailing is the unlawful extortion of money under threats of reporting or exposure or publication. So here is a store owner. He had been given the leader of the standby in their place amenities like free cigarette, free drink, free coffee. But the store owner had become fed up. So he told him, from now on, I will no longer give you these free amenities. No more cigarette, no more drink. This made the leader mad and said, ikaw pabisit, tandaan mo ito. Isusumbong kita sa BIR dahil hindi ka naman nagre-report ng income mo. Pag hindi mo itinuloy yung hinihingi namin sa iyo. Now, there is a threat. But the threat is not a crime. Crime ba yung magsumbong sa BIR? Dahil hindi dabayad ng fees? Hindi. But nonetheless, it becomes a crime. And there was a demand for money. Hindi ba blackmail yun? Pag hindi mo ako binigyan yan, i-report kita sa authority. Dahil hindi ka naman nagbabayad talaga ng tunay na fees. That is an example of blackmail. But you consider the provision of Article 356. Doon naman, actual case na hinandel ko, yung editor ng isang tabloid. Kanyang tinakot yung businessman, pag hindi nagbigay ng 1 milyon piso, itutuloy niya yung pagpapublish ng derogatory statement amounting to libel sa kolon niya. So, kunyari pumayag si businessman doon sa pananakot na yun. Nagsumbong sa kanyang kaibigan, assistant director ng NBI, and so there was entrapment. They agreed that the money shall be delivered at the lobby of Manila Hotel. But the columnist just surrendered all the materials, including those pictures depicting him under in a compromising situation with the distress. Susumbong kita sa misis mo, papublish ko, papadala ko yung mga picture nito. Sabi ng misis, maawa ka naman sa akin na namamaril ng Armalite yung misis ko, baka ako patayin niya. Sabi niya, magbigay ka ng 1 million. So, kunyari nga, magbibigay. Pero, yung pera, parang budol money. In-arrange na parang 1 million, nilagay sa envelope. Pero actually, ang genuine money ay yung lang nasa ibabaw at saka nasa ilalim nung cut out of papers, the same size as 1,000 peso bit. Kaya nung makita at sinilip yung folder na may laman na pera, akala ng columnist, lahat yun talagang tunay na pera. Tinanggap niya. Diniliver niya naman yung mga materials, pictures, including the negative of those derogatory pictures of that businessman with his mistress. When the money, the envelope was given to the secretary of the businessman, of the columnist, eto na. Yung dalawang babae na matatangkad at magaganda na pinakilala nitong businessman ng mga secretaries niya sa opisina, kayo pala ay mga black belter na NBI women agent. Hinuli na ngayon yan. As a businessman. Ipinay ang kaso after investigation. Alam niyo ba kung ano ipinay ng NBI? Robbery extortion. Yan ko yung senior agent nila na abogado. Ano ba? Paano ba ito naging robbery extortion? Di ganyan. Nakita ko, pati naman yung aking assistant prosecutor, the duty inquest, ang recommendation din para aprobahan ko, robbery extortion. Sabi ko, saan kayo nag-aral ito ng doktor pang ito? Ang liwanag ng provision doon sa Article 356, kapag ka nag-offer ng not to publish a libel, o kaya na ipapublish ko itong libelous matters na ito, pag hindi ka nagbigay ng pera, that is blackmail. The other provision, which is the companion of Article 283. Ang crime lang doon ay offering to publish a libel or offering to prevent the publication of a libel in consideration of certain amount of money. So that is blackmail, not robbery extortion. Kaya yung columnist, tuwan-tuwa, nagpasalamat sa akin. Sir, salamat. Ang bigat ng piyansa kung doon sa original. Sabi, marami naman nagsabi, siguro kilala ni Chief Salva itong akusado. Bakit ganun ang kanyang record? Bakit yan ang kanyang approval? Napaboran siya dahil alam ko ang batas. Yun lang ang kaiba nun. Kung hindi ko rin alam ang batas, ang dali ko namang i-sustain yung recommendation ng assistant ko dahil sila muna ang nag-aaral doon. Pero mapapahiya naman ako. Ako ang principal officer sa Fiscal Office ng Manila na tanging nag-a-approve lang ng mga information na ipapay sa husgado, wala nang iba. Kaya kilala ko lahat ng RTC judges and PC judges. Many of their children have passed in my hand as students in the College of Law. Kaya pati sila naniniwala na magaling ako sa law. Ayun mga judges. Tapos gano'n makikita nila, gano'n ang inaprobahan ko. Mawawalan sila ng kumpiyansa na sa akin. So, natutupad yung mga tiga-NBI. From then on, hindi na sila nagkamali na mag-file ng kaso ng robbery extortion kung gano'n ang pass. It's always violation of Article 356. Now, Article 284. Now, this is the provision where you find the penalty of discarol. Because there are only 4 instances in the entire revised penal code where penalty of discarol could be properly imposed. One is under the provision of Article 247, death and serious physical injuries under exceptional circumstances. Number 2, under the provision of Article 284. That is, when the offender in the crime of grave threats under Article 282 or light threats under Article 283 could not post a bond for good behavior as ordered by the court, in which case the penalty of desterro shall be imposed by the court. That is the provision of Article 284. The third one is in the crime of concubinage under Article 334, concubinage. That is a married man who shall keep a mistress in the conjugal wedding. If both of them are convicted, the married husband will be sentenced to the penalty of prison correctional, but the other woman, the concubine, will be sentenced to desterro. This is what I call symbolic penalty. Because if both are to be sentenced with a penalty of imprisonment, there is always that possibility of continuing their illicit relationship inside the jail. So the woman shall be punished and the man inside the cage in jail. Now, other light threats, when a person during quarrel draws a weapon, that is light threats, unless the drawing of that weapon is for self-defense. There is no crime. That is the first paragraph. Also, when in the heat of anger, the offender makes that threats, but subsequently he did not show any persistence to make the threat possible. And threats to commit a wrong that does not amount to a crime. But if it is subject to condition, it falls under Article 283. Then we have grave coercion. Are there how many kinds of grave coercion? Under the provision of Article 286, there are two. Preventing somebody from performing an act not prohibited by law, and the other one is compelling another to do something against his will, whether right or wrong, and the offender has no lawful authority to do so, and the means employed is violence or intimidation. In other words, any person who without lawful authority shall, by means of violence or intimidation, prevents a person from performing an act that is not prohibited by law, or compelling another to do something against his will, whether right or wrong. Now, X have been victim of robbery snatching a month ago. Then today, he meets a person wearing the wristwatch which was taken away by the robber. He confronted the man. Of course, he was definite the man wearing is not the same person who had snatched it from him. So he confronted the man and said, "Padre, yung relos na suot mo, sa akin yan eh. Kilalang kilala ko dahil yan. Tignan mo yung gilid. Nilagyan ko pa yun ng aking initial. Tinignan, oo nga, ano." Sabi niya, hindi ko ito pwedeng ibalik sa'yo. Sabi niya gano'n. Binayaran ko ito, akin na ito ngayon. Nagalit ngayon si Bayari. Binunod yung kanyang balisong knife. Batanggay niya pa, ikaw ay sasaksakin ko. Sabi nung batanggay niya. Sa takot, binigay sa kanya. Huwag mo na ako saksakin, ito na. Ano ang magiging crime nito ng batanggay niyo? Si X. Is it robbery? The answer is no. It is grave coercion. Why? Because there could be no robbery to be committed by a person who, by means of violence, he takes his own property. Because the provision of Article 293, defining the crime of robbery in general, it is the unlawful taking of a personal property belonging to another with intent to gain, with violence against or intimidation of person, or force upon things. So it says belonging to another, not belonging to the offender. So the crime is only grave coercion. without any lawful authority shall by means of violence or intimidation compel another to do something against his will, whether right or wrong. What about this first kind of great coercion, preventing a person from performing an act not prohibited by law? I'll give you an music illustration. Here is Mary and Johnny. They are sweetheart, classmates in the College of Law. They were our both first year in the College of Law. But they agreed to see a movie one afternoon about 6 o'clock. They went to the movie. Siguro maganda ang palabas na kailang ulit na sila. Hindi pa rin sila lumalabas sa sinihan. Inabot sila doon. Last show, past 1 o'clock na nakalabas. So, after coming out from the movie house, the girlfriend, Mary, was already in a hurry to go home. But the boyfriend does not want her to immediately go home. Pero nagpipilit tayo si Mary, sabi niya, Jack, may hinahanap ako ng aking ng parents ko. Jack, lagot ako sa kanila pag ako hindi pa umuwi. Eh may makulit itong lalaki. What? Hanggang sa nagalit si lalaki. Inambanan sa suntok, pag ikay umalis at umuwi sa inyo, bubuntalin kita. Sabi yung gano'n. So may intimidation, hindi na nakauwi si Mary. Pero sabi niya, tapos na ang relasyon natin. I will become history to you. So, gano'n nga nangyari. Masama loob ni babae. Pumunta siya sa kaibigan niyang abogado. Turuan na ng leksyon itong dati kong boyfriend. Sabi, ganito ang ginawa niya. Hindi pala siya pwedeng maging asawa. Yun lang, nananakot na, bubuntalin pa ako. Now, what is the crime committed? And what should be the charge if ever the lawyer advised Mary to institute a criminal action against the former boyfriend? Then it will fall under the first kind of great coercion. Because going home to the parents by that young lady is not an act prohibited by law. And the boyfriend has no authority to prevent her from going. Hindi pa naman sila mag-asawa. And there was employment of intimidation. In short, all the elements of great coercion of the first kind are present. Hence, the boyfriend shall be held liable for that first kind of grave coercion, preventing somebody from performing an act that is not prohibited by law. Now, when is the detention of a person considered illegal detention, or if he is a public officer, it shall only be coercion and not arbitrary detention. That is, if the main purpose of detaining the person is to compel him to do something against his will, that is coercion. A policeman who detains one who is suspected of having committed a crime but he has no evidence to prove it, and he told the person whom he detained, hindi kita palalabasin dyan hanggat hindi ka nako-contest ng iyong kasalanan. What is the crime committed by that public officer? Is it arbitrary detention? The answer is no. It is only coercion, grave coercion under Article 286. If, for instance, a boyfriend of the girl detains the girl inside his house, and then I will allow you to go home only when you agree to marry me. Now, would he be charged with illegal detention? The answer is no. What is the crime committed? It is the crime of grave coercion. Because the main purpose is to compel, not to deprive her of liberty, which is the element of illegal detention. Now, what is the distinction between grave coercion and maltreatment of prisoner? In grave coercion, when he is not yet a prisoner, the person or suspect is being compelled to contest something or wrongdoing. In the case of maltreatment of prisoner, the victim is already a prisoner, and he employs the same intimidation or violence to make that prisoner confess to any wrongdoing. That will constitute maltreatment under the provision of Article 235. But if he is not yet a prisoner, and the same purpose is present to make him confess in the commission of a crime, then the crime committed by the police officer is only grave coercion. Now, other form of light coercion, in case of a debtor who seizes the property, a creditor seizing the property of his debtor in order to apply the same as payment for the indebtedness, that will become a crime of light coercion under Article 287. And that provision also provides for the least kind of coercion, otherwise known as unjust vexation. Any conduct or act of the offender which is not capable of inflicting harm, but nonetheless vexes, annoys, or irritates an innocent person, provided there is no violence or intimidation, shall constitute the crime of unjust vexation. The moment there is violence or intimidation, then it becomes grave coercion, no longer unjust vexation. A woman complains to the police near the Luneta, complaining against the man. Ano ba ang kasalanan itong mama na ito? Ba't may kinukomplain ng unjust vexation? Eh, hindi na naman niya pinapansin. Yun na nga po eh, hindi nga niya ako pinapansin, kaya nairita ako. Unjust vexation, no? It annoys me. Now, this revelation of secrets, pabayaan nyo na muna yan. Basahin nyo na lang. Ayaw ko mag-discuss ng mga krimen, ng mga chismoso at chismosa. Hayaan nyo lang, kayo lang ang makaintindi niyan. Alam na natin naman yan eh. Ay, revelation of secret na yan. Napakadaling intindi niya. Let's go now to the Title 10, Crimes Against Property. Remember that treachery does not apply to a crime against property, no? Because basic is that treachery applies only to all crimes that are embraced in Title 8, Crimes Against Person. Now, according to Article 293, the elements of robbery in general are as follows. One, there must be unlawful taking of a personal property. You could not unlawfully take a real property. If real property is taken over by the same mode, by violence or intimidation of person, that will not be a robbery. It will fall under Article 312. The crime is usurpation of prior rights or usurpation of real property. That is the crime, not robbery. There is intent to gain. The means employed is by employing violence or intimidation of person or force upon means. Now, in the case of a question like this, when is the taking complete in robbery? Then your answer must be qualified. If it is robbery with force upon means, it is necessary that the offender must unlawfully enter an inhabited or uninhabited house. He gets something of value from inside, and then he must be able to get out of the building, whether inhabited or uninhabited.
to become a consummated crime of unlawful taking in robbery with force of handling. But that is not the rule when it comes to robbery with violence against or intimidation of person. The moment the offender, in the case of robbery with violence or intimidation of person, already has control of the thing taken, regardless of whether he has sufficient opportunity to dispose the same, the crime is already consummated. Now, intent to gain, there is already a presumption of intent to gain if there is unlawful taking. But for purposes of understanding any benefit that the offender intends out of that property taken shall be considered intent to gain. Even taking of, let's say, a vehicle for joyride, the Supreme Court has ruled it is already attended with the elements of intent to gain, even if the purpose is for joyride. He is not the owner of that vehicle. The most, the provision where almost every year, bar examination, question is derived therefrom. That is the first kind of robbery under Article 294. Robbery with violence against or intimidation of person. The first paragraph contains the four kinds of spatial complex crime. Of course, you know the distinction between ordinary complex crime and spatial complex crime. It is ordinary complex crime if it will fall under Article 48. When the single act will constitute two or more grave or less grave felonies, or when an offense is committed as a necessary means to commit another. The penalty to be imposed on ordinary complex crime shall be that penalty pertaining to the most serious offense, but must be applied in its maximum period. With respect to spatial complex crime, there are two or more crimes specified in a provision of law providing single punishment. And this is the example of a spatial complex crime, the first paragraph of Article 294. It says, the penalty of reclusion perpetua to death shall be imposed whenever, on the occasion or by reason of robbery, homicide shall have been committed, or when robbery is accompanied by rape, intentional mutilation, or arson. So there is robbery with homicide, there is robbery with rape, there is robbery with intentional mutilation, and robbery with arson. All of them are spatial complex crime. There is only one penalty. It is reclusion perpetua to death. It is specified, and that distinguishes it from an ordinary complex crime. In ordinary complex crime, there is no specific offense or felony that is mentioned to have been committed. Any felony that will arise from a single act, provided both are grave or less grave felonies, they could become a complex crime. Or when one felony is committed as a necessary means to commit another felony, that is ordinary complex crime. Now, when shall this penalty be imposed if it is robbery with homicide or robbery with rape? It is important that the main purpose of the offender is to rob. That must be the principal purpose. If in the occasion or by reason of robbery, somebody is killed, it could be the owner of the thing taken, he could be a stranger to the house, or the person killed is a fellow robber. As long as the killing happened on the occasion or by reason of robbery, the crime remains to be a spatial complex crime of robbery with homicide. If the robbers are already through ransacking the house, they are already carrying the loot that they have taken from inside the house. They are now rushing towards the side of the seashore where the banca, which they will use as getaway vehicle, is parked or located. Along the way, which is half kilometer away from the place or house that was robbed,
somebody was looking at them. It was still daytime, and the robbers thinking that he could be a possible witness against him. They killed that person. Now, what is the crime committed? The Supreme Court said it is still robbery with homicide because the killing has direct causal connection with that robbery. Suppose the robber accidentally shoots or fires his gun, the bullet exited on the wall. It so happened that somebody is passing by. What is the crime committed by this robber? It is still robbery with homicide because the shooting that resulted to the killing was by reason or on the occasion of robbery. There is one case reported in your book. The case of People versus Mangulapnan. Group of robbers rob a house, and when they are through taking the personal belongings and ready to flee the place, one of the robbers went at a table with the firearm directed towards the ceiling. Accidentally, the gun fired. But there was an inmate who saw tributes in the ceiling who was hit by the bullet and died as a consequence. Is it still robbery with homicide? So the Supreme Court said yes. In that case, Mangulapnan was charged and convicted of robbery with homicide along with others. But the others did not appeal. He was the only one who appealed, Mangulapnan. His contention is that he would not be guilty of robbery with homicide because he did not intentionally kill the victim. It was only by accident. Following the provision of paragraph 1 of Article 294, when on the occasion or by reason of robbery, homicide shall have been committed. And that phrase, according to Mangulapnan, implies that the killing must be intentional because of the phrase shall have been committed. But the Supreme Court explained, your argument is not meritorious. That provision of paragraph 1 in the English text of Article 294 is not the correct translation from the original Spanish text. Because in the original Spanish text, said the Supreme Court, it says, con motivo o con ocasión del robo, homicidio resultare. Correct translation is, on the occasion or by reason of robbery, homicide resulted therefrom. It does not say that homicide shall be committed. So any kind of killing, as long as it has direct connection in the robbery that was committed, it becomes robbery with homicide, a spatial complex crime. Even if the killing is accidental or through negligence, even if the robbers had already left the place, they were already in their safe house, and when dividing the loot, they did not, there was misunderstanding. One of them thought that he was being double-crossed. He shoots the other robber. He was arrested. What is the crime committed? Said the Supreme Court, is still robbery with homicide because the killing has causal connection with the robbery, even if it is between the robbers themselves, as long as the shooting and killing of that fellow robber was connected in their main crime, which is robbery. Now suppose in the robbery, victims, or two victims were killed. Or let's say the entire members of the family are killed. 5 members. Then they ran away, they were arrested. What should be the proper charge against them? Shall it be robbery with multiple homicide or multiple murder? The answer is no, said the Supreme Court. It remains to be a designation of the offense as robbery with homicide, regardless of the number of the person killed. It is incorrect to label the charge as robbery with multiple murder or robbery with multiple homicide. Besides, the use of the term homicide in the first paragraph of Article 294, it is used in its generic sense. It covers homicide, parricide, or infanticide, and murder. So, as long as there is killing, even if there are qualifying circumstances to make it murder, the level should always be, the designation of the offense shall remain robbery with homicide, not robbery with murder. Now, suppose the crime of robbery with homicide is committed in the dwelling of the victim. Can dwelling be considered as a generic aggravating circumstance? You will say yes, because the robbers, sasabihin ng answer. Makaramihan ng answer dyan, no. Because it is already part of the definition of the crime. It was dwelling where robbery is committed. Now that answer is correct. If there is no act of assault or violence that were committed by the robber, it will only be a simple crime of robbery in an inhabited house. Dwelling could not be appreciated anymore because inhabited house is dwelling. And therefore, when dwelling is already part of the definition of the crime, it could no longer be separately appreciated as an aggravating circumstance. But when can dwelling be appreciated? Then several decisions of the Supreme Court until the present, the recent one. Once the killing happens on the occasion of robbery committed inside the dwelling of the victim, then the crime is robbery with homicide with the aggravating circumstance of dwelling. Reasoning, the crime of robbery with homicide could be committed even without violating the sanctity of the home. That is the reason, said the Supreme Court. They could bring out the victim out of the house and kill him somewhere else. But they opted to kill the victim inside the house. Then, the aggravating circumstance of dwelling could be appreciated. Now suppose the victim, the owner of the house, was killed while the owner was sleeping. It was on the occasion of robbery. Shall the crime be denominated as robbery with murder because of the attendant qualifying circumstance? The answer is no. As I told you, that term homicide is used in the generic sense. It is always robbery with homicide. What happens to the qualifying circumstance of treachery? You know, basically, robbery with homicide is a crime against property. And therefore, treachery does not apply based on the definition of treachery in Article 14. Whenever a person commits any crime against person, that is the only classification of felony where treachery could apply. But in this particular case of robbery with homicide, the Supreme Court ruled consistently based on the decision of the Supreme Court of Spain with the same provision as in paragraph 1. Borrowing that decision, the Supreme Court now ruled that when in robbery with homicide there is treachery, that could not be appreciated as qualifying circumstance, but only as generic aggravating in that component crime of homicide in order to fix the proper penalty to be imposed upon the offenders. Not as a qualifying aggravating, but generic aggravating circumstance with respect to that component crime of homicide in that crime of robbery with homicide. So if there is treachery in a robbery with homicide, then since the penalty is reclusion perpetua to death, that is aggravating circumstance to justify the imposition of death penalty, assuming there is no mitigating to offset the same. But that will be an academic discussion because whether with qualifying or aggravating circumstance, as long as it is robbery with homicide, death penalty could not be imposed anymore because of the present law, Republic Act 9346, prohibiting courts from imposing death penalty. So always, the penalty shall be reclusion perpetua, regardless of the presence of aggravating circumstances. Now those succeeding articles, paragraph. There are 5 paragraphs in Article 294. From paragraph 1 up to paragraph 4, all of them are spatial complex crimes. Robbery with physical injuries. Why is it also regarded as a special context crime. Because in those paragraphs 1, 2, 3, and 4, even if there are physical injuries committed, there is already a specific penalty prescribed therein, which makes it a special complex crime. There is only one paragraph that there is no special complex crime. It is under paragraph 5, the list time of robbery with violence against or intimidation of person. As a matter of fact, this might be a source of conflicting opinion or confusion, because if a robber snatches the bag of the victim from behind, you know, the policeman will arrest the offender, and certainly it will be charged, he will be charged of a crime. What is normally the charge that is filed by the police, and oftentimes adopted by the prosecutor to whom it was presented for inquest. It is robbery, simple robbery, under that 5th paragraph of Article 294. But remember, to become robbery under that provision of law, there must be certain amount of violence or intimidation. But in mere snatching, he did not suffer, or the victim does not suffer any injury. There was no intimidation. Will it not fall under the definition of Article 308 on theft, which is the unlawful taking of the personal property belonging to another, with intent to gain, without violence or intimidation of person or force upon things, but the taking was without the consent of the owner. There are a lot of decisions now where the information filed was robbery, or a simple case of robbery is nothing. But because the lawyer for the defense is brilliant, he doesn't want his client to plead guilty, even if there was already an offer to penalize him with a lesser penalty if he pleads guilty because of the mitigating circumstance of voluntary plea. The lawyer said, no, I will not allow that. I could secure a much lesser penalty. I will prove that it is not robbery, but only simple theft under Article 308. And in all probability, that brilliant lawyer will win the case for his client. Either that he gets acquitted, or the list is he will only be convicted of simple theft under Article 308 and not for simple robbery under the 5th paragraph of Article 294 because of complete absence of violence or intimidation in the commission of that act of taking. Corollary to this, there is that provision in PD 532, brigandage or robbery or highway robbery. Now, when shall a robber be convicted under the provision of Article 294, paragraph 5, which is simple robbery, and when shall it be for violation of PD 532 for highway robbery? Now, highway robbery under the provision of PD 532 is committed by any person who, by means of violence or intimidation of person or force upon things in any highway, which or street or avenues that is used for movement of person and transportation of goods, the penalty shall be that which is provided under PD 532. And there must be an element of that the victim, the robber, commit robbery indiscriminately. There is no specific victim. Because if there is a specific victim, and that was the victim of the unlawful taking, then it will only fall under the provision of paragraph 5 of Article 294, even if the robbery is committed in the highway. That is the difference. In PD 532, it must be shown that the robber commits robbery indiscriminately. He has no specific victim in mind at the time when he committed the robbery. But if he has a specific victim, then it will not fall under the provision of PD 532. Rather, it will be simple robbery under the 5th paragraph of Article 294. Now, suppose the robbery is committed by Ivan. And, of course, ban is defined in the same manner as it is defined in Article 14. There is a ban whenever there are more than 3 armed malefactors who take part in the commission of the crime. But remember, do not mispronounce the word malefactor by pronouncing it malefactor, because there might be some people who will hear it, aba, kapag ka pala 4 na babae, female factor. Ano? Malefactor is derived from the word wrongdoer. Mali, wrong. Factor, doer. Kaya, wrongdoer or malefactor. Not malefactor. Alright, suppose it is a band that commits a robbery, and only one of the robbers had killed the victim. He shoots the victim, the owner of the house. The 3 others has no participation or had no participation whatsoever. How shall they be penalized? Then, according to the provision of Article 296, whenever robbery is committed by a bank and anyone commit assault that is resulting to death, for instance, of any person during the course of robbery, the rule is all of them shall be guilty for robbery with homicide with the same penalty, except when the 2 other robbers or any of those remaining robbers attempted to prevent the killing. If there is no evidence proving that any of those robbers who did not participate in the shooting, that they prevented the killing to happen, then all of them shall be liable for robbery with homicide. The penalty is reclusion perpetua to all of them. Suppose rape is committed along with the killing. Before leaving, one of the robbers among the 4 rapes the ravishing beauty of a maid found in one of the rooms of the house. So there was killing, there was rape. How shall the charge be denominated in the information? Then the Supreme Court explained, it shall always be robbery with homicide, even if there was rape committed. What happens to the rape? Now, in one earlier case, or many earlier case, the Supreme Court explained that that rape shall only be considered as a generic aggravating circumstance in order to fix the proper penalty. Now, I disagree with that. Had it been said that it will constitute ignominy, then that is correct. But if rape itself is the one mentioned as aggravating circumstance, that could not be applied. Why? Because in the 21 paragraphs of Article 14, you could not say commission of rape as a generic aggravating circumstance. And that was emphasized in a later case, the case of People versus Regala, where the Supreme Court, a division of the Supreme Court held that robbery shall be deemed absurd in the crime of robbery with homicide. It could not even be regarded as an aggravating circumstance because it is not provided in the 21 paragraphs of Article 14 in Book 1 of the Revised Penal Code. The same is true with robbery with homicide where the victims of killing is more than one. Let's say 3 members of the family were killed. What shall be the penalty? Now, according to the ruling, those additional killing could not be considered as an aggravating circumstance. Why? Because you look at the 21 paragraphs of Article 14, you will not see that additional killing in the commission of any crime shall constitute an aggravating circumstance. But the earlier ruling says that it would be absurd to impose a penalty that is the same as when there is only one killing. To the penalty to be imposed if there are several persons killed. So in that ruling, they said that the additional killing shall be regarded as generic aggravating circumstance in order to raise the penalty in its maximum period. But that is incorrect according to a ruling of the Supreme Court. The crime could not be robbery with multiple homicide. It is robbery with homicide. All the additional killing shall be treated as absurd. Suppose serious physical injuries, less serious physical injuries, were also committed along with the killing. then all those crimes, according to the Supreme Court, shall be absorbed in the crime of robbery with homicide. All right, ladies and gentlemen, we will resume next week. And that will be the time when I probably consolidate these special laws that had something to do with minor offenders. Because there are a lot of special laws that are part of the 2011 syllabus which you are obliged by the Supreme Court to study. Everyone. All right, there are some points I wish to emphasize in connection with my lecture a while ago in the morning. Like for instance, I touched on anti-fencing law. Now, may a person be convicted of fencing purely for being in possession of articles which are proceeds of the crime of robbery or theft. Well, under Section 5, there is a presumption from mere possession. And it has been held by the Supreme Court in the case of Pamintuan versus People, where a person who is not able to prove the legitimate source of those articles which are proceeds of the crime of robbery or theft. His main defense is denial, knowing that they are proceeds. So that it will not prevail over the presumption of the law under Section 5. And on appeal, his conviction was appealed because the only defense he put up during trial is that he has no knowledge that those proceeds are from the crime of robbery or theft. The Supreme Court said that is not sufficient defense. You have to prove that your source of those goods or articles are from legitimate source. Like for instance, a appliance, bought from a regular appliance store. You were issued this official receipt. Even if it is placed on the possession of the buyer and has evidence that that was a proceeds of the crime or robbery or theft, this possessor could no longer be convicted because he has proof that it came from a legitimate source. The store which sells this kind of appliances or furniture. But if it is not covered by any receipt, for instance, and he was found in possession, he said, kasi mura kaya binili ko eh. So that having bought an almost brand new appliance for the purchase price of a measly amount, let's say the television set will cost about 30 to 35,000. But he bought the same brand new at in the amount of 10,000 pesos only. That is sufficient. Sabi yan, that the buyer should be warned that television set could have been a proceeds of the crime of robbery or theft. And remember, fencing is not a continuing crime. Let's say robbery is committed in Manila, and then the goods stolen were brought to Cavite, where it was sold. Now, there is only one place where the charge of fencing could be properly prosecuted. It is only in the place where such property was bought by the buyer, or in the place where he dealt with say proceeds of the crime of robbery or theft. It could not be initiated in Manila on the theory that since it was taken from Manila, then Manila could have jurisdiction of the violation of anti-fencing law. That is not correct. It should only be in the place where such violation of the fencing law was committed. What about in carnapping? The vehicle carnap was brought in other places. Then the place where the vehicle was found together with the culprit be a proper place for the prosecution in the crime of anti-carnapping? The answer is no. The Supreme Court held, like robbery in theft, carnapping is fully consummated
in the place where it was taken, regardless of where it was brought by the offender thereafter. So if carnapping happens in Manila, and the carnap is brought in Mindanao, or in Apari or Batanes as the case may be, there is only one place where such charge could be initiated. It is in the city of Manila, because it is in the city of Manila where the act of carnapping was consummated. Now, in Istapa, under paragraph 2, E, paragraph 2E of Article 315, that of obtaining foods, accommodation at hotels, restaurant, inns, boarding houses, lodging houses, apartment houses, without paying therefor, with the intent to defraud. The second is obtaining credit at any of the said establishment using false pretense. And number 3 is abandoning or surreptitiously removing any part of his body in the establishment after obtaining credit, food, or accommodation without paying. Now, it mentioned about an apartment house. Suppose here is a lessee in the apartment. He pays to pay the rental for more than 3 months, and since he has no prospect of getting money to pay it in the middle of the night, he surreptitiously leaves the premises of that apartment house. And then it was discovered by the owner. Can the tenant, who in the middle of the night disappeared, bringing with him all his belongings without paying the rental, be possibly prosecuted under this paragraph 2E of Article 315? The answer is no, because there is no deceit there. The entry was by reason of contract of lease. The failure to pay will only constitute a civil liability, but no criminal liability, because in the case of Istapa, there must be deceit or abuse of confidence, and that there shall be damage or prejudice suffered by the offended party. Here, there could be civil liability only, but there was no deceit, because the entrance of the tenant is by means of a contract of lease. They agreed together. Therefore, violation of the terms of contract merely constitute breach of contract, which will give rise to a mere civil action against the party. This apartment house should be understood to be in the same nature as in hotel or inns or tavern. It was them generous. It must be within the concept of inn, tavern, or hotel, where usually the persons occupying the same are merely transient guests, not permanent guests like a lessee. Now, with respect to the case of money placement transaction, please take note that money placement transaction in any bank is in the nature of loan. There is no istapa. There is no istapa. It is a mere transaction of loan, according to the Supreme Court. And also, with respect to the istapa, when partners contribute money and property for the business operation of the partnership, and it gain profit, then later on, one of them misappropriate those profit, there could be no istapa there, because they are co-owner of the same proceeds or profit from the operation of the partnership. Exception: when a particular partner contributed money or property for a specific purpose, and that the managing partner misapplied or misappropriate that property of money for a specific purpose, contributed for a specific purpose, and diverted to some other purpose. That will be where istapa would lie in case of partnership. Now, under Article 315, paragraph 1B,
in your 2011 bar examination syllabus, there was mention of the trusteeship law. Now, violation of the trusteeship law will constitute estafa under paragraph 1B. How is this estafa committed under the trusteeship law? Now, there is trusteeship agreement. Usually, a businessman who had no money would apply for a trusteeship with the bank. The bank will finance that importation of goods. But in the trust agreement, there is a condition that the trustee, meaning to say the eventual owner of the goods that is imported, has to remit the proceeds of the sale if those goods are sold, or if not, to return those goods to the entrustor. If such entrustee fails to deliver or discharge any of those two alternative duties of his upon demand without justifiable reason, then it is estafa, which is under the trusteeship law. The penalty shall be under the provision on estafa. So the parties there are the entrustor, which is normally the bank, and the entrustee, the one who have the obligation to remit or turn over the proceeds of the goods covered by the trusteeship, or to return the goods or commodities that were covered by the trusteeship, should they be not sold. Alright, let's go on to arson. Arson is now covered by two sets of laws. There is only one provision under the revised penal code on arson, and that is destructive arson under Article 320. All other provisions on arson are found in PD 1613, our arson law. And what is arson? It is the destruction of property by means of fire. Now, some authorities previously told the students, if what is burned is only a thing or property of a small value, that will not be considered arson. It will only constitute malicious mischief. But that is wrong. Any kind of property, big of big or small value, as long as it is destroyed by means of fire, is arson. Because if you will consider malicious mischief, the provision on malicious mischief, you will find there that it is the destroying or damaging property for the purpose of damaging it, maybe impaired by anger, evil motive, revenge, and the damaging cause is deliberately done. So that is malicious, provided it is not covered by the provision on arson. So in other words, this malicious mistake could not be committed by means of fire, because it is excluded. That situation where a thing is deliberately destroyed by means of fire is excluded from the provision of malicious mischief. Now, in Article 320, the enumerated edifice to be burned are all permanent or immovable property, except in paragraph 3, because it mentions vessel, ship, locomotive, and public conveyance. So they are the only movable property which, if burned, could constitute destructive arson. All others outside of that paragraph 3 are immovable. And one thing more, when it comes to a residential house, the burning thereof must be in the residential area, thereby endangering the other properties located therein. Because if there is no allegation in the information that it is located in a residential area, and it gives danger that other houses will be burned, then upon conviction, he will be only guilty of simple arson. It will fall under the provision of PD 1613. But if it is alleged that it was located in a residential area that will endanger other properties, should that residential house is burned, then it will be a crime under destructive arson, Article 320. If in the occasion of that destructive arson, somebody is killed, a person is killed, what is the crime committed? It is qualified arson, or the so-called composite crime of arson with homicide or murder, or with homicide, I mean. The penalty is death, but now it's already caution perpetua. But if it is only simple arson and somebody dies, then that killing or homicide shall be considered absurd in arson. It will not qualify. The qualifying circumstance that somebody dies applies only under Article 320. It is when the arson is destructive. Now, when is the killing of a person by means of fire? Murder under Article 248. And when shall it only be considered as a qualifying circumstance in the crime of arson? It is the main purpose of the offender which will determine whether it is murder or homicide. If in burning the house or building, the purpose is to kill a particular victim, then it shall be considered as murder under Article 248. But if the offender's purpose is to burn the building and unknown to him, there is a person inside who was burned to death, then it is qualified arson. The penalty is death. If arson is committed under PD 1613 or even under the provision of 320 of destructive arson, but such crime will cause or will create a condition of widespread panic or threat, or panic or fear on the populace, with the intent of coercing the government to give in to a local demand, then the crime is terrorism, violation of Human Security Act. If, for instance, however, other elements of terrorism like prosecution fails to prove that there was widespread panic created by the burning, but the fact of arson is explicitly and specifically alleged in the information or the element which is proven by evidence. While the accused could not be convicted of terrorism, he will, however, be convicted of arson only. Same is true with murder, but not homicide. If the crime of murder is committed by the offender, but such killing creates a condition of widespread panic or fear or chaos among the populace, with the purpose of coercing the government to give in to such unlawful demand, then it is terrorism. And if the other elements of terrorism, however, is not proven, but the murder or the killing, together with all the elements, are alleged and properly proven by evidence, then the court is correct in convicting the accused not of terrorism, but murder only. Murder and arson could not be separately charged from terrorism. They shall always be alleged in the information as the predicate offense to commit terrorism. It is only when all the elements of terrorism are not proven when the accused could be convicted under the same information of either murder or arson as the case may be. Now this Article 318, this is an all-cuts provision on estafa. If the fraudulent acts or the deceit or false present, which are the elements of estafa from Article 315 to Article 317, do not cover such kind of deceit, then it will fall under the other deceits. That is Article 318. There is a case that it clearly illustrates how this other deceit or the all cuts provision on estafa under 318 would apply. This is the case of Ginhawa versus People, volume 468 of ESPRA, page 316. You know, Ginhawa is operating a car dealer or car selling business. He buys one brand new L300 Mitsubishi van from the Universal Motor Corporation. Now, along the way, when the driver of Ginhawa was traveling, going to Dhaka City, where the business of Ginhawa is located, he met an accident. And the car was damaged. There are some spare parts, including front tires, to be replaced. So the van was repaired. And the repair was such a good one that it looks like again a brand new Mitsubishi L300 van. So Ginhawa now displayed it in his store of cars, display window, as a brand new car for sale. So here comes the complainant. They wanted an L300 van to be used in the conduct of their business. Upon seeing the car from the outside of it and inside, they were impressed. Napakaganda nito. Ganda nun, magkano ito? Hindi pa naman masyadong mahal ang presyo. Ang timanong pinili ng mag-asawa. Then later on, when they were using it already, they hear some creaking sound on this brand new, or what they believe as brand new Mitsubishi L300 van. So they brought it to their mechanic. It was discovered that there were damages under the car, and they discovered that it was not a brand new after all, because it already suffered repair for the damages that it sustained during a vehicular accident. For this, the couple filed a complaint for estafa under the provision of 380. The accused Ginhawa was convicted by the lower court. He went up to the Court of Appeals in order to appeal the judgment of conviction. It was sustained. The court already said the conviction is correct because that pretense or deceit falls under Article 318 because it does not squarely covered by the deceit mentioned in Article 315, 316, and 317. He's still not contented because he said he has not committed any crime at all. Because these buyers should be, as he had observed, caveat emptor. But the Supreme Court, when he appealed there, the Supreme Court said, no, the failure of the buyer to detect those damages is not its own fault that could affect your criminal liability. The fact remains that you employed deceit by displaying that car, which is no longer brand new. You did not disclose to your buyer that it has already undergone repair because it met an accident causing damage to your car. So the Supreme Court said that kind of deceit falls under the provision of Article 318. That is the case of Ginhawa versus People. That is already published or printed in ESCRA, volume 460. Now this last mode of committing Article 318 the second one is when the offender for profit or gain does the following: interpreting dreams, fortune telling, making forecast, and taking advantage of credulity, translated in Tagalog, kapangahan of the public in any other similar manner. Yung kapangahan ng public will not affect the criminal liability of the offender. So yung mga dagnang nasa ka na pwedeng, kung pwede pang makapag-asawa ng prinsipe, dapat pumunta doon sa Quiapo. Marami rong fortune teller. And for a certain amount of money, biglang magkakaroon ka ng pag-asa. Naku, malapit nang dumating ang kapalaran mo. May lalaking hulog ng langit na siya ang iyong magiging katuwang sa buhay. Tuwa-tuwa naman, nagbayad. Pero tumaan na ang 10 taon, kamuti na buhok, walang dumating. Nahulog ng langit para maging kabiyak niya. So, di ba, if that is the nature of the work of that fortune teller, dapat paghuhulihin mo yun eh. Nagtataka ako, bakit nagpuproblema sa Quiapo eh? O yung mga medyo handsome ang lalaki, dahil gusto nila maging handsome, ay pumunta sila ron at sasabihin, tatanungin yung fortune teller, hulaan mo na ako, Madam Auring, may pag-asa pa ba ako maging handsome? Eh, magbayad ka muna para maging magandang hula ko sa iyo, ha? So it depends upon how much you will pay for the fortune that you will have out of his fortune telling activity. Now this removal, sale, or pledge of mortgage property under Article 390. Now this refers to personal property that is mortgaged under the provision of the chattel mortgage law. To become a valid transaction in the chattel mortgage law, such mortgage shall be registered in the book of chattel registry in the register of deeds. Now, after registration, and the mortgagor will remove it permanently from the place where it was, where the personal property was at the time the mortgage was contracted, and the removal is permanent without the consent of the mortgagee. Then it will become a violation of Article 319. But if the mortgagor sells the same without the consent of the mortgagee, not which is written at the back of that chattel mortgage on record with the register of deeds, then that will constitute violation of the other provision under the by selling or trading. That will be also violation of Article 319. So the mortgage to be covered by this
crime of removal, sale of pledged or mortgage property, it must be registered. Because if it is not registered in the registry book of chattel mortgage property, which is found in the register of deeds, this provision of law will not apply. Now, malicious mischief under Article 327. Who are liable for malicious mischief? Any person who shall maliciously damage the property of another, provided he does not make use of what remains on that destroyed property. Because if he makes use of what remains in the destroyed property belonging to another, he will be guilty for the crime of theft under the second paragraph of Article 308. As explained earlier, now there is the so-called also qualified malicious mischief under the provision of Article 328. Like for instance, those damage caused to promenades, road, water supply, because these are being used in common by the public. Once they are the ones destroyed, it will be considered as qualified malicious mischief. Now, I have to emphasize the importance of Article 332. This pertains to the exemption from criminal liability in crimes against property. In almost 3 successive years, this particular provision was source of bar question. Now, what is this exemption under this article? You know, if the crimes committed are 3 felonies, theft, malicious mischief, and estafa or swindling. If the offender against each other are the spouses, ascendants, descendants, relative by affinity in the same degree, and this include step-parents, step-children relationship, and also common law husband relationship. That is covered there. Because they still own in common that property from against which those crimes are committed, they shall not be liable. Who are these again? They are spouses, ascendants, descendants. The natural, illegitimate, adopted brothers and sisters, and relative by affinity in the same degree. That is the first category of person who could claim that exception. The second one, the surviving spouses with respect to the property left by the decedent, the other spouse, before the same is partitioned among the heirs. So the surviving spouse remains to be the administrator of the same property if he commits to any of those 3 crimes. Okay? Malicious mischief or estafa, the surviving spouse is exempt. And the third one are brothers and sisters, whether legitimate, natural, or adopted brothers and sisters, provided they are still living with each other at the time any of them commits the crime of estafa, malicious mischief, or theft, as the case may be, against the other brother or sister. The moment they are already living separately, that exemption could no longer be claimed. Now, assuming that they are still living together, if a brother commits estafa against the sister, like for instance, he falsifies a private document, making it appear that her sister had given him the authority to collect certain amount of money from C, who is the debtor of that sister.
And relying on this falsified letter of authority, the money was, he was able to get the money pertaining to his sister, and he misappropriated the same for his own personal gain and benefit. What crime or crimes were committed by the brother who is still living with the sister, whom he had prejudiced? Now take note, there is no such crime as I earlier explained of estafa, complex crime of estafa through falsification of private document because of the doctrine of common elements of crime. Remember that when he falsifies that document, he resorted to falsification of that private document. Letter authority, purporting that he is given authority to collect certain money that is due to his sister. When he affixed his signature there and writing those wordings, he is already guilty of falsification. Why? Because that act of falsification, that is an act of falsification. By making it appear that a person has taken part in that act of the preparation of that letter authority, when in fact he is not. And when he did that, he has intent to cause damage to his sister. And the elements of falsification of private document as a punishable offense is there must be an act of falsification. Any of the act mentioned in Article 171, there are 8 modes of committing falsification there. And it is coupled with damage or at least intent to cause damage. So even if that falsified document has not been used, since it is very clear that his purpose is to cause damage to his sister, then he is already punishable of that crime. But he used it in order to collect the money, which later on he misappropriated. Now, if this one he resorted is falsification of public document, well and good, there is such falsification of estafa through falsification of public or official document. But there is no such complex crime of estafa through falsification of private document. Then what is the crime committed for which the brother shall be prosecuted? It is the crime of falsification of private document. Estafa, it will not exist anymore because the element of estafa is already there when he consummated that falsification of private document. They are living with each other, brother and sister. But since the crime that was committed is falsification, the brother could not claim the exemption provided under Article 332 because it says that the crime must be either the following: malicious mischief, theft, and estafa or swindling. Falsification is not included. So the brother is not entitled to that exemption. Now, theft committed by a son of the property belonging to the father and vice versa, there shall be exemption to both of them. Because ascendants, descendants. The father is the ascendant, the son is descendant. It is covered by the exemption. What about if it is robbery that was committed by the son or the father, as the case may be, on the property belonging to each other? Will the son or father be entitled to the exemption? The answer is no. Why? Because robbery is not included in the 3 felonies that are enumerated in the provision of Article 332. But can the son, if he robs the property of his father, be entitled to certain leniency or preference? The answer is yes. By the Supreme Court decision, if it is robbery, the son who robs the property of his father may be entitled only to a mitigating circumstance analogous to that of theft as appearing in the provision of Article 332. And there is no aggravating circumstance of relationship in crimes against property. It is always exempting only, or mitigating circumstance by analogy to the provision of Article 332. Now, if the crime is estafa through falsification of public document committed by any of them, ascendants, descendants against the father, or brother and sister against each other, Will the offender be entitled to exemption? The answer is no. The crime must always be simple estafa, simple theft, simple malicious mischief. The moment it is complex with another crime, that exemption could no longer be claimed. When the law says theft, malicious mischief, estafa, it is plainly simple theft, simple malicious mischief, and simple estafa. It should not be a complex one. Because if it is complex with another crime, that will not be included in the exemption under Article 332. All right, we proceed to Title 11, Crimes Against Justice. Take note that this is different from the crime of abuse against chastity. Because abuse against chastity are those crimes committed by public officers, which are defined in Article 245 of the Revised Penal Code. When you speak of these crimes against chastity, these are crimes which could not be prosecuted de officio. They are crimes which are also considered or termed as private crimes. And what is a private crime? A private crime is one where the offended party is given the option whether to remain in silence or suffer the trauma of the crime committed on her, or expose herself to embarrassment that is present in a public trial. So if she wants to be embarrassed for the crime committed on her, then she files a complaint. If she does not want, then keep silent about it. That's why it is now called crimes which could not be prosecuted de officio or private crime. That is the meaning of it. Now, first and foremost among these crimes against chastity are the first two articles. Article 333, which is adultery, and Article 334, the crime of concubinage. Who are guilty of adultery? The law says any married woman who shall have sexual intercourse with a man other than her husband, and by a man knowing her to be married. So, in this definition, you could see that the two shall be charged together because that is a condition sine qua non for the prosecution of adultery. Both offenders, the married woman and the paramour, must be included in the complaint if both are still alive. If one of them is already dead, then only one shall be complained of. And the law says, who shall have sexual intercourse. And what is important, even if the marriage is subsequently declared void. So it means to say, and it has been held by the Supreme Court, if the act of adultery is committed already, and later on, this marriage of hers is declared void, that will not cure the criminal liability she has already incurred for the infidelity that she has committed. And there is only one way of committing adultery. The married woman shall have sexual intercourse with a man, not her husband. And the law says, and by a man knowing her to be married. So there is a chance that this man could be acquitted during the trial because the law says, by a man knowing her to be married. And it is not uncommon that these married men look more than single than a real single girl. Talking from experience, of course. But they are only my friends and nothing more. You might have something in mind that I don't have. Neither the prosecution for adultery shall foster if there was already pardon or consent by one to the other. What is the concept of pardon so far as this crime is committed? Pardon pertains to past act of infidelity. But consent pertains to future act of infidelity by the married spouse, by the married woman. And how is this pardon granted? It shall be granted according to Article 344, prior to the institution of the criminal action, not when the case is already pending in court. Some authorities say at least up to that stage of preliminary investigation. But the moment the information is already filed in court, according to the explanation under Article 344, that pardon may not be considered valid anymore by the judge. What about consent? Consent, for instance, A and B are married to each other. And then after 5 years, there developed irreconcilable differences between the two. And they decided to part their ways. So, they signed a document. Ako si Maria, ako si Pedro. Kami ay nagkasundo na kami maghihiwalay na. At bawat isa sa amin ay nagbibigay ng karapatan sa isa't isa na humanap ng bagong kaligayahan. That is future consent. If ever, in the future, any of them live with other man or woman as the case may be, both of them still being married, then in case of prosecution, they could just present that document that there was consent. And certainly, they will be acquitted. But if that kind of document is presented to a notary public and it is notarized, huwag na kayo magsabit ng mawawala ng titulo yung tao na yun. Because that document could not become a notarizable document because it is contrary to public policy. Marami na natanggalan na ang lisensya ng notaryo publiko kasi yung mga ganong agreement between husband and wife ay kanyang notaryo. That is against public policy. Now, in how many ways could adultery be committed? The law says by having sexual intercourse with a man, not her husband. So there is only one, by way of having sexual intercourse. And the Supreme Court had ruled that adultery is not a continuing crime. For every act of sexual intercourse had by the married woman with another man, not her husband, will constitute one count. Now suppose the married woman goes with her paramour inside the hotel. They stay there for 1 week. How many counts of adultery shall be charged? And it is not, of course, you will say, tiyak na maraming count yan dahil imposible naman na naglaro lang sila doon ng tongkit sa loob ng hotel, sa loob ng isang linggo. But you know, mahirap i-interpret yung decision ng Supreme Court na yun, literally. Kasi, una-una, pag pumasok yung dalawa, married woman at saka yung paramour, wala naman silang kasamang scorer. Paano nila malalaman how many sexual intercourse? Pangalawa, none of them will tell what they did. Wala naman magsasabi. So what is the better interpretation? For every occasion that the married woman and the paramour goes to a private place, there will be one count. If they opted to go to some other place, another hotel, dahil nagsawa na sila, punta na naman doon sa medyo maganda hotel pa, then they stay there for 3 nights. Again, that is one count. That should be a reasonable interpretation of that Supreme Court decision. What about in concubinage? How is it committed? While in adultery, there is only one way of committing it, that is by having sexual intercourse with a paramour by the married woman. In concubinage, however, the married woman shall commit any of those 3 acts enumerated there. The first act is by keeping a mistress in the conjugal dwelling. When the law speaks of keeping the mistress, it has been interpreted to mean that the married husband shall bring into the conjugal house another woman to be his other wife. Because if the situation is like this, the wife had engaged or hired a domestic servant, a house helper, who is very pretty. At first, the husband does not mind her, but because every time he looks at the maid, she is very pretty, until finally he fell in love. And every night he does a guerrilla tactic style, slipping into the room of the housemaid, until the housemaid became pregnant, and then there was discovery by the wife. If the wife files a case under that provision of law for concubinage, will it prosper? The answer is no. Why? Because the married husband never brought into the conjugal dwelling that woman. It was hired by the wife, and she was already there when the relationship developed. So it cannot fall under that. Is there any sexual and the second act that may constitute act of concubinage is when the married man shall have sexual intercourse under scandalous circumstances. Mura kang nakakaalam ng ginagawa ng husband, pati yung wife hindi rin alam. So walang scandalous circumstance doon. And what does this scandalous circumstance mean? Of course, when the married man had a concubine, a mistress, and then they live in another place. And even if the windows of their house are open, they perform some lascivious conduct like heavy petting, seen by the public outside, while the woman and the man were all scantily dressed. Now, it is not necessary actually that there shall be a witness who will testify that they saw the man and wife in the act of fornication. Wala namang gagawa nun sa publiko. So, circumstantial evidence is sufficient. In the same manner, in adultery, no witness could be found who will testify having seen them in the act of sexual intercourse, because that act is done in utter secrecy. So, circumstantial evidence also is the evidence that shall be presented for adultery and on that second act of sexual intercourse or sexual act of concubinage. Hindi naman siguro katulad halimbawa, itong mama, yung married husband, nakatagpo ng isang pagkabata-batang concubine na iskandaloso pa. Eh doon sa neighborhood by evening, nakadinig sila ng malakas na sigaw ng bata na yun. Na sinasabi, sinisisi yung kapitbahay, mga kapitbahay, wala kayong kwenta. Bakit hindi nyo agad sinabi sa akin na ito pala napakasarap? Wala naman siguro gagawa nila. But that is circumstantial evidence, if you will ask me. No act of sexual intercourse is in. But having heard that kind of shout from the young woman would only give you an impure imagination. Now the last act is by cohabiting in any other place. Now the Supreme Court had already interpreted that third act. It means that the married man and his other woman shall live in another place as husband and wife for a considerable length of time. It should not be by chance meeting alone or dating relationship once in a while. That will not suffice. The married man and the concubine, as explained by the Supreme Court, must live together as husband and wife for a certain period of time. Thus, in one case, the bank manager was charged by his own wife of concubinage because the wife discovered that a pretty girl has given birth to a child And then suspecting that the husband should be could be the father, he went around to the civil registrar's office. And he found a document, the birth certificate of the child. And her husband signed the document acknowledging the paternity of the child. It happened, the manager had disappearing acts in the office from 12 to 2, he's out. And the reason is always out for lunch. With instruction on any of his employees, if his wife calls the office and asks for him, tell him that he is out for lunch. Unknown to the wife, he visits his other woman in an apartment house. Then, intermittently, of course, the girl became pregnant and that baby was born. What happened to that case? Will it prosper? Despite the discovery of that birth certificate of the child, the answer is no. The man was convicted by the lower court. But on appeal, he was acquitted. Why? Because the facts and the evidence does not sustain or do not sustain that praise that the married woman cohabits with the other woman in some other place. The appellate court emphasized that that word cohabit means cohabitation between man and woman as husband and wife for considerable length of time. There is no evidence or proof to show that the man ever slept and lived in that apartment. Tingnan nyo, i-compare ninyo itong provision na ito ng concubinage doon sa provision ng adultery. Masyadong pabor sa mga kalalakihan. Eh bakit kamo? Eh kasi man kalalakihan ang gumawa niyang mga batas na yan. So laging ligtas ang leeg nila yung sa kasakali ka. Kaya bihirang-bihira na makita ng conviction for concubinage. Kasi ang hirap patunayan. Kahit nagkaanak na yung other woman, hindi pa rin maprobahan yung concubinage of adultery, madali. Kasi pumasok lang sa loob ng hotel. And they remained there the whole night. You know, there was a story where I was an actual prosecutor who handled the inquest. And it's about an engineer who was working abroad because of the several rumors that were related to him while working in Saudi Arabia, that his wife was committing or having illicit relationship with another man. He went back without giving notice to anyone, and then he conducted surveillance until he chanced upon the wife entering an hotel. He went to the nearby police station, explained his problem to the chief, and so the chief of that station assigned a policeman to join him. They went inside the hotel, and with the cooperation of the hotel management, the husband and the police were able to open the door. And what did they see? The wife is scantily dressed, with the man also almost without clothing. And so there was confrontation. Anong ginagawa mo rito? Sabi ng husband. Hindi, nagsama lang kami ni attorney dito sa loob. Dahil yung kaso ko, magkakaroon lang kami ng konferensya. Ha? Konferensya? Kinilasuot. Hindi yung klaseng konferensya. So I can't do anything except to order the incarceration of both. Pero kung sana, hindi ganun ang sitwasyon na nakaparehong nakahubad, I will give the benefit of the doubt in favor of the man. Eh, lalaki lang ako eh. Dapat inisyuhan ko na agad ng order of release and schedule the case for preliminary investigation. Pero hindi. Hindi nila maitanggi na talagang sila ay scantily dressed. At saka yung sinabi ng babae, nakakainis. Sabihin mo nagkukonferensya tungkol sa asunto. May kaso nga yung babae. At yung attorney, ang abogado. Pero bakit hindi sa law office? Bakit sa loob ng madilim na kwarto ng biglang liko? Yan ang ano ron eh. Now, the penalty for adultery is a little higher than concubinage when it comes to imprisonment. And besides, while the parador and the man, not her husband, if both convicted, the penalty is both imprisonment. But in concubinage, it is the married man, if convicted, who shall suffer the penalty of imprisonment. But the concubine or the mistress, if convicted, she shall suffer the penalty of discharge. Magkaiba. Well, to me, that is a symbolic penalty. If both are convicted, the man is placed inside the prison cell and the woman is banished. That is because there is possibility of continuing with their illicit relationship if both will meet inside the jail. So that is a symbolic penalty. Symbolic penalty. Now suppose the situation is like this. The husband of a man, the husband went to abroad, to US, secured a divorce. And then the wife, thinking that she could already enter into a relationship with another man, cohabited with another man, not her husband. Now suppose the former husband charges her of adultery. Will that prosper? Now divorce divorce obtained by a Filipino will not have effect at all. But if what the Filipino husband does is obtain American citizenship first, and then seek a divorce, and if granted, then the woman here, or the wife here, could rely on that divorce. She believes that she is already free. Because it would be unfair if the Filipino who obtained divorce is free to marry without incurring any criminal liability. But the wife who is in the Philippines, if he maintains or lives with another man, he is not free from criminal liability for adultery. That there is inequality in that situation. But there is now a recent decision on that point. If the Filipino husband secures nationality, American citizenship first, and thereafter obtain divorce, then if that divorce is valid, the wife in the Philippines could already marry legally or even maintain a relationship in a common law or live-in partner relationship without incurring criminal liability. But not before obtaining the citizenship, the U.S. citizenship. Mere divorce there will not give the wife here the right to marry subsequently or even have a relationship with another man. Because in the eyes of law, that divorce has no effect in the Philippines. It is void. It is not recognized. In concubinage, there is also that legal possibility that the other woman could be acquitted. If the woman successfully proves that he does not know that the married man or that the man with whom she lived with is a married man. Mas madaling paniwalaan ang single ang mga lalaki. Kasi matalim ang dila nila. Matagal na akong nabalo. At ako'y malungkot na sa buhay, kaya kita minakay. Naniwala si Chicks. Pero yung pala, nandun pala yung asawa niya. Hindi pala naman. Yung iba, sa ibang mga kalalakihan, marami na beses na namatay ang mga asawa nila. All right, rape is no longer included in this title. Republic Act 83-63, the new rape law, transformed rape from crime against chastity to crime against person. Previously, when a woman was attacked surreptitiously and by means of treachery, and the man succeeded in having sexual intercourse with her against her will by means of violence or intimidation, the treachery there would not be appreciated, even if it is clearly established by evidence. Why? Because treachery applies to only one classification of felonies, and that is the crime against person, or crimes covered by Title 8. All other crimes, treachery could not be applied. But now, since rape has become a crime against person, in that same case, where treachery was not appreciated by the court as an aggravating circumstance, it could now be properly appreciated because rape is now a crime against person. Then we have acts of lasciviousness. Now, this acts of lasciviousness is committed by any person of either sex against person of either sex also. To acts with due design, short of sexual intercourse, under the same circumstance as in the commission of rape, like where there is false intimidation, the victim is deprived of reason or otherwise unconscious, or the victim is below 12 years old. Noong araw, wala pa yung fraudulent machination, wala pa. Bago lang yan dito sa ating Article 266-A on rape under Title 10 at Title 8 of the Revised Penal Code. So there was once a bar examination question during our time when a pretty girl was at the Luneta waiting for a ride. And these three young men on board a top-down car. Apparently, they belong to a scion of 20 family. They pulled over and talked to the girl, invited to her base snack, and then the invitation was accepted. They went to the restaurant along Rojas Boulevard and drink a little. Afterwards, they brought the girl to an hotel. And when inside the hotel, induced because of the pretty girl, the pretty face, they began molesting her, removing her clothes one by one, until they discovered that the man also has a penile instrument like him. What is the crime committed by the three? Marami ang nag-answer, impossible rape. But the correct answer is Article 336. That is act of lasciviousness. It is committed upon persons of either sex. So even male could be victim of acts of lasciviousness. Ang nakakatawa dyan ay kung ang babae ang accused at ang lalaki ang victim ng acts of lasciviousness. That is possible under this provision of law. Then we have this crime of qualified seduction, where the victim is above 12 but below 18, of good or a woman of good reputation. Now, when the law says the victim should be a virgin, it does not mean that she is always physically virgin. She is not what in Latin called virgo intacta, which is comparable to a virgin forest that has not been explored. That is not the meaning of virgin under the provision of law. It is not that the woman is morally virgin. Because a woman may have had sexual intercourse with a man
victim, for instance, of rape. Physically, she is no longer virgin, but morally, she is still virgin. And in one decision, the woman is still virgin if she had only sexual intercourse with her boyfriend and not to any other man. And how is qualified seduction committed? It must be by abuse of authority, abuse of confidence, and because of relationship. When the seduction is committed by ascendants on a descendant or a brother against the sister, the age is immaterial as well as the reputation of the woman. That is qualified seduction because the crime was committed with abuse of relationship. But in the case of abuse of confidence or abuse of authority, the girl must be about 12 but below 18, who must be morally virgin or with good reputation. Now, in simple seduction under Article 338, there is only one way of committing the same. The victim is also above 12 but below 18, who must be single, or even if widow, she is of good reputation. That she had sexual intercourse by means of cajolery or deceit. In your study of Book 2, your professor will tell you that the form of cajolery or deceit is always promise of marriage. So if the woman submits herself, although voluntarily, because she was induced by the promise of marriage, but thereafter the man reneges on that promise, then the crime committed is simple seduction under Article 330. Now this reminds me of a case that is cited in your book, the case of People versus Hernandez. The victim of seduction was a woman whose age is only about 16 years old. She happens to be the daughter of the landlady of the boarding house where the accused was a boarder. The girl was infatuated with a man who was a young and dazzling and handsome man. And the man was very aggressive. Knowing that the girl is flirting to him, he immediately grabbed the opportunity, courted the girl, and after a short while, they are already sweetheart. But the man was too aggressive. The accused wanted to know how much the girl loves him. And the girl every time would answer, ilang beses ko ba sasabihin sa iyo na talagang tunay na mahal kita? And then the man said, no, that is not the way of proving your love to me. You better go with me. And then, let's have sexual intercourse. But the young woman said, no, I will not surrender my virginity unless we marry each other first. And so the man answered, all right, pakakasalan kita sa lahat ng simbahan. Mamili ka. And then the girl said, all right, ikaw na mag-arrange. So the man, the accused, contacted his friend and instructed him to borrow the uniform of a priest and memorize some passage or the passage that is said usually by a solemnizing priest during marriage. The man was a little bulky, that's why we shall call him meanwhile as Father Damaso. So the appointed time for the appearance of the sweetheart came, together with the respective ninong and ninang. And so after saying the usual passages in the celebration of marriage, they were pronounced man and wife. So the solemnizing officer, although he was a posure priest or fake priest, said, all right, kiss the bride. Oh, mabilis pa sa alas 4, kiss the bride. pikit mata pa ang babae, halikan. Afterward, they had a short dinner and then retired to a room in a biglang liko. And they stayed there for several hours until the next day. When the girl went home, she was confronted by the mother. And so she could not lie to her mother anymore. She relayed what happened, that she was married to the man, and everything that married couple do is already over, finished. And so it infuriated the mother. He went around to find out that there was really a marriage that was celebrated between her daughter and the mother. Certification issued by the Registrar of Deeds showed that no person by those names had ever been married or whose marriage is registered in the civil register. That's the filing of the case. What is the case? Simple seduction. But the one who posed as priest was charged with usurpation of authority and official function under Article 177, because he usurped the function of a administering priest. And so the man was convicted of simple seduction because of the promise of marriage. Now, if this case happens now, what will be the crime committed? Well, it is rape, because the third circumstance is present. There is fraudulent machination. Imagine having a posture crest just to prove to the girl that he loves her only to bed her, and she succeeded. And he succeeded in having sexual intercourse with the girl because of that deceit or cajoling. Simple seduction was the crime before, prior to the effectivity of our Republic Act 8363, because there is no yet that circumstance of fraudulent machination before. So that is now a case which could constitute rape under the third circumstance as provided under Article 266-8, paragraph 1. Now, in the case of corruption of minors, those who shall corrupt minors in order to give, to satisfy the lust of another, parang ito walang pinagibhan sa bugaw. Gumawa sila ng mga minors so that the lust of other person could be satisfied. That is the crime under Article 340. You know that will also constitute violation of Republic Act 7610, child abuse. But you know, in the on Thursday tomorrow, perhaps I will lecture on you those provisions concerning child abuse, and there are several provisions of law. Apat na yata yung provision ay yung special law that pertains to minors. Iba-iba ang definition nila. Iba-iba ang definition. Siguro, mas magandang pakinggan yun para magkaroon na kayo ng idea tungkol dito sa mga special laws dito na isinama ni Justice Abad doon sa inyong syllabus for this year's bar examination. Then we have white slave trade, Article 341. This is different from slavery under Article 272. In slavery, the offender kidnaps, buys, sells any human being, that includes a woman, of course, for the purpose of enslaving the victim. Or if she is a woman, if she is consigned to sexual exploitation like prostitution, it merely becomes an aggravating circumstance in the crime of slavery. But here, while slave trade, the offender engages women in order to, for the business of prostitution. He engaged in business of prostitution. And there are 3 acts that are punishable here, but it is easily understandable. There is no necessity of habituality. It is not that the offender there recruits these women in order to engage in prostitution. Then we have this crime of abduction. Abduction is of 2 kinds: forcible abduction and consented abduction. How is forcible abduction committed? When the woman is forcibly taken with due design. When, for instance, a college girl is coming out of the gate of her school, her college, her university, and then a man grabs her on her arms and try to pull her inside his car. He was seen that while pulling the woman, he is already kissing her, touching the breast and other private parts. This is an indicia of due design. So that forcible taking of a woman, of that woman in that fashion, is forcible abduction. If, however, the woman is raped afterwards, then it will become the crime of forcible abduction with rape, a complex crime under Article 14. The commission of forcible abduction was an easier means to commit rape. But if the purpose of the abductor is really to rape her and no other, then the Supreme Court ruled that the crime is rape and forcible abduction is absurd. In one case, the girl was abducted with due design, placed her inside a van. At the back of the van, she was raped. Then she was brought in other places, Valenzuela and Pampanga, and then in Bataan. In all these 3 places, the woman or the victim was raped by those abductors. For what crime or crimes shall these abductors be charged with? Shall it be several counts of forcible abduction with rape? Because the woman was brought in 4 different places where rape was committed. Now, the Supreme Court in that recent case held that there shall only be 1 count of forcible abduction with rape. The rape that was committed shortly after the forcible abduction shall be the one to be considered as a complex crime of forcible abduction with rape. Those succeeding rape shall be considered only as 1 count of rape in every place where she was subsequently raped. So if there are other 4 counts of rape after the first rape, then forcible abduction with rape, the first. Then 4 separate counts of rape for those other rape that was committed or that were committed by the offenders. You know this case of People versus Laranaga, the grandson of the late President Osmeña, who together with several others, young men, some are already matured, but majority are still below 21 years old, while the 2 pretty co-eds in Cebu City were waiting for the ride. They both were chanced upon by the group of Laranaga. So they forced the 2 girls inside their vehicles and they began molesting them and brought to some other places. And the two women were first forced to dance before them naked. Then later on, they were raped by the same group. One of them was thrown into a ravine, and the other one, the body could not be found anymore. Her whereabouts is still unknown up to the present. Only the other one was recovered but was already dead. Now, what is the crime committed? Then the Supreme Court ruled that it is kidnapping with rape, thus justifying the penalty of death to some and to those minor, like in or reclusion perpetua, like the case of Laranaga, who was a son of Laranaga, a Spanish. And Laranaga, while serving sentence in Muntinlupa, was petitioned by the parents with the official imprimatur of the Spanish government that Laranaga be brought to Spain so that there he could serve his sentence, which was granted by our government. Laranaga is now in Spain serving sentence for the crime of kidnapping with rape. I told Justice Angelina Gutierrez de Pudente, because that was given in the bar examination when she was the chairman. I told the good justice, why is it that the offenders were convicted of kidnapping with rape? Is it that if the woman was forcibly taken and there was due design, that should be kidnapping? I mean, forcible abduction, and subsequently she was raped. That should have been the crime. And the fact that she was killed, it could be homicide with rape, or rape with homicide, when the victim is killed. Sabi niya, ay hayaan mo na yan na piskal, sabi sa akin niya. Pareho rin naman ang penalty, kahit na alin dalawa. Hindi, alam mo, justice, magaling din yung malaman namin kung ano talaga ang dapat na proper crime. Although tama naman na pareho ang penalty. Kaya lang ang problema, paano namin ipapaliwanag yan sa ating mga estudyante? Ako, ang paniniwala ko dyan na it is forcible abduction. With rape. Pero pinatay, siyempre may rape with homicide, penalty of death rin dahil yun ang qualified rape. And forcible abduction may be considered as already absorbed by that. Pero hindi na kami nagkaliwanagan ng justice nun unless there is a future case that will happen where the Supreme Court could again pass upon and compare the factual setting in the case of Laranaga, whether they will make some amendments to their original decision or maintain that original decision as the case is. Now, if the taking, although possible, the main purpose of the abduction of the woman is to deprive her of liberty, then that will be kidnapping. The main purpose will determine what is the crime to be. If the purpose is to deprive her of liberty, then that will be kidnapping. If in the course of detention she is raped, then that is qualified kidnapping and the penalty is death. If the victim is forcibly taken away, brought to the house of a man, the man who is courting her, both of them being single, there is no legal impediment for them to marry. The main purpose of the man is to compel her to marry him. That is the purpose of detaining. What is the crime committed? The Supreme Court had held it is grave coercion. Because there is no other purpose on the part of the man except to compel her to do something against her will, whether right or wrong. Both of them being single and no legal impediments for them to marry. But if the man is already a married man, then it would be a different thing. It will be kidnapping because there is no possibility of him getting married to the woman because he is already a married man. Okay, let's have a short break. Short break. Then I will continue. Alam niyo ba ang tawag sa Nipongo sa rapist? Biakero. And the victim of rape in German, Rockenheimen. All right, Article 343, consented abduction. Here, the victim is a minor, above 12, but below 18. She must be good reputation, and the taking of the woman must be with due design. There must be participation on the part of the offender, which induced the young woman, the victim, in coming with him or leaving the house. Because if the situation is they are sweetheart, but they came home from the movie house a little late, so it made the parents angry, and they punished the girl. The girl rebelled against the parents, and then he runs away. And the only house he knows where to go, she knows where to go, is the house of the boyfriend. So she stayed there. The parents of the boyfriend was persuading the girl to go home because it is not good, it is wrong, being a minor, running away from their parents' house. But the girl could not be persuaded. She threatened the boyfriend and the parents, sige, pag ako'y pinalis nyo rito, magpapakamatay na lang ako, ay sasama na lang ako dun sa mga kung sino-sino lalaki dyan. Until the parents were able to trace the house of the boy. Then they charged the boy with consented abduction. Now, while the lower court convicted him of consented abduction on appeal, he was acquitted because the girl testified that on record that there is no participation whatsoever on the part of the boyfriend. There was no inducement on his part that she leave the house. It was voluntary on her part to go to the house of the boy. So the boy was acquitted. The accused. Now, is there such crime of consented abduction with rape? Yes. In forcible abduction, there is rape. It is also true with respect to consented abduction. When she consents to the abduction of herself, it doesn't mean that the man could just force himself into her. So if the boy with whom she eloped would force himself into that woman, and such act will fall under any of the circumstances of rape under Article 266-8 paragraph 1, then it shall become a complex crime of consented abduction with rape. Now this provision relative to the crimes against chastity, prosecution of the crimes of adultery, concubinage, seduction, abduction, and acts of lasciviousness. Rape should be excluded already from the provision of Article 344. Because if you remember your Article 89, it says marriage also will extinguish the marriage by the offended party to the offender extinguishes the criminal liability of the principal as well as the accomplices and co-conspirators. But that particular provision of Article 344 will no longer apply to rape cases. Why? Because Article 266 kasi provides now marriage, which is a cause for extinction of criminal liability. But it will only extinguish the criminal liability of the offender who marries the victim or the offended party. It will not inure to the benefit of all others, unlike under Article 344. Now, this procedure in the prosecution is also found in Section 5 of Rule 110. Who shall prosecute the criminal action? In that Section 5, it enumerates what are stated in this Article 344. In the case of adultery and concubinage, in the case of adultery, only the offended husband could institute the criminal action. In the case of concubinage, only the offended wife, no other person could institute the criminal action. In the case of concubinage, seduction, abduction, and acts of lasciviousness, well, the victim herself should institute the criminal action, except in the case of minor, if she suffers from disqualification or any causes other than being a minor, then the parents could file the complaint against the offender, any of the parents. In the absence of the parents, any of the grandparents. In the absence of the grandparents, then the guardian. In the absence of all of them, then the doctrine of parens patri will apply. The state would assist the minor victim of this crime to institute the criminal action. Can these minor offenders or minor victims can they pardon the offender? Now you see the Supreme Court said, if it is a minor victim and she pardons the offender, it is not effective unless it has the concurrence of the parents. On the other hand, if the parents pardons the offender but without the concurrence of the minor complainant, will it be effective? It will only if the minor offender is incapable of giving consent to the pardon granted by the parent. That is, if she is suffering from some mental aberration or defect, which make him unable to agree or consent to the pardon. Now, with respect to the civil liability of persons guilty of this crime, assuming that in this seduction and abduction, that is the civil liability, then the civil liability for damage, and if there is a child born out of them, then to acknowledge the child, except when there is an impediment for such acknowledgement. Like, what about if the victim is the victim of multiple rape or multiple seduction, and there are several accused? Can all of them be ordered to acknowledge the child that is born out of that criminal act? The answer is no, because it's difficult to prove the filial relation of the child. Who among those four who had sexual intercourse could be the father? But in that case, they shall be ordered to support the child. You know, merong advantage kung sakaling pinapayagan ng batas na lahat yung nang-rape ay acknowledge. Kaya lang, may disadvantage. Ang advantage doon sa bata, Bay maraming magbibigay ng baon sa kanya. Apat ang tatay. Ang disadvantage naman doon, mahihirapan naman yung bata. Papapagod sa kamamano. Sa apat na ama. Now let's go to these crimes against the civil status of persons. Now, simulation of birth under Article 347 and usurpation of civil status, these are crimes that are punished because the purpose is to lose the civil status of a person. Like for instance, the simulation of birth. There is no need of further and clear explanation on how this happened or how this crime be committed. Let's just take this example. A and B are married couple, Mary and Peter. But they're already married for 10 years. They were not able to have a child of their own. So they finally decided to adopt. But before they go on the to go to the adoption, to the orphanage, one morning, they heard a knock on the door. When they opened, they see a very young, unwed mother carrying a child and begging that she be given a little amount of money because she is going to her home province. She was deserted by the boyfriend, who doesn't want to face responsibility. And upon knowing that she is about to give birth, the boyfriend disappeared and could not be found anymore. So she is left to fend for herself. She has no means with which to support the child. So she said, Ma'am, pwede po ba? Itong bata na ito, ampunin na lang ninyo. Bigyan na lang po ako ng kaunting pera o uwi na ako sa aking probinsya. So, sinabi niya sa kanyang asawa, Daddy, siguro ito ang hulog ng langit sa atin. Sige, tanggapin na natin yung baby. So, binigyan ng small amount na 5,000 pesos for her care going back to her province. And so, what the couple did, called on their friends who is a comadrona and instructed that she produce this form of birth certificate. It was filled up. They made in the blank for parents, they placed their own name, Mary and Peter. And in format is the comadrona. Now, what crime or crimes were committed by all the three? By all of these three. Now, it is violation of the provision on simulation of birth because they made it appear that the child is born out by the wife, which is not true. And by doing so, the true civil status of the child is lost because the civil status should be that of the son or child of that young unwed mother. But once they register this by simulation of birth, then the child becomes the child of this married couple, and that is punishable under that provision of law. When it comes to substitution, another amusing illustration so that it could not need further explanation. Armand Pabella Memorial Hospital is the favorite hospital of unwed mother as well as the poor mothers who could not afford to give birth to a private hospital. Armand Pabella Memorial Hospital is a government hospital. Now there was a couple, the wife was about to give birth to their first child. So the husband, who is a gifted driver, immediately brings the wife to the Armand Pabella Hospital. But since according to the midwife, it will take a little time for her to get back. So the husband still proceeded to ply his road as passenger duty driver so that he could earn money. Now, in the evening, he went back to the hospital. He directly saw the wife and said, and asked her, "Where is our baby?" It is in the nursery. So he went there. But before leaving, paano po magkikilala yung ating anak? May lagay na tag yun. Pagpunta niya ron sa nursery, hinanap niya yung baby na may pangalan ng yung nakasulat na apelido niya. Nakita naman. Nung matitigan niya ang mukha, napangiwi siya. Ang pangit naman ng baby niya. Naluminga-linga siya, wala naman nakatingin. Ginawa niya yung katabing baby, nagwapo. Bigla niyang ginawa, nalis yung pangalan, inilagay niya yung kanyang anak doon. Pero inilagay niya yung pangalan ng baby. Di maganda, nagwapo na yung kanyang anak. Yan ang substitution of one child for another. Ganun lang kasimple yan, hindi kinakailangan ng mahabang explanation. Tsaka, medyo amusing pa, di ba? May example yun. Next, ito, maraming maaaring kasalanan nito, yung illegal marriages. Now, are there how many kinds of illegal marriages under this chapter, Title 12? There are three. One, Article 349, the crime of bigamy. Number two, the crime of marriage against the provision of our marriage law. And number three, that is premature marriage where only the wife, the married wife, could become an offender. In bigamy, this is a public crime. Any person could institute criminal action for bigamy against the offender. And how is bigamy committed? Then bigamy is committed when a married person shall contract a second or subsequent marriage while his first marriage is still subsisting. Or, in the case of absent spouse, that his presumptive death has not been yet declared. All right. The second marriage, in order that it may constitute as bigamous marriage, it must have all the requisite of the valid marriage, like the first marriage. So it's like this. The first marriage must have all the requisite of valid marriage. The second marriage that was contracted by the offender must have also the requisite of valid marriage. And this second marriage could have been valid were it not for the existence of the first valid marriage. That is how bigamy exists as a crime. Now suppose the first marriage is voidable, and in the belief of this married spouse that such marriage is without force and effect because it is void. He contracted a second marriage. Can he be guilty of bigamy? That is the first situation. Suppose after the second marriage, this married spouse files a petition for the nullity of the first marriage, and it was granted. Will this declaration of nullity of the first marriage cure his criminal liability for contracting the second marriage? The answer is no, because one of the elements is that before somebody could marry subsequently, he must first secure the declaration of nullity of his first marriage under Article 40 of the Family Code. No one under the Supreme Court decision has the authority to interpret the validity of his or her own marriage. It is only the court who can make that declaration. So for purposes of contracting second or subsequent marriage, while the first marriage is subsisting, to prevent prosecution for bigamy, the first thing that this spouse should do is cause first the declaration of nullity of the first marriage. His honest belief that this void will not cure the criminal liability already incurred if he marries without securing the declaration of the first marriage. But there is only one exception. The case of People versus Marego, which was decided by the Supreme Court sometime in February of 2004. How did it happen? Now, the first marriage was contracted by the man, by the husband. But you know, there was no officiating priest. There was no marriage license. The parents agreed that the daughter and the groom shall marry each other. And so, the contracting parties signed the marriage contract together with their respective principal sponsors. So they live together now as husband and wife. Later on, the husband marries for the second time without securing the declaration of nullity of the first marriage. The accused was convicted of bigamy. So he went to appeal. And on appeal, the Supreme Court reversed the judgment of conviction. Why? Because in order that the provision of law requiring that there shall be a declaration of nullity before contracting a second marriage will not apply in this particular case. Because the Supreme Court said there was no marriage to speak of. It was merely an agreement signed by them without the presence of any solemnizing officer, without even marriage license. There is no marriage to speak of. Therefore, there is no void or voidable marriage to declare, because there is no marriage at all that has taken place. So the accused was acquitted. But it's merely by way of exception. If the first marriage has all the requisite of valid marriage, and the second one also has, and there was no declaration of nullity of the first marriage, the husband or any married spouse who contracted a second marriage could not escape the criminal liability for bigamy. Even if subsequently, by reason of his filing or her filing of the first petition for the nullification of the first marriage, even if it is granted, the criminal liability is already there. It could not be cured. It could not be cured. Now, suppose this couple on the second marriage, after the marriage, they went on honeymoon. For 3 months, they went to El Nido Beach in Palawan. They stayed there for 3 months. Medyo mahabang honeymoon yun, ano? Now, you will be asked what crime or crimes were committed by the contracting party in the second marriage. Okay, the answer would be, with respect to the marriage, certainly, they are guilty of bigamy, assuming that even the woman knows that if the woman does not know that the man with whom he contracted marriage is already married, then she will not be guilty of this crime. But if she knows that she is already married, then the woman could be convicted as an accomplice to the crime of bigamy. Now, aside from bigamy, the husband could be charged by the wife of the crime of concubinage, together with the concubine, because no institution of criminal action or concubinage will prosper unless both offender is included in the complaint, if both are still alive. Of course, the girl could always put a defense that he has no knowledge that the man to whom he got married is already a married man. That is only a defense. Alright, what of cohabitation was committed by the married husband? That of cohabiting with another woman in some other place as husband and wife. There is considerable time of cohabitation during that honeymoon, 3 months. That is sufficient to comply with all the elements of the third act of concubinage. Suppose the woman with whom he contracted the second marriage
is also a married woman but had been legally separated from her husband for more than 3 years. The husband learns of the second marriage of his wife with that married man. Now, what crime or crimes would be charged against both? Of course, both are guilty of bigamy. Bigamy, independently of each other, they could be held liable for bigamy. Since it is the husband of that legally separated woman who shall file the charge, then she could charge both the couple in the second marriage the crime of adultery because it falls under the provision of Article 333. A married woman having sexual intercourse with a man, not her husband, and by the man knowing her to be married. That is the crime. With respect to the crime committed by the husband, it is only the wife who will file the complaint. Then it shall be bigamy also. And in addition, both will be charged with the crime of bigamy, meaning adult concubinage, because the married woman, the married man has cohabited with another woman in some other place for some considerable time. Of course, in adultery, there is already sufficient circumstantial evidence that they had sexual intercourse with each other. By the fact alone that they got married and then went to Boracay on honeymoon for several months, you wouldn't say that there was no sexual intercourse there. That is already strong circumstantial evidence that there was sexual intercourse between the married woman and the other man who is not her husband. That should be the way it should be placed in your answer. Or it is the way you have to analyze the problem and think of the proper provision of law that applies to a situation like that. When you are paid to select the best answer or the correct answer for what crime will they be properly charged under that set of facts. Now, with respect to marriage contracted against provision of laws, all right, the first marriage is valid. It has all the requisites of a valid marriage. But the second marriage was contracted. The marriage license was issued by the office of the local civil registrar 2 days after the celebration of marriage. Now, what is the crime committed by these offenders? Then it will not fall under Article 349 on bigamy, because not all of the requisites of valid marriage are present in the second marriage because of lack of valid marriage license at the time the marriage was solemnized. And since it lacks the required marriage license, certainly it will fall under the provision of Article 350, that is marriage contracted in violation of our marriage law. And so thereafter they went on honeymoon. Baguio, they stayed there for 2 months. Now, what crime or crimes were committed? Don't say that the crime committed by the husband is bigamy. That would be wrong. It is not bigamy because the second marriage did not have all the requisite of valid marriage by reason of the absence of a valid marriage license at the time of the solemnization. So the other crime, the first crime of the husband is violation of Article 350, which is marriage contracted in violation of the marriage law. Then what other crimes? Then he will be charged also by the wife for concubinage, for having had a cohabitation with the other woman in the concept of husband and wife. So both of the couple who married each other without defect in the marriage contract will be both charged of the crime of concubinage. And assuming that woman is also separated only from her husband and who discovered the second marriage,
then the crime is also violation of our marriage law for lack of the necessary requisite of valid marriage. And what will happen to the judge or priest or municipal mayor who celebrated the marriage knowing that there was absence of one of the essential requisites of valid marriage? Then he will be charged under the provision of Article 352, performance of illegal marriage ceremony. That is the crime committed by the officiating priest or officiating officer, the mayor. There are only some instances where marriage license is not necessary. That is, marriage in articulo mortis, and when the couple are already living together as husband and wife for 5 years or more, there is no more need to apply for marriage license. What is only important is to execute the affidavit, which is also appearing in the form for that purpose in the civil registrar. Nakalagay na doon yung affidavit, ipirmahan na nila, then paste that under oath. That is already equivalent to marriage license. Now, with respect to the premature marriage, when the widow marries before the expiration of 301 days from the death of her husband, then that is the crime committed, premature marriage. Or when their marriage is declared void, if that married woman marries before the expiration of 301 days from the finality of the judgment of declaration of nullity, then it is the crime, premature marriage. The man with whom she got married, even if he has clear knowledge that the marriage was before the expiration of that 301 days, could not be made liable for violation of this article. It is only the married woman who shall be offender in this third kind of illegal marriage. Now, what is the purpose why the law requires that there should be no marriage before the expiration of 301 days? It is in order to prevent the confusion as to the paternity of the child that will be born within that period of time. So it is the purpose of the law under the provision of Article 351. If you happen to be a lawyer already, passing the bar this year, and then subsequently there is somebody who hires your services in order to defend her and the charge for premature marriage, because the facts of the situation is that this woman who became widow was already 7 months pregnant at the time the husband died. And so subsequently, about weeks after the death, out of pity, the neighbor offered marriage to her so that the widow would have the help in fending off for herself as well as for the children, including the child that will be born later. Now, could you secure her acquittal on the charge? Well, it is clear that it was before the expiration of 301 days. Yes. How? By invoking the defense that since the purpose of this provision in Article 351 is to prevent the doubtful paternity or confusion as to the paternity of the child, then there is no more confusion that will arise from the fact of the situation, because when the woman is already 7 months pregnant, yung ba namang fetus na yun, madagdagan pa ng ibang figure, galing doon sa kanyang mga papangasawa muli, magkakaroon pa ba ron ng confusion as to the paternity? No, no. It is considered that that child to be born is the son of the late husband. So that would be the argument by using the purpose of the law why premature marriage is prohibited before the expiration of 301 days.
Now, I told you that when a solemnizing officer solemnizes the marriage, he has a general power to solemnize marriage. But the specific authority to solemnize marriage between the contracting parties is the marriage license. Marriage license. The priest have that general authority to solemnize marriage. Also the mayor, or ship captain, as the case may be, or any religious sect where their pastors or reverends have given authority to solemnize marriage. But they could not just solemnize marriage without the issuance of a valid marriage license, except in those cases that I mentioned, articulum mortis, or when the couple had been living as husband and wife for 5 years or more. In all other cases, there should be a valid marriage license to be secured, and which marriage license should be applied before the office of the civil registrar. And normally, it is published for a period of 10 days. If it is on the 11th day that this marriage license is issued to the applicant, this should be presented to the solemnizing officer, and that will give him the specific authority to solemnize the marriage between the couple. Now, if it is done, if the celebration is done before the issuance of the marriage license, then the solemnizing officer, if he were a municipal or RTC cards, there is already precedent that he is subject to administrative charge, suspension of suspension from office, sometimes 3 months or 6 months as the case may be, short of dismissal from the service. But if he does it repeatedly, then probably he shall be dismissed from the service, because in the first conviction for that administrative charge for performance of illegal marriage ceremony, there is already a stern warning. A repetition of the same will justify a more severe sanction against him, and that could be dismissal already. Now, it could not be a crime of usurpation of authority or official action, because they are actually persons or public officers authorized to administer the solemnization of marriage. But if a person merely falsely represents himself as a priest, so he becomes a pure priest, a private individual who is not a priest, but who pretends to be, and he solemnizes marriage, then he will not be guilty under this provision of Article 352. Rather, it may fall under the provision of Article 177, which is the crime of usurpation of official function or usurpation of official authority. There was this anecdote of legal separation. Because of irreconcilable differences between the husband and wife, they decided that it shall be the end of the relationship. So the wife filed a petition for legal separation. But there was cooling off period in the judge summoned them. Pwede ba pag-usapan na lang niyo ito? Alam niyo naman ang batas. Napakahigpit. They wanted to maintain marriage as a social institution. And it is always to the benefit of the family that parents should not separate and then help each other in rearing the children. That is good, sabi nga naman ng babae. Pero hindi na po kami pwedeng magkasundo ito. Alright, isa pa, mahirap kayong kapaghiwalayan. Paano kung meron kayong mga ari-arian na paghahatiin? Mag-aaway kayo. Ay, wala na pong pag-aaway dyan. Dalawa lang pong piraso ng lupa namin, pare-parehas ang area. Hindi na po kayo magkaroon ng diferensya. Eh, may mga anak kayo, sabi niya, ilan ba ang anak niyo? Sabi doon, tanong sa babae.
Eh, 3 po. At dyan tayo mahihirapan. Paano mahahati ang 3 anak? Sabi nga doon. Okay, mabuti pa, mag-uling period muna kayo. Magsama muna kayo ng 1 taon. At baka sakaling magkaroon pa ulit kayo ng 1 anak. By the time you come back to me, 4 na ang anak ninyo. 2 sa kanya, 2 sa iyo. Ay, hindi po mangyayari yan, Your Honor. Hindi na po ako papayag. Eh, bakit iha? Sabi niya gano'n, apa, kung ako po'y umasa lang sa estupido kong kasawa, ay di wala kaming 3 anak ngayon. Oh. Alright, we will continue tomorrow. I will touch on the crimes against honor, and relative thereto, I will discuss to you also the preference in the imposition of penalty and libel based on the recent Supreme Court Administrative Circular. You know, I came late because I woke up from a little groggy feeling. I was overworked. I lectured up to 9:30 last night, starting at 5:30. So perhaps I was overworked. And I will announce that this afternoon session, when pushed through, I will have to consult my physician. You know, it's one of the things that I'm afraid of, seeing a doctor, my physician. Lagi na lang na mga bagong sakit na nakikita. Pero what I dreaded most is, let's say when he will tell me, attorney, I'm sorry to tell you, but yours has reached a lobat. Lobat. You know, I am sad to tell you that your penile instrument is already with lobat. And I dread that. Imagine, naalala ko tuloy yung istorya tungkol sa isang mama. Ganyan na nangyari. Permanent erectile dysfunction. So, pag uwi niya, malungkot siya punta sa isang sulok ng bahay nila. Tapos, tinignan niya yung kanyang pinag-instrument at nabalungkot niyang sinabi, Tol, bakit ka naman ganyan? Pinunahan mo akong mamatay. Sabay lang naman tayo ipinanganak. Alright, we will just finish the topic on libel. And tomorrow, we will wind up in the morning all the special plenarons. And in the afternoon, we will have that drill on multiple choice question exam. With, of course, explanation as to the correct answer. I know many of you have not had experience yet how to answer multiple choice question. But those who are fresh graduates, I know very much that the last 2 semesters of their 4th year, they have already experienced this multiple choice question style of bar exam. Now, libel in the article 323, you know that libel there is not the correct translation from the Spanish text. Because what is stated in the original Spanish text of our Revised Penal Code is defamation, meaning defamation. And in one bar examination pertaining to this libel, the question asked is, what is defamation? And what are the 3 forms of defamation? You know, the answer should be that defamation is the public and malicious imputation, of course. The definition is correct. But with respect to the 3 forms of defamation, number 1 is the libel, which is defamation in writing or by means of printing, publishing, or those that are uttered in over the radio. What about those uttered
on television. You know, if you will examine the provision on libel, there is no mention of television because at that time there was no television yet. But the enumeration of those means by which the defamation shall be considered libel includes and other similar means. So in the rule of interpretation, it is used then generis. If there is a general statement meaning of similar nature, then television is also included there. Now, the second form of defamation is the so-called slander, which is of two kinds. The grave slander and simple slander. And last one is the defamation, which is what we call slander by deed. Not by words, not by writing, but by means of act. By means of act. Those are the three forms of defamation. Strictly speaking, it will follow the original text of our revised penal code in Spanish. Then how is libel defined? It is the public and malicious imputation of any crime or vice or defect, whether imaginary or real, any act or omission, or condition or status or social circumstance which cast dishonor, discredit or contempt of any person, whether natural or artificial, or shall blacken the memory of one who is already dead. That is exactly how libel is defined under Article 353. It is not only a natural person who could be victim of libel, because it says artificial person, meaning those corporations or entities that have separate personality from their members. And then we have even dead person. If the defamatory statement concerns the blackening of the memory of one who is already dead, that is also defamation. Now, to be able to answer whether a certain publication is defamatory or not, you must be familiar with the complete elements of the crime of libel. What are the complete elements of libel then? Number one is there must be an imputation. And that imputation must consist of a crime or any vice or condition or defect or act or omission which shall cast discredit or say that the imputation must be made public. So that is the element of publicity or publication. And it must be malicious. So that is the element of malice, which is of two kinds, malice in law and malice in fact. What do you understand by malice in law? That malice that is already presumed from the defamatory statement. It does not require open presentation of proof to establish the same. What is malice in fact? That is actually actual malice. Actual malice or malice in fact requires proof to establish that the purpose of the author of the defamatory statement is to destroy the integrity, the reputation of the offended party. And then lastly, that the victim must be identified or at least identifiable. Now, there is no problem in understanding that last element. The victim must be, or the offended party must be identified. If there is defamatory statement in writing and the name is expressly mentioned, then that is identified victim. But if it is only a description of a person to whom the defamatory statement is alluded to, then he is not immediately identified, but only identifiable. Who could identify the victim? Of course, himself or any other third person. If the victim himself is the only one who could identify himself, then there would be no actionable libel. There must be a third person who have read that defamatory publication who is able to identify that the victim is the object of that libelous statement. So, if it is only the offended party who claims to have been libeled, who could identify himself, then that libel charge against the offender will not prosper. Now, this element of publicity or publication, what does it mean? It means that there must be a third person who could have read that libelous statement. That is the meaning of it. So, between the offender and the offended party, there must be an additional third person to make it satisfy the requisite of publication or publicity. And there are already many cases. If a letter defamatory of somebody is sent through mail inside an envelope, but it is not sealed. Now, even assuming that there is nobody who is proven to have read that, there is already element of publication, said the Supreme Court, because the fact alone that this envelope containing the letter, which is defamatory in character, there is already presumption that persons could have read other than the addressee. Now, in one case, a lawyer, Attorney Piernes, was the object of a libelous statement in a letter, which is inside the envelope, and then given to the wife. It says, "Attorney, you are Satan. Your English is Carabao English," and so forth and so on. So he was object of ridicule by his coming from his wife himself and the children, his children. "Daddy, ginagago ko naman yung tao niya." That was the comment of the children. Now, of course, Attorney Piernes read the letter when it was given by the wife. And so he proceeded to institute a criminal action for libel. The author of the letter was convicted, but he claimed there is no publication, he said, because it was only the wife to whom the letter was given. And the Supreme Court said, for purposes of understanding the element of obligation, wife is a third person, which will qualify to testify that there was a libelous statement made on the victim. Even if the letter, for instance, is addressed only to another person, a private communication, but it contains defamatory statement against a third person, not the addressee of the letter. If the third person learns that there was defamatory statement written in that letter, then there is also an actionable libel. The person to whom the letter is addressed in the envelope is already considered a third person. So there is publication. The action for libel will prosper. The action for libel will prosper. Now, with respect to this malice, there is the so-called privileged communication, absolute privileged communication, and qualified privileged communication. What do you understand by this absolute privileged communication? This is communication that could not be subject of actionable libel. Example, the speech or debate made by members of Congress in the halls of Congress. This could never be subject of prosecution because under the Constitution, the same libelous statement, even if it done with bad faith or with the intention to destroy the integrity of any person whom he libeled in the halls of Congress, that could not be questioned in any other place. Meaning to say, it could be subject only of investigation and disciplinary action of Congress exercising in its inherent power to discipline those members of Congress who have committed violation of the rules. But it could not be prosecuted outside of the court because it is absolutely privileged communication. Also, those pleadings filed in court, the defamatory statement made by lawyers in any particular case pending in court, as long as those statements are relevant to the issue in that case, that could not be subject of actionable libel. It is absolutely privileged. Now, those qualifiedly privileged communication, then we have those that are mentioned in Article 354. Every defamatory statement is presumed to be malicious, except the following. There are two paragraphs in Article 354. They are private communication by one to another and the exercise of legal, moral, or social duty. And number two, paid and true report made in good faith without commentary or remark of any official proceedings, whether judicial or legislative proceeding or other proceedings with respect to matters that are not of confidential character, or those conduct of those officers who participated in that proceeding. Those are qualifiedly privileged. Now, when it is privileged communication, it destroys the existence of malice. It could only be proven as malicious in disqualifiedly privileged communication when the complainant shall offer proof to show and establish that there was intent on the part of the offender to destroy the personal integrity and reputation of the offended party. Now, where shall be the venue for the execution of criminal action? You know, Frank Chavez, our former Solicitor General, filed a case of libel in Makati. You know, Chavez was a brilliant lawyer, master in English. Kaya kung siya ay nagsasalita sa husgado o kaya sa kanya mga pleadings, marami siya nagagamit na words na kung minsan hindi mahalata noong taong pinagpapatungkulan na yun pala ay libelous na or defamatory. Dahil magaling siyang pumili ng words na English. But he found a case of libel. Do you know that by mere technicality, he lost the case because of lack of jurisdiction over the case, the libel case. So there is requirement sine qua non before the court can exercise jurisdiction over the libel case filed before it. And what is the rule with respect to the venue for execution of libel cases, whether criminal or civil? Number one is, if the offended party is a public officer or a private individual, the action for libel may be instituted before the RTC of the province or place where the crime of libel was printed and first published. Printed and first published. That is where Chavez lost it. He said the information, but probably it is not the fault of Chavez. It was the fault of the information of the fiscal who prepared the information. Because while they state that the accused committed libel within the city and in the city of Makati and within its jurisdiction, it pays some effort to state whether it was first printed in Makati. Failure to allege that, the Supreme Court said, the court did not acquire jurisdiction because that is a condition precedent before the court could take action on the libel case filed against the victim. Also, when it's a private individual, even if the action is not filed in the court of first instance or now RTC of the province where the crime was committed, however, that private offended party institute the criminal action in the court of or the RTC of the province where he actually resided at the time libel was committed. So the place of residence of the victim is also a condition precedent if the publication is not done on Makati or it was not first entered in the place where the action was taken. And if the public officer holds office in Manila, then the action will be filed before the RTC of Manila. If he is a public officer holding office outside of Manila, then in the place or the court of first instance of the place where he is holding office. So these are the rules that must be remembered. Be familiar with all those rules with respect to the institution, venue, the rule on venue for the institution of criminal action. To repeat, if it's a public officer or any or private individual, action for libel could be instituted before the RTC of the province where the libelous publication is printed and first published. Or if he is a private individual, he could institute the action in the court of first instance of the province where he actually resides at the time the crime of libel was committed. Or if he is a public officer whose office is located in Manila, then before the RTC of Manila. Or if he is holding office outside of Manila, then in the court of first instance of that province where he holds office. That is the complete rule in the institution, in the venue for the institution of criminal action. Now, with respect to, there is one case about whether or not those two privileged communication in Article 354 are exclusive. Is there any other source of privileged communication? This is the case of Art Borjal, the late Art Borjal, who was a famous columnist in Philippine Star prior to his demise. There was column, several issues of Philippine Star where he had column. He made scathing criticism, which is amounting to allusion of commission of crime against a certain Frank Wenceslao. Frank Wenceslao is a private individual, but he is an executive director of a private organization who is working closely with the government for the upliftment of the transport industry of the Philippines. So because of that, he was able to generate public interest in him. He was able to secure contribution, funding from the business and government sector in order to pursue the objective and mission of that organization. This collection amounted to several millions of pesos, but the members are complaining because there was no accounting of the funds. They kept on sending letters and documents to Art Borjal, and Art Borjal made an expose of this. There was a scathing statement that the director, Frank Wenceslao, could have pocketed the money for his own benefit. So because of this repeated publication, Frank Wenceslao now proceeded to institute a criminal action against Borjal in the city of Manila. Of course, Borjal lost the case in the court of first instance because his defense merely is that I could not be charged of an actionable libel because my column is privileged. And the complainant said, no, that is not one of the privileged communication. Therefore, you could not invoke privileged communication. The court of first instance sustained the claim of the complainant. And then in its decision, he said the defense of Borjal is not meritorious because there are only two kinds of privileged communication under Article 354. It is private communication by one to another or paid in true report, made in good faith, without any comment or remark of any judicial, legislative, or other official proceeding which is not of confidential character. Since the column of Borjan does not fall under any of these two privileged communication, then he could not claim as a defense that his column is a privileged communication. So Borjan lost the case. He was made to pay several million, 5 million pesos as damages. So he went up on appeal. On appeal, the CA sustained the findings and decision of the court, the Federal Trial Court, that the defense of Borjan is not meritorious because there are only two privileged communication under the provision of the revised penal code referring to Article 354. So again, the aggrieved party Borjan in that decision went up to the Supreme Court. Now it is entitled Art Borjan, Arturo Borjan versus the Court of Appeals. And what did the Supreme Court do on appeal? The Supreme Court held it is grave error for both the RTC and the CA to conclude that there are only two sources of privileged communication. They are wrong in pointing to the two that are mentioned in Article 354 of the RTC, because the genesis of all privileged communication is found in the Bill of Rights of our Constitution, contained in the privilege and in the right of expression and the right to express their freedom of the press and freedom of speech. That is the genesis of all the privileged communication. So while it is not included in the two enumerated privileged communication under Article 354 of the RTC, it does not mean that there is no source. As a matter of fact, said the Supreme Court, the genesis of this privileged communication is found and enshrined in the Bill of Rights, freedom of speech and of the press. The citizens have the right to express their opinion on matters of public interest. Since the issue that was being addressed in the column of Borjan are matters of public interest because they pertain to the upliftment of transport industry. And moreover, even Francis Wenceslao is a private individual. He has become renowned and he has become and attained that public figure status. And if he is a public figure, he is like a public officer who must not be onion skin. And a public figure like a public officer must accept criticism because they made their life already subject of interest by the citizenry. As long as the alleged defamatory statement is about their official conduct, whether as a public figure or a public officer. Since it is a matter that the citizenry have interest, such criticism, although it may be ultimately been proven false, as long as the writer does not have knowledge of its falsity or that they are not recklessly imprudent in publishing it without knowing whether it's true or not. The Supreme Court said Mr. Borjan was not reckless because the basis of his criticism to the point that he is alluding commission of crime on the part of that public figure, Mr. Frank Wenceslao, it was well founded from the documents presented. It is based on established facts, said the Supreme Court. So there is no reckless disregard whether his criticism is false or not. And therefore there is no actual malice or malice. So this Borjan won the case before the Supreme Court. So he was no longer made to pay that huge amount as fine or the commission of the crime of libel. Now, the test of defamatory statement is not what the writer mean on what he has written. It is the belief of the readers by reading the defamatory statement, regardless of what is the motive or intent of the writer, as long as from the viewpoint of the reader, it is nonetheless or defamatory. It is the test of such defamatory information. Now, what is the nature of fair commentaries on matters of public interest? Of course, they are considered as privileged communication, and it could be a proper defense when charged of libel by reason of such fair commentaries on matters of public interest. Now, I have already mentioned to you about who is a public figure. Now, any person like Manny Pacquiao, because of what he had reached up to this moment, even without being a congressman, he became already subject of the focus of the interest of the public because of his achievement. He is now considered public figure, and he could not just easily complain about some criticism which he felt it was already defamatory, because he is already a public figure, subject of discussion in matters of public interest. Those actors and actresses, they are considered public figures. You know, there is one case which I think many of you have read, and because it refers to a popular figure in the movie land, like Christopher Min. You know, Christopher Min was charged of libel by the couple Annabel Rama and Eduardo Gutierrez, or Eddie Gutierrez, because in the column of a tabloid paper on and of which Christopher Min is the president and general manager, it was published that the couple had become fugitive from justice in the United States because they escaped prosecution from the alleged swindling cases filed by Filipinos in the States who were duped by the couple who was still engaged in the business of selling these expensive cooking wheels. So because of that obligation, this couple filed a case of libel. During the trial, Permin's defense was only that he does not know about the publication because he is only the owner and president and manager of the publication. She did not present any further evidence to exculpate him from criminal liability. So Permin was convicted of the crime of libel because under the provision enumerating who are the persons criminally liable for the crime of libel, they are those authors of magazine or pamphlets or papers, the authors of those that were published, or those who caused exhibition of those libelous statements, or the owner of the printing plant which publishes the same, and all persons who have participation in the publishing or printing thereof. The Supreme Court said when it was appealed to the Supreme Court, because he was already convicted of libel and was paid to pay the penalty of fine. Of course, there was no imprisonment that was held to be remitted to Christopher Min. The Supreme Court said Christopher Min could not feign lack of knowledge about the publication. He is the owner. of the printing press. He is the president. She is the president. And she is the general manager. She knows the day-to-day activity in the pay of her publishing company. So she could not feign innocence, but she does not know that such defamatory statement was published in her paper. Thus, she was convicted. Also, this Erwin said, mga public figure, mga artista naman yan, pwede naman sila samihan, i-commentary because they are already public commodities. But the Supreme Court said no. If it is concerning their official conduct, yes. But if it runs towards the personality, the private person of the victim, like for instance, charging them of having swindled several Filipinos and that they are fugitive from justice, that is a different thing already. It does not concern the official conduct of this public figure, the actor Eddie Gutierrez and the actress Annabelle. Kung yung sabihin lang nila na itong sila Eddie Gutierrez, hindi naman magaling na artista, pero kung mas taas na, kala na yung pinakamagaling na artista, nanloloko lang siya. Yan pwede yan, walang malis yan. Because it concerns their official conduct as actors and actresses. But if it is a private individual, it's different. If it runs to the very privacy of their life, this defamatory statement, then they will not escape criminal liability. Now, as I was telling you, while discussing Article 283, which is the crime of live threats. Now, that live threats there, I told you, is one of the two provisions in the revised penal code, which is akin to blackmail or blackmailing. And blackmail or blackmailing, as defined, is the unlawful extortion of money and the threats of exposure or accusation, subject to the condition or demand for money. Now, the other article now falls under this crime against honor. That is Article 356, the crime of offering or threatening to publish a libel or offering to prevent the publication of libel in consideration of some money. That is what Article 358 says. The acts punishable there are threatening to publish a libel against another concerning the letter or his parents, his spouse, child, or other members of his family. Or number two, by offering to prevent the publication of such libel for compensation or money consideration. So in other words, in what felony is blackmail possible? Under high threats, Article 353, 283, and the crime of threatening to publish a libel or offering to publish a libel in consideration, of course, of money consideration. Now, to illustrate this theory, why is Article 283 akin to blackmailing? Well, of course, according to Article 283, the crime is committed by any person who shall threaten another with a wrong that does not constitute a crime, subject to a demand of money or subject to certain conditions. So, if a person says, ididemanda kita sa BIR dahil hindi ka nagbabayad ng tamang buwis para hindi mo ako binigyan ng kalahating milyong piso. Now, this is live threats because there is threat of accusation
of a crime. What is that accusation? For not paying the proper tax. But that threat will not constitute a crime because there is no law that punishes a person who shall report one who does not pay tax to the proper authority or proper agency of the government. However, what makes it criminally liable is when he demands consideration for preventing him from pursuing his threat to report him to the NBI, to the BIR. So that is blackmail and lawful extortion of money under threat of accusation. On the other hand, the provision of Article 350, threatening to publish a libel or offering to prevent the publication of libel for compensation or for money consideration. Example of this is, if for instance, a columnist or writer with a newspaper calls the victim, the offended party, and said, I will publish this libelous statement against you. It will affect your business. And I will even publish pictures of yourself in a very compromising situation with your business. If you will not give me 1 million pesos. Alright, there was threat. What is the threat? Threat of exposure. Threat of publication. That he will not publish that libelous statement if he will deliver 1 million pesos. So that is blackmail, plain and simple. Blackmail. It could not be considered as robbery, as what many law enforcement people would say and file the case of robbery extortion, like what happened in the case which I personally handled. I told you that already during the past lecture. A columnist who was charged with robbery extortion under Article 294 because he threatened the businessman that he will publish that libelous statement if he will not give him 500,000 pesos. The 500,000 pesos was given to him, but it was marked money. So the NBI immediately arrested the columnist and then filed the case, which is denominated robbery extortion. But when it reached my table and I reviewed the case, I said it was a wrong charge. It is squarely falls under the provision of Article 356 of the revised penal. So that is how it should be explained. Now, if we are in this gathering, over this microphone, I utter defamatory statements, let's say to some of you, or even against all of you. Shall I be liable for libel? The answer is no. Unless this microphone is in the radio station where I give those statements and broadcast over the radio. But if it's only here, what crime is committed? Merely oral defamation. Oral defamation. Now, what is oral defamation? It is also a malicious and public imputation of any crime, vice or defect, whether real or imaginary, or any condition, acts or commission or status or circumstance which cast discredit, contempt or embarrassment on the person, whether natural or artificial, or shall blacken the memory of death. But unlike in libel, this is committed orally, verbal. But the same elements, except that the mode of committing oral defamation is verbal compared to libel. There is a case of grave oral defamation which was filed by a complainant residing in Tondo against a neighbor who was really a very troublesome lady. So, it happened in Manila. The case was filed by the fiscal finding probable cause after preliminary investigation. The case now is assigned to a judge who hailed from a province far from Metro Manila and who disliked Tagalog. So he is not good in Tagalog. Those people from that province wanted their dialect to become the official language together with English, not Tagalog, not English. So during the trial, the first witness was presented by the prosecutor. And the first witness was the complainant herself. After having answered, state your name and other personal circumstances. Now came the question. What was the defamatory statements addressed to you by the complainant? And then the witness, by the accused, and the witness in Tagalog, of course. Ikaw na putang ina mo. Ang iyong pek-pek ay tulad ng isang tahong na bumubulak-bulak pa. Sabi ng judge, Mr. Interpreter, translate that in English. I could not understand it. And so the interpreter began to translate it into English. The complainant stated that this accused has stated the following defamatory utterances. You son of a bitch, putang ina mo. Your pek-pek, your vagina is like a pearly shell with tiny bubbles. Ang ganda ng translation. Perhaps it could not be oral defamation if it was stated in English. Pero sa Tagalog, pakinggan nila. Of course, oral defamation are of two kinds. If you will look at your Article 90, with respect to the prescription of crime, when it comes to oral defamation and slander by deed, it says the period of prescription is 6 months. But you should not follow that strictly, because as I told you, there are two classifications of oral defamation. Simple slander or simple oral defamation, which is only penalized with arresto minor, and grave oral defamation, which has the penalty of arresto mayor. That 6 months prescriptive period applies to grave oral defamation, because if it is a life felony, the prescriptive period is only 2 months. 2 months under the provision of Article 90. Now, when is it simple slander? And when is it grave oral defamation? It is grave slander when it is of a serious and insulting nature. Now, sometimes the defamatory statement, although insulting, was rendered only by the Supreme Court to be slight oral defamation, especially so if the statement was uttered in the state of drunkenness or in the heat of anger. Although the utterances may apparently very insulting, but under those situations, the utterance was said to be merely slight oral defamation. Now, in the case, this is a case that happened in Morong, Bataan. It was the lawyer, Attorney Benjamin Escolan, was the complainant. He was candidate for vice mayor of the place. You know, that man, I know that because during my infant years in the when I was still waiting for the result of the bar, I was handling a case of land involving about 4 hectares, owned by the brother of my classmate in the College of Law, who did not take the bar examination because he said, wala akong chance ang nakapasa. dahil matanda na raw siya. He was a veteran of the Second World War. According to him, during in 1945, he enlisted in Philippine Scout at the age of 17. He was wounded. So when he was discharged, he became a pensioner of the U.S. government. He was graduate of education, but then later on he decided to take up law, and that was the time when I met him, and we became friends. Because he had a great admiration, perhaps, even if I was not yet a member of the bar. I was the one whom he said, total, dito pala naman ito sa Bureau of Plans, hindi pa naman nag-require itong turing na abogado. Pwede ka na mag-handle. So I handle it. And of course, it became a little protracted. When the decision came, I was already a lawyer, but before the decision came that I became a lawyer, I continued handling the case. Fortunately, I won the case over my opponent, who was well-known lawyer there and was the vice governor of the province of Bataan. Pino Navarro was the name of the lawyer for the other party. You know, my attorney's fee should have been 1 hectare of that land. And don't you know that how much does it now command as a price? Ando doon na yun sa subit na in-improve nila. But because I was still a very young man and single, sabi ko, bigyan na lang niya sa iyong kapatid, anak niya, sabi ko nila. Tsaka nakita ko yung bundok pa, maraming MPA, sabi ko, hindi ko naman pupuntahan yan, hindi ko na kukunin yan. 1 hektarya na, sabi ngayon nung mga kakilala ko doon sa Moro, Atty, magkamali ka ng decision, bakit? 1 hektarya lang dito, mahigit ng 1 milyon na kalaban, dapat daw ka ng 1 milyon. Hindi pali na. Meron naman nakinabang yan, masama, walang nakinatak. Sabi ko, ang hirap ng pamilya nung aking pinagtanggol, kaya mo sa kanila, 4 ang anak. O, di naman na sila ngayon, kasi yan siguro marahit sila. Hindi nila makakalimutan ako. Doon ko nakilala yan si Atty. Benjamin Escolano. He was also a new lawyer, but still connected with the constabulary. There was a case of oral defamation only. But you know, no one of us could claim victory because ultimately the parties agreed to settle the differences. But what I observed on Atty. Escolano, he is always temperamental, and he has a very poor choice of word whenever he speaks, especially if he's at the height of his temper. His words were very acidic. It hurts other people's feelings. So we were not able to develop a close association with each other. Although we respect each other being members of the same profession. Now, coming to this case, his neighbor, well, there was a caucus of his leaders in the front of their house. This neighbor of his, the accused in this libel case, uttered expletive. He said, "Putang ina mong attorney ka," sabi niya, "napakatanga mo, napakawalang hiya mo." That was the appearances. So napahiya. He was embarrassed before his leader. But previous to that incident, the family of this offended party had been feuding with the Escolanos. So Escolano now filed a case of oral defamation, grave oral defamation. And he presented array of witnesses because there were several political leaders and followers of Escolano at that incident. So he won the case before the municipality. And then there was appeal. It was sustained. Then it reached the Supreme Court because the RTC modified the conviction. Instead of sustaining the conviction for grave oral defamation, The RTC said, while it is true that there was oral defamation, it is not fake. It is only simple slander because those statements, which are apparently insulting to a lawyer, were uttered under a state of drunkenness, and because of the previous incident that the families of both Escolango and the offender are feeling, it is by reason of anger, at the heat of anger, that these statements were uttered. Thus, the lower court said it is only slight oral defamation or simple slander. So Escolango is not happy with that. He went to the appeal. Consensual, questioning the lowering of that charge of grave oral defamation to the oral slander. But the Supreme Court ruled the RTC is correct. It could not be considered as grave oral defamation under those situations. So this is a lesson on how the alleged expletive or slanderous statement be taken. Is it grave oral defamation or slander? If there is no condition, like what happened in this case of Escolango, he's a lawyer, noted, very respected. If those statements are uttered, in no way could those statements be considered as merely simple slander. And perhaps because he is a politician, he had encounter with his political opponent, and perhaps the neighbor was not his political follower. And so Escolango was also very mad at the neighbor because he could not attract the support of his neighbor. Now the word putang ina mo had been ruled by the Supreme Court as early as during those days when you were still in Persia. It said it was not intended to hurt the feeling, but it is merely an expression of expletive. Expression of disgust. Kasi lahat naman tayo siguro nakapagsalita na rin ang putang na, pero wala naman tayong interest na talagang sabihin, kahiyain ng tao, kundi expression, kundi common expression naman yun, putang ina. But the question in this Escolango case, ay kung sinabi nilang naputang ina, baka nakalibre na siya eh. Eh sabihin ba naman, napakawalang hiya mong attorney? Ba masama na yan? You know, sometimes, meron mga gamit ng Tagalog na hindi naman mga tunay na Tagalog na pwedeng ma-misinterpret at maging oral defamation. Like for instance, in the gathering, hindi naman Tagalog ito. Pero katapos ang salita niya ganyan, oh, sige na, nabisita ko, lumamon na kayo na lumamon, wala kayong kahiya-hiya. Pero actually, wala naman gustong sabihin masama yan, normally lang yung choice of Tagalog ka. Ibig lang sabihin, sige mga bisita ko, kumain lang kayo ng handa natin at huwag na kayong mahiya. Eh, ganun ang ibig sabihin. Eh, pero sabihin mo, lumamon na kayo ng lumamon, wala kayong kahiya-hiya. Eh, siyempre, kung kayo nandoon at kayo Tagalog, pasak na ng loob din mo. Ano ba naman ito? Nagpapakain niya, pero minumura naman tayo. Alright, let's go to proof of truth. Can evidence of truth of a defamatory statement be presented in evidence? As a rule, the proof of truth is not admissible, but there are only two exceptions provided under Article 361. And what are these two instances where proof of truth is admissible in evidence? If the imputation is proven true, then the accused is entitled to acquittal. Number one is when the act for omission constitutes a crime, regardless of whether the offended party is a private individual or a public officer. So take note, if the imputation is a crime against the offended party, whether he be a public officer or a private individual, proof of truth may be offered in evidence. And if that crime which is imputed against the offended party is proven true, then he deserves an acquittal. The second is, when the offended party is a government employee and the imputation is not a crime. If it is not a crime, it will not constitute a crime of libel. But such proof pertains to imputation that does not constitute a crime. Like for instance, if during the time of manager Winston Garcia of the GSIS, naku, napakaraming tao ron na nagbubura kay Mr. Winston Garcia, especially those old pensioners. Dahil nawawala ang mga check, hindi natatanggap ang kanilang mga pension. And so every time that these people complain to Garcia, Mr. Garcia will sometimes would not face those complainants who wanted to launch and express their disgust on how these people in the GSIS entertain their problems. And one time, assuming that one time, Mr. Garcia really is already fed up on this complaint. So when an old man went to his office to complain about the failure to receive his pension for several months already, Mr. Garcia was seen and heard uttering expletives but not addressed to any person. Putang inang mga yan, kung sino yan, walang mga puso, pero malakas ang boses. Nadidinig ko magko-complain sana. Sabi niya, at lasing, sabi, namumula ang mukha. So dalawang beses nagpunta itong mama na ito na makagana. Ngayon, naka-interview siya. Napublish yung kanyang statement. Yang si Winston Garcia niya, General Manager ng GSIS. Wala nang ginawa kung hindi bagbura doon sa loob ng kanyang opisina at laging lasing. So hindi naman crime ang sinasabi yan. Nagmumura lang, wala naman sinasabi kung sinong minumura. So si Mr. Garcia na yun, nag-file ng complaint or libel against this old man. It was an imputation, but it does not constitute a crime. But it pertains to the official conduct of Winston Garcia as General Manager. Now, applying this proof of tort provision in Article 261, the second, if that old man is able to present evidence that he is really oftentimes bullying up people and always coming to office drunk or intoxicated, then if proven true, that old man will be acquitted of the charge of libel. That is the meaning of the second instance. If the imputation against a public officer does not constitute of a crime, proof of truth may be offered in evidence. And if such imputation that does not constitute a crime is proven to be true, then the accused deserves to be acquitted. Now, in the first, in order that proof of truth may become admissible, the imputation must always be the commission of a crime, not any other kind of imputation. And such imputation of a crime is made against a person, whether a public officer or a private individual. Proof of truth is admissible in order to gain his acquittal. That is the provision of Article 361. Now, with respect to the crime of slander by the third form of defamation. Now, this is different from the first two because in the first one, libel it is in writing or by way of publication. Slander is by means of orally uttered defamatory or slanderous statement. But here, it is performance of an act which will cast dishonor or contempt or insult upon another person. So our normal and vocal example is when a person slaps the face of another in the presence of so many. But there must be a purpose for that slapping. The law says it must cast dishonor or contempt. If there is no such purpose, that would not be slander by deed. There are two kinds of the slander by deed. One is serious, which is punishable by arresto mayor, and the other one is light or simple slander by deed. This is only punishable by arresto minor. So, the one that is mentioned, slander by deed, in Article 90 on prescription of crime, says oral defamation and slander by deed shall prescribe in 6 months. Those two pertains only to grave oral defamation, and the other one, serious slander by deed. Because if they are both light oral defamation and light slander by deed, which is punishable only by arresto minor, then the prescriptive period is 2 months and not 6 years. And not 6 months, not 6 years. Only it's only six months, not 6 years, I think. 6 months if it is grave oral defamation or serious slander by deed. So if there is no purpose of embarrassing or insulting the person by his act of slapping the face, then it will only constitute the crime of under the provision of Article 266, which is slight physical injuries. It will only constitute maltreatment. In other words, this kind of slight physical injury. But if the injury, by reason of the slapping on the face of a person, constitute less serious physical injury, the purpose of exposing the person, the victim, or the offended party to embarrassment, or when the purpose is to cast insult or contempt upon that person, it will only become qualified less serious physical injuries. That act of insulting is a crime of less serious physical injury according to Article 265 will only be considered as a qualifying circumstance. But if it is only slight physical injury, then it is slander by deed, either serious or slight slander by deed. Perhaps we will not forget that anymore. Now, this crime of incriminating innocent person, and be sure to distinguish it from perjury. Both incriminating innocent person and forgery for the purpose of falsely prosecuting a person has the same purpose. This incriminating an innocent person under Article 360 is commonly known to us as planting of evidence. That act of causing a person to be implicated to a commission of crime which is not existing, that is the crime of incriminating an innocent person. The police officer could not arrest a person. He wanted him arrested and make it appear that it was a lawful arrest. So, he accosted a person and then began frisking. And when he opened his hand, there was already, let's say, 1 sachet of shabu or marijuana as the case may be. But actually, it was already on the hands of the policeman when he dipped his hand inside the pocket of the poor victim. Now, that is planting of evidence. But remember, previous to the effectivity of Republic Act 9165, the planting of any drugs, whether marijuana or shabu, will only fall under this provision. But since we have now a special law, especially Section 29 of Republic Act 9165, it becomes now a specific crime of planting of evidence. And once convicted, the law says the penalty is death. It will not fall under this crime of incriminating an innocent person. How is the planting of evidence of any dangerous drugs committed? It is committed by any person, not necessarily a police officer. The law is very clear. Any person who shall maliciously, surreptitiously insert into the possession of a person or within his immediate vicinity or within his residence or any dangerous drugs for the purpose of implicating him or any violation of the Dangerous Drugs Act, it shall constitute violation of Section 29, otherwise known as planting of evidence. And once convicted, the penalty is death. However, if what is planted are paraphernalia, like the rolling papers used, or rolling marijuana leaves, or any water used for inhaling the smoke, or the smoke being emitted by a heated up shabu or cocaine, as the case may be, that will be a crime of illegal possession of drugs paraphernalia. Since if that is being planted on the victim, it will not constitute planting of evidence under Section 29, because under Section 29 of Republic Act 9165, what must be planted or surreptitiously inserted upon the innocent victim must be drugs themselves. If it is paraphernalia, it is not drug. The penalty of for mere possession of paraphernalia is a maximum penalty of 4 years, unlike in planting of evidence, which is penalized by death penalty. So what will be the crime to be charged against the offender, whether police officer or not? But who plants drugs paraphernalia? The crime is violation of Article 363. It is incriminating an innocent person. When a person was also arrested, but there was a planted unlicensed firearm. You know, policemen always carry 2 firearms, especially if they are on operation. One, the license for the official service pistol or firearm, as the case may be, and one which is unlicensed. In case of emergency, if there is risk that they may be open for prosecution for what they have done on the victim, they will agree already draw this unlicensed firearm. Like for instance, in one confrontation, the policeman, because he did not like the manner that person whom he had confronted, he is arrogant, and he happened to fire at him fatally, so he fell and died before anyone could, any law enforcement agents could come. He was passed on TV. He put that unlicensed firearm on the palm or on the hand of the victim. What is the purpose? To make it appear that the man whom he had shot at was the first one who tried to kill him. So it was self-defense in order to cover up that crime. That was how he did. Now, you know, if that is what happened, what are the crimes committed by the police officer? If that act of his was not prudent, meaning as self-defense, what will be the crime committed? Well, firstly, they shall be guilty of homicide. What is the other charge that could be filed? It could be a crime of obstruction of justice. Why obstruction of justice?
because he plans that evidence. The purpose by concealing the body of the crime. What is the body of the crime? Homicide. By making it appear that he was the one who attempted against his life, prompting him to defend himself. But it was not proven during the trial. Then he shall be held liable for 2 offenses, assuming that 2 charges were filed against the offending police officer for homicide, and the other one is for obstruction of justice, for concealing the body of the crime in order to avoid the discovery thereof. What is the body of the crime? It is corpus delicti. And the cadaver of any victim is not corpus delicti alone. It's not per se the corpus delicti of the crime of murder or homicide. Take note of that. It is not. The cadaver is only part of corpus delicti. What is corpus delicti there? And what are the 2 parts of corpus delicti? Corpus delicti is the fact of the commission of the crime itself. So, with that definition, even without the recovery of the victim's body, an accused could be convicted of either homicide or murder as the case may be. Now, I forgot to touch this in my lecture about kidnapping with murder or homicide as the case may be. I could have posed the question or the query to you, may a person be convicted of kidnapping with homicide or murder, or plain homicide or murder, if the victim of the victim's body, who is claimed to have been killed by the victim, by the offender, could not be recovered anymore. Now, have you come across cases like that? You know, I was lecturing on this several times. I wonder why I forgot to tell it to you during the pertinent discussion on homicide, murder, and in the crime of kidnapping with homicide or with murder. You know, it was the case of People versus Sostosa, and the other one is People versus Prolonda. In the case of Prolonda, the facts of the case that the accused were seen with the victim. His hands were tied with a rope. They were pulling him towards the forested area. That was the last time the victim was seen alive. So, because there was witness who had seen this event, the family of the victim, who could not be found anymore, were charged of kidnapping and with murder. Because they said they were the only ones who was with the victim, and therefore they are also the author of the killing. Alright? They were charged before the RPC, there being probable cause. They were convicted by the lower court. But on appeal, before the Supreme Court, because they were convicted of kidnapping with murder, the penalty is death. So it went on appeal. The Supreme Court said, after reviewing the evidence, the crime for which the accused could be convicted is only kidnapping or a serious illegal detention. It could not be a special complex crime of kidnapping with murder because there is no corpus delicti that was proven as to the death of the victim, said the Supreme Court. Now, it is unlike the case of People versus Sostosa. The Sostosa case also kidnapping for murder. The victim's body was not recovered, but the Supreme Court said the conviction by the lower court for kidnapping for murder is correct. Now, how is that case of Sostosa? What is this case of Sostosa? Which was not the same as in Rolonda, where the charge is also kidnapping with murder, but because of the failure to retrieve and recover the body of the victim, the Supreme Court said it was clearly kidnapping. Now, the facts in the Sostosa case, it was like this. The victim was pulled out of his house by about 3 accused. When they were already pulling down, they start beating
the man with piece of wood. Some were armed with bladed weapons. He was pulled towards the shore of the sea nearby, and while the offender was continuously beating him. He was already too weak, but then he was made to ride the boat, and so the culprit and the body already there sailed out toward the middle of the sea, and they were seen even still hitting the person. Nobody could testify whether he died already by reason of that act of violence. But that was the last time the victim was seen alive. So after several months that the body could not be found, the relatives now filed the case of kidnapping with murder. And the lower court convicted them. But the Supreme Court, the accused, testified, argued in their appeal. How could they be convicted of kidnapping with murder? The victim's body was not recovered anymore. Then there was discussion. The body of the crime has been clearly established. What is the body of the crime? The part of the commission of killing. But the body was not retrieved. But the body of the victim is only part of corpus delicti. Sensible. What are the parts of corpus delicti? And that was asked in the bar 2 times already before. There must be a crime that was committed, and that the identity of the victim was established. These are the 2 parts of corpus delicti. So, when they say the crime was committed, the accused were identified, and the acts were shown to be illegally employed, resulting to the killing. How could that be established when the victim's body is no longer recovered? Said the Supreme Court in the Prolonga case. In the Sustosa case, there was act of violence. The victim was already weakened by that act of violence, and when they were made to board the banca, he was already very weak, and that was the last time when the victim was seen. So there is evidence to show, and could be basis of conclusion that it was the act of violence of those accused that caused the death of the victim. The body could have been thrown out of the sea. That's why it could not be recovered anymore. Perhaps they were already eaten by big pieces or by sharks, said the Supreme Court of this decision. So that was a case of kidnapping with murder that was sustained by the Supreme Court, notwithstanding the non-recovery of the victim's body. But the corpus delicti, according to the Supreme Court, was established sufficiently. Unlike in the Rolanda case, there was no act of violence. The testimony of the witnesses merely says that the victim had his hand tied. No act of violence was ever proven to have been inflicted. So at most, what was proven by the evidence according to the Supreme Court is only kidnapping, but not the crime of murder. Hence, simple kidnapping, not the special complex crime of kidnapping of murder, was committed by those accused in the Rolanda case. Now, going back to the incriminating innocent person, in one bar examination, there was a question asked. The problem was, while playing mahjong in one house, the victim's coat was hung in one of the chairs. Now, another person who entertains ill will against the person who owned the coat, he picked the wallet of one of the players and placed it on the pocket of the coat of that person. Of course, it was discovered later on that the wallet of that victim was in the hand. But since he is an honorable man, sabi nung may-ari ng wallet, siguro merong bumiro sa iyo partner. It's good that there was somebody who happened to see that person who picked the pocket of that other person and then place it on the coat. Now, what is the crime committed by that person? There was no appearances. There was no affidavit. But there was performance of an act. The purpose of which is to cause the implication of that innocent person, the owner of that coat, for a false prosecution for the crime of theft. So that is the crime, incriminating an innocent person. And incriminating an innocent person. In the case of intriguing against honor, what is the crime of intriguing against honor? Ito sa Tagalog, chismis. A person, by means of escape, spread some nasty rumor against somebody. But the author of the same could not be established. This person who is spreading the rumor make some exchange in order not to trace the source of it. Sabi lang niya, naku, dito sa ating kapitbahayan nito, meron palang magnanakaw, nagtatago rito. Sino may sabi niya? Naririnig ko yan usak-usapan sa kanto. Pati ko na siya ilabas di parang sa inyo. Now, nagalit ngayon itong tao na ito, nutukod niya. Dinimanda siya. Ano ang crime na nakabit niya? Is it oral defamation or is it intriguing against honor? It is intriguing against honor. It could only become oral defamation if the source could be traced and established. And that person who is spreading the rumor must be utilized as a witness. The crime committed should be oral defamation. But if he could not establish who the author was, then the one who is spreading the unsavory rumor against that person, which constitute oral defamation, the crime committed would only be intriguing against honor, not oral defamation. Alright, this crime of quasi-offenses. Alam mo, meron dito ang conflicting opinion ng mga authorities. Is negligence or imprudence a crime in itself? Now, if you will read the book of prayers, you will read there that this negligence or imprudence is not a crime in itself. It becomes punishable only when such negligence or imprudence results to a crime. Well, in some books, like for instance, the book of Professor Guado, he made a distinction between that negligence or imprudence in Article 3, which is the so-called culpable felonies. There are, Article 3 is one of the three provisions of the revised penal code that give us the classification of felonies. In your syllabus for 2011 bar exam, there is a topic there. What are the classifications of felonies? Now, there are only three provisions of the revised penal code, book 1, where you could get this classification of felonies. As to the mode of commission, there are two classifications. They are felonies by dolo, which is intentional felonies, or felonies by culpa, which are the culpable felonies. That is the first kind. Now, according to Professor Guado, the negligence there in Article 3, the negligence there, is only a modality in the commission of the crime. But this negligence or imprudence that is treated in Article 385 of the revised penal code is a crime in itself. I could not reconcile this statement of Professor Guado because have you seen any information
charging a person of mere reckless imprudence without any damage, without any person injured? There is none. That's why if we charge a person who has committed reckless imprudence, it's alright. If it is a person who died, reckless imprudence resulting to homicide. If only damage to property, it is reckless imprudence resulting in damage to property. Now, there is no crime of reckless imprudence. There is no crime of reckless negligence. There is not. It is only punishable when there is a resulting crime coming out from that negligence or imprudence. Of course, in Article 3, we learn there that crimes committed by culpa are culpable felonies. So it's correct to classify felonies according to modes of execution. That it is by dolo, that is intentional felony. If it is by culpa, then culpable felonies. What is the second article that provides for the classification of felonies? It is Article 6. Classification of felonies according to stages of execution. Consummated, prostrated, and attempted felony. And the last one is found in Article 9. Classification of felonies according to their gravity. Then we have grave felonies, less grave felonies, and light felonies. You know, I want you to remember those three articles because that is a particular topic treated in the 2011 syllabus for the 2011 bar examination. Classification of felonies. And perhaps that is what Justice Abad wanted you to answer just in case. Or remember, in case a question is asked on classification of felonies. You don't classify mala ense and mala prohibita as felonies. No. They are classification of crimes according to wrongfulness. It is mala ense and mala prohibita. But they are not classification of felonies. To clarify that point. And one of the best point or topic that is mentioned in the syllabus concerning Book 1 is the distinction between mala ense and mala prohibita. Always a favorite topic in all bar examination. Lagi na lang nandiyan yung mala. Ngayon, may multiple choice question na. Nandiyan pa rin yung mala ense and mala prohibita. So, tagtag na ang utak nyo dyan sa dalawa na yan, hindi nyo na makakalimutan yan. Alright, I will finish the lecture for the day. I cannot meet you this afternoon because I have agreed with my position.
Kayong maging abogado, ano? I hope my lecture on book in the special panels could add to what you have already in your house of knowledge in order to ensure your passing the bar. You know, your reviewer this morning, and until we finish the entire book is Professor Salva, Nelson A. Salva. I am the head of the Criminal Law Department in the School of Law of Arellano University and professor in several law schools in Metro Manila and paper reviewer in many review centers all over the country. I just got from Davao where I lectured also on Book 1. But the next weekend I will also lecture on what I'm going to lecture through this schedule. So, in a way, this is only a rehearsal for my succeeding lectures in the other review centers. All right, you know, all your efforts during this review is in order to eliminate your ignorance of the law, especially those that are covered in the 2011 bar examination syllabus. You know, Justice Abad, who happens to be my classmate in Penn during AB days, had told us, unlike in the previous bar, there is no specification on what to read And this time, he wanted it to be a little more specific. That's why he came out with this 2011 bar examination syllabus. I say to eliminate ignorance of the law. Ignorance of the law excuses no one from compliance therewith. But your ignorance of the law will not excuse you from passing the bar. Take note of that. And all the laws which you learn and discover in your adolescent years in the law school will have to be revived from your memory. You know, the adolescence age of all of us in the law school is from first year. But actually, in our actual life, the most wonderful age is adolescence. The age of adolescence, because that is the time when men meet girls. And on the other hand, girls become happy because they discovered that they are discovered. That is age of adolescence. Now, book 2 is divided into 14 titles. But the review here is more lengthy because of the additional special panels. We shall begin with title 1. This title was first read by you in book 1 because it is included in the 5 exceptions to the rule of territoriality of our criminal law under Article 2, the last of the 5 exceptions. Crimes against the national security and the laws of nation as they are defined in Title 1 of Book 2 of the Revised Penal Code. So it covers Article 114 up to Article 123. Now, first, treason. What is treason? Treason is a breach of allegiance of any national or citizen to his sovereignty. Allegiance is the obligation of obedience and fidelity to his country or state in return to the protection that that national or citizen received from it. There are 2 ways of committing treason in Article 114. They are, number 1, levying war against the government, and number 2, adherence to the enemy, leaving them aid in comfort. But remember, treason could only be committed in times of war. There is no traitor to his country unless the country is at war with the foreign power. And the offender, previously, in the crime of treason under our code, are only citizens of the Philippines. But before the outbreak of the Second World War, that provision of Article 114 underwent amendment through an executive order, making aliens residing in the Philippines also liable for the crime of treason. So both Filipino citizens and resident aliens are the ones liable. If aliens are not resident of the Philippines, then they are excluded. The citizens of the Philippines, wherever they may be, once they commit any act of treason, they shall be held liable and be held before our Philippine court. But with respect to resident aliens, they should be committing those acts only when they are in the Philippines, not outside of the Philippines. So the elements of treason act that must first be, number 1, the offender is a citizen of the Philippines or a resident alien. Number 2, that the Philippines is involved in a war with a foreign enemy country. Number 3, that this offender either levy war against the government or that they adhere to the enemy, giving them aid in comfort. Now, what is the meaning of levying war against the government? It means that the offenders shall assemble themselves. There must be actual assemblage of men
for the purpose of carrying out treasonous design against the government by means of force. So, mere inducement to fight the government is not enough to make one liable for treason. It requires actual assemblage of men in order to carry out the treasonous design against the government by means of force. And then we have the second mode of committing treason, that is adhering to the enemy and giving them aid in comfort. So mere adherence to the enemy without giving aid in comfort does not make the offender guilty of treason. What is the meaning of adherence? Meaning, intent to betray. The offender is entertaining intellectual and emotional sympathy to the enemy and an adverse sympathy against his home country. But that alone will not make him liable unless it is coupled by that second element, giving aid in comfort. And what does aid in comfort means? That aid must have the effect of strengthening the effort of the enemy in fighting our government. Mere giving women to enemy soldiers or army, commanding all women in order to give them entertainment. The Supreme Court said that is not the concept of giving aid in comfort, although giving them women entertainment will boost their morale. It does not fall under that concept of strengthening the effort of the enemies against our government, said the Supreme Court. So kahit na ibigay ng traitor yung lahat ng mga prostitute sa ating bayan sa Pilipinas para sila ay aliwin, hindi raw yung crime ng overt act of treason. Bakit kamo? Eh kasi common sense, lalo lang silang manghihina kapag kalo lang ginawa nila. Lalo lang silang manghihina. It weakened them. Then, so giving foodstuffs, supply of foods, giving armaments will constitute overt act of treason. There are two ways of proving treason. Or the question would be, what is the quantum of evidence required to prove treason? Now, under the second paragraph of Article 114, it says, no person shall be convicted of treason unless upon the testimony of two witnesses at least to the same overt act or confession in open court. So those are the two modes of proving the crime of treason. Either that two witnesses are presented testifying to the same overt act. That is the so-called the two witness rule. And the other one is when during arraignment in open court. And that court must be a court of competent jurisdiction which could render judgment of acquittal or conviction as the case may be. And the accused in that open court makes an admission of his guilt, confession of guilt in open court. Meaning to say, he confesses that he had committed the act of treason, either by levying war or adhering to the enemy, giving them aid in comfort. And how will you apply this to witness rule? When shall it be considered to have been complied with, so that it will result in the conviction of the accused? Well, these two witnesses must testify to the same overt act. Meaning to say, if for instance there are two overt acts committed by the offender, a Filipino citizen. The first is delivery of truckload of rice to the enemy garrison. The second, delivery of 100 pieces of automatic rifles to the enemy. There were two witnesses presented by the prosecution. Witness A testifies to that overt act of delivery of rice to the enemy garrison. Then, witness B was presented, and this witness B testified he saw the same offender deliver these 100 pieces of automatic rifles to the enemy. Those are the only evidence presented by the prosecution. Can that result to the conviction? There are 2 witnesses testifying to overtime. The answer, no, it will result to the acquittal. Because while there are 2 witnesses, each one testified to an overtime different from the other. When you speak of testifying to the same overtime, if there is an overtime of delivery of 100 pieces of armalite rifle, those 2 witnesses must testify to the overtime. And also, the 2 witnesses shall testify to the fact of the delivery of the truckload of price to the enemy. That is how these 2 witness rules should be applied. And remember, even if there are 2 witnesses who will testify to the same overtime, it requires that both must be credible per the assessment of the court. Because if only one of them is found to be credible, then the 2 witness rule is not complied with. It will result likewise to the acquittal of the accused. Remember that treason is the only felony under the revised penal code requiring these 2 witnesses to testify on the same overtime. No other felony. Why is it so? Because the crime of treason, which has a very severe penalty, is committed during abnormal times. And during abnormal times, like war, people may, in a small squabble, may forget their scruples and may sacrifice thoughtfulness. Thus, if there is no 2 witness rule, one who is entertaining some peeling of pretense against a Filipino during wartime, in order to get even with him, that sole witness may be tempted to file a complaint for treason against that man and testify against him. Because he has given the enemy aid and comfort. He adheres to the enemy. If he is a good false witness, there is probability that the court may be persuaded to believe his testimony, and that will result to the conviction of the accused. That will be a grave miscarriage of justice. To avoid that situation, the law requires this 2 witness rule to apply strictly in cases of the crime of treason. That is the reason for this 2 witness rule. Now, of course, in proving treason,